The Royal Commission is now in session. Please be seated.
Just a couple of things before we get started. As will be evident, we're still having sound problems. I'm told that there's some replacement equipment coming at lunchtime. But if the sound should drop out, what we must all do is just sit silently until it comes back on, which apparently will not be long. So we won't be adjourning if there's a sound drop out. We'll just sit and wait. You can sing if you like, Mr. Scott. That couldn't do any harm. But nothing will be recorded, so we've got to bear that in mind. Number two, what I propose to do for the rest of this hearing block at any rate is to endeavour to extend the sitting hours by taking an hour for lunch and sitting till 5 o'clock as a general rule, which I appreciate will put an enormous burden on people because the time out of the hearing is usually spent in preparation, the need for which is extensive. But in order to get through the witness list, I think we're just going to have to manage it. So that's the plan, Ms Hogan-Doran. I think you've been warned.
Thank you, Commissioner. I'll be here.
Good, thank you. All right, now you're appearing.
I am,
Mr.
Commissioner.
Scott.
If it pleases, I appear with Ms Marsh for the first two witnesses today, Ms Bundy and Mr Brazel.
And the appearance for the Commonwealth is the same or not?
No, Commissioner, I appear today with my learned friend Mr Vial.
Mr Vial, thank you. All right. Yes, and Ms Bundy, we've got you back. Thank you.
Commissioner. Ms Bundy, you'll recall yesterday in our discussion, you conveyed your understanding of the legal position in 2017 when you were head of the appeals branch as being that it was permissible for decision makers under the Robodebt scheme to rely on the best information they had available to them, that is, the information in effect in the possession of the department without making any further inquiries.
Yes, unless that was displaced by other information.
Sure, but in circumstances where, to take the EIC and QP schemes as examples, two genuine attempts had been made to contact the recipient and those attempts had failed, your understanding was that it was perfectly lawful for the compliance officer to rely on the information which they had available to them without making inquiries with employers.
Yes, and that was based on the legal advice.
Yes, and that's what I wanted to confirm.
Yes, that was the position that I understood, absolutely.
And you understood that because you'd been advised by lawyers to that effect?
I'm just trying to remember the sequence of my understanding. When I first started, I think I made inquiries with Mark Withnell, who advised this is a long-standing practice of the agency. I said, and I don't know who to. I had it. Well, somehow I had an understanding that DSS had.
Can I briefly interrupt you, Ms. Bundy? I don't want to cut you off, but you said you were advised by Mark Withnell that this was a long-standing practice of the agency.
Yes.
Does that include does that refer to a statement that it was a long-standing practice of the agency to rely on averaging without making any inquiries of employers?
No, it was that in the past, the process was that to inquire with employers, and sometimes they couldn't be found, and sometimes they didn't respond to information, and it was in those circumstances where the ATO information would be used.
Okay. All right, so I interrupted you, Ms. Bundy, so I think you're purporting.
Yeah, and the change in my mind was that we weren't going to employers anymore. And I don't know who I spoke to, but somehow I got a view, an understanding that DSS had said from the policy agency perspective, yes, and then I was fairly comfortable that that was okay.
So you haven't mentioned any lawyers in that sequence. I just want to clarify, did you get legal advice, or were you informed of legal advice by a lawyer that it was okay?
I'm just trying to recall. I had I know from looking at my records that Maris sent me some advice on the 2nd of March 2017, and I think that was the DSS advice. And I also had a view for some time, I'm not sure informed by what, that there had been external legal advice from DSS, and I can't find a record of receiving internal legal advice, like written advice, but I did have a conversation in the context of appeals about, does this mean that we now need to get pay slips?
By Maris, are you referring to Maris Steepniks?
Yes.
He provided you, forwarded something to you on the 2nd of March 2017?
He copied me into something, yes.
Okay. Have you produced or caused that document to be produced to the Commission?
I refer to it in my statement.
Whereabouts?
Paragraph 146.
Paragraph 146, is that right?
Yes.
All right. And that has a footnote 122, and that footnote refers to 4 documents, is that right?
Yes.
And is that a document which contains, is one of those documents the email from Mr. Steepniks on the 2nd of March 2017?
Yes, that would be correct. So I think what had happened, Maris had sent me into the email to someone else. At that point in time, I must have recalled receiving something from Maris, and my officers found that. And at that time, given Professor Carney's article, I think there was a request from Jason McNamara, or the Deputy Secretary, to forward that on to them.
Sorry, Professor Carney's article?
Yes.
What Professor Carney article are you referring to?
The one from April 2018.
Right, but that's obviously after the 2nd of March 2017.
Yes.
Okay, so I'm just focusing at the moment on the 2nd of March 2017 and what you're forwarded from Mr. Steepniks.
I don't recall now receiving it, and I looked at the email. I asked my office to print it.
So when did you ask your office to print it?
I think I don't know what day it was. I can check, but the email trail, I've said please print.
So this is in 2018 after coming...
2017.
Oh, okay, I see. Right. And is your recollection that... We're just trying to bring it up, Ms Bundy, we don't have it to hand. Is your recollection that that contained advice regarding the issue of averaging?
My recollection is that it contains the email that DSS sent to the Ombudsman's office with some attached advices.
I see. Right. Okay. Can we please have brought up on the screen Exhibit 2, DSS.5006.0003.1833? Is Can we have brought up on the screen Exhibit 3? Actually, instead, can we bring up on the screen doc ID CTH.2000.0007.5664? Do you recognise that document, Ms Bundy?
I don't.
Is that not the document that you're referring to as having been forwarded to you by Mr Steepnicks?
It well could be the document, but I have to say I haven't. There's been so many sort of bits and pieces going on. I'd have to actually just go and check that that was actually the document attached to the document. But
Well-
yes, from memory there was advice from 2014 and 2017, and there's a covering email from DSS to the Ombudsman.
Okay, can I just get you to look at paragraph 146 of your statement, which you should have in front of you?
Yes.
And you recall footnote 122, which is at the end of that paragraph?
Yes.
Which refers to the contact from Mr Steepnicks on the 2nd of March.
Yes.
And if you look at that footnote, have a look at the doc ID for the last document footnoted in footnote 122.
Yes.
Yes, satisfied that that's what we're talking about?
Yes.
Okay, thank you. All right. Commissioner, this document hasn't been tendered yet. Perhaps it could be tendered.
So what are we going to... I haven't got an exhibit list in front of me, I'm afraid.
I'm just getting in a number for you, Commissioner. Could it be numbered 3588A?
Right, it'll be 3588A.
Thank you, Commissioner. Can we just call out the section under the heading 2017 advice? Thank you. And Ms Bundy, can you read that section to yourself, and then I'll ask you some questions about it.
Yes.
You read that? Mm-hmm. Do you understand that to be advice provided by DSS in 2017?
Yes.
Do you understand that to say in the first sentence in that section, that is to identify the question for which advice was being provided, being about whether using income averaging as a last resort to determine a social security debt was lawful in circumstances where no other information about the person's circumstances are available? See that?
Yes.
See the words last resort?
Yes.
And I think your evidence is that is not how Robodebt operated, is it? That is, it was not using averaging as a last resort.
No, it was not.
So the question that is being answered in this advice is irrelevant to the lawfulness of the Robodebt scheme, isn't it?
No.
Why is that?
Because while the question is talking about a last resort, I think people's understanding of what last resort can differ, and I think from the agency's perspective that this was similar to language used previously where averaging was done on a last resort basis where we went to get employer information, whereas the advice, and I'm just reading down there, that which effectively was read and taken to be, and I'm saying this in hindsight because I'm not sure I actually read this advice in 2017 because it was copied to me and it was a very busy time, and I think I read the first email that was attached as opposed to really digging into the advice. But I read this and it talks about as long as the person has been given the opportunity to provide the information, then that information can be used.
As a last resort.
As long as they were given, that's right, as long as they were given the opportunity to provide further information, that information can then be used.
And in circumstances where there had been 2 failed attempts to contact the Social Security recipient, under QP and ERC, averaging was applied, correct?
Yes, on the basis that that was the best available information to the decision maker, and there was no duty to inquire under administrative law to obtain further information.
And there was no attempts whatsoever made to seek information from other sources, even if those other sources might provide readily available information.
Yeah, if the person had not engaged, that's correct.
It's plainly not using averaging as a last resort, is it, Ms Bundy?
I would say that's correct in those circumstances, yes. That is not. I also probably wouldn't say what we were doing previously as being a last resort activity either.
Can we bring it up? Not just yet. Can we just bring that section that's highlighted there down?
What do you mean by that?
Oh, sorry, I just didn't want that section highlighted so I
right.
can take...
Mm-hmm. Did you look at that advice in any detail?
In 2017, I don't think I did. I think what I did was read the overarching email that was sent to the Ombudsman that said this is consistent with legislation.
Can we just...
Because if you look at it now, you can see that there's no reference to any case law and no reference to any section which authorises, any legislative provision which authorises averaging. And it doesn't seem much more than I think it'd be a fair thing, really.
It was supplemented, and I don't think I've got a copy of it. I couldn't find a copy of it, as I understood, by other internal DHS advice. And for some reason, I had a view that there'd been external advice at the time of the NPP, but I'm not sure how I had that view.
Can we just go to the next page of the document, please? No, the previous page, I beg your pardon. Were you aware that in 2014 the Department of Social Services had given earlier advice about the use of averaging?
My recollection is I read that in the covering email that had been sent to the Ombudsman by DSS.
Right, and you're aware that that advice said that averaging is unlawful?
Yes, my view for a very long time was that DSS had provided advice in 2014 that was on the basis that we would just be getting the information and averaging and not asking people to, affording them procedural fairness, and that once DSS understood that that wasn't the process, then that was okay. There was as I understood it, that there was a change in the proposal at that point in time, and perhaps that's why I thought there had been external advice. I'm not sure.
Now, just get you to have a look at what's on the screen there. Doc ID CTH.2000.000.566. Do you see the heading 2014 advice?
Yes.
Do you see what it says there? You have asked whether a debt amount derived from annual smoothing or smoothing over a defined period of time is legally defensible.
Yes.
And the answer is, in our view, a debt amount derived from annual smoothing or smoothing over a defined period of time may not be derived consistently with the legislative framework.
Yes.
That's clear advice, isn't it, that smoothing, which is another way of referring to averaging, is unlawful.
Yes, that it wasn't consistent with the legislative framework. Yes.
Right. And so, and you read this advice as well as the 2017 advice, which we've just...
I don't think I did read the advices. I think I read the covering email.
I see. But the earlier advice, the 2017 advice that refers to last resort, you caused to be printed out on or about the 2nd of March 2017.
Yes, I had asked my office to just print documents, put them in the pile of things to get to.
And didn't read it?
My recollection is that I read the covering email that had been provided to the Ombudsman's office.
Wasn't the lawfulness of the use of averaging as it applied in the Robodebt scheme of central importance to your role insofar as you were the manager of the branch that had the AROs within it making decisions under the Robodebt scheme?
I think the lawfulness of the scheme was central to all decision makers.
So wasn't it central and important to your role to actually read the legal advices on the question of averaging?
Yes, I think people probably should read all legal advices.
Why didn't you?
I was extremely busy time. I had come into the role on the 10th of February. There'd been a lot of work already done. I had perhaps made the assumption that these things had effectively been resolved. I'd read the email that went to the Ombudsman that said DSS had said this was consistent with the legislation, and that's all I can provide.
Excuse me. Can we get... Oh, okay. This is what she's referring to. What about the one that I'm going to take? Ah, here we go. Commissioner, I need to take the witness to a document which is referred to in the witness's statement, but hasn't been. It's an email that hasn't got redactions on it. It might be necessary for it to be shown in hard copy to the witness so that
Okay, have you got a copy for me?
I've only got one copy.
Okay.
Okay, if we can bring it up on the screen and not put it on the live stream, we could do that.
Mm-hmm.
The document is cth.2000.0007.5662. Do you see that, Miss Bundy? And just for your reference, if you go to your paragraph 146, footnote 22, you can see that it's got the document ID for the second last document referred to in that footnote.
Yep.
And would you agree with me that is the covering email that would have been that earlier document I showed you would have had attached to it?
Yes.
Okay. And is this what you understood to be the advice provided to the Ombudsman?
Yes.
Aren't you calling Mr. de Burgh today?
Yes.
Won't that exist in a redacted form somewhere?
It might be in a different document ID, and I don't have Mr. de
Oh,
Burgh's.
okay.
Sorry, Commissioner. Now,
So what are we getting from this?
I'm just trying to find it, Commissioner. I haven't marked this up. So firstly, does this record what you understood to be the subsequent advice that explained the change of position that you were referring to earlier, Ms. Bundy?
Yes, I understood that the proposal previously wasn't going to allow people to respond to information, and then I think it's the key difference, the average income is only used for the purpose of calculating time when no other information is available and attempts have been made to seek information from the individual.
What part are you referring to where it says no other information is available?
So a key difference between the measure as DSS originally understood it and the approach that was ultimately implemented is that average income is only used for the purpose of calculating a time when no other information is available and attempts have been made to seek information from the individual.
Yes. And that could only be reconciled with the 2017 advice to which we've just identified if no other information is available is a reference to the words last resort. Don't you agree?
Yeah, I think that's right. In hindsight, you could read it in that way. The way that was read was that the information available to the decision maker in front of them.
Do you agree that So you now accept that the statement, no other information is available, is inaccurate in that part of the email.
I think people's understanding of what that meant could be different.
Including the words in that advice, that 2017 advice to which we've just referred, where the words were explicitly last resort.
As I said, I think people's understanding of what certain things mean can differ.
Including the words last resort.
Yes, I think the words last resort can differ. People's understanding of what that means, yes.
In circumstances where the previous advice, the 2014 advice, had been that averaging is unlawful.
So, as I've said, in the past, we used to attempt to get pay slips from employers, and we called that, if we couldn't do that, we called that last resort. Could we have actually done more and sought further information, asked for bank statements at that point? Yes. So is last resort, in that context, a last resort?
So just so I'm clear, what you're saying is that the view as to what constituted last resort changed in the implementation of the Robodebt scheme.
No, what I'm saying is that I think people's understanding of what last resort can mean can differ, and as is what is the best available information.
Surely last resort means there's no other options available.
Yes, and in the past, where we'd gone to employers and that was the step taken and we would average the information, we called that last resort. That did not necessarily mean that there was no other options available.
When this thing started, DHS officers weren't even looking at the DHS file to see if there was anything on there that explained anything. And people were accepting that as a last resort, were they? The information, the employment separation certificate, which might clear things up, is on the file, but we regard ourselves, because the information's here from the tax office, as in a last resort position?
No, Commissioner, I think that was an incorrect position and that was, from memory, referred to in the Ombudsman's report, that if you must consider all the information you have available to you in the records of what's in front of the decision maker. And so that was corrected.
What about a situation where it's obvious from the file that there is a reasonable prospect that with a simple inquiry with the employer, the assumptions underpinning an averaging calculation would be falsified?
So there was, and my recollection is in 2017, where there was, for example, averaging would result in an amount that was not a pay rate or a very anomalous type of pay rate, that what then averaging wasn't applied in those circumstances.
Can I show you an example of what I'm referring to? Perhaps, Commissioner, this document should also be made an exhibit in the previous document that the witness was taken to. Perhaps 3588B and 3588C.
All right. What is it before I make it an exhibit?
Thank you, Commissioner. Ms Bundy, do you have your AAT decisions bundle in front of you that you provided overnight?
Yes.
Can you go to tab 3 of that bundle? That should be exhibit 3461.1 doc ID CTH.0032.002.020.
Yes.
That could be brought up on the screen. Have you had an opportunity to review this decision overnight?
Yes.
Thank you. And for completeness, to accept that this is the first case listed in the AAT-CI case summaries document, which should be behind your tab 2, which is document exhibit 3460, doc ID 3007.0006.1949.
Yes.
Same case? Mm-hmm. And the case summaries document is a document you had provided to you in 2017?
This is not the case summaries document provided to me in 2017.
Were you aware of the case that we're referring to in 2017?
Yes.
Okay, thank you. Go back to the case, please. Go to the second page of the document. First paragraph, call that out, please. This social security recipient gave birth to a child on the 17th of June 2014.
Mm-hmm. Yes.
As a consequence, she claimed parenting payment for which she was paid from the 17th of July 2014 until 16 June 2015.
Yes.
And that's the fact that she was giving birth to a child would be why she would be claiming that payment, correct?
You would assume so, yes.
But notwithstanding that, there was a decision made on the 11th of October 2016 that she was not entitled to that amount. Do you see that?
Yes.
Part of the online compliance intervention process.
Yes.
And if we go to paragraph 2 and call that out, the recipient sought review of this decision and an ARO reviewed the available evidence but was unable to speak with the recipient.
Yes.
And there was a decision made to average her income using the ATO data.
Yes.
And so that even though she wasn't working over those 2 weeks while she had a child, it was deemed that she'd earned income over that period.
Yes.
And part of the calculation involved, if we go to paragraph 10, paragraph 3.
Well, she was actually on unpaid leave from October to March. It wasn't just the 2 weeks you referred to that she
That's
wasn't
right.
working.
And so the process of this decision was to average out her income across the entire period, including, we go to paragraph 10, it was in receipt of paid parental leave. See that?
Yes.
And paid parental leave is a source of income that's not assessable for the purpose of the income test, correct?
Yes.
And so the decision erroneously took into account, as part of her income, amounts paid as paid parental leave, which shouldn't have been taken into account, correct?
Yes.
And would you accept that the circumstances of this case demonstrate that it would have been a very easy exercise to make inquiries with the employer to ascertain the true state of her income and what she was doing on leave?
I would say in respect of this case that it was in 2016, the review and decision, and obviously the AAT decision was in 2017, and there had been changes made. So yes, could inquiries have been made with the employer previous to the applicant engaging? Obviously, once someone engaged, there was a different process that came about. But equally, there were circumstances, and as I said, where and we continue to, sort of approach to continuous improvement, where if there were circumstances that where averaging wouldn't seem to be the right approach. And I'm not sure from memory what the process then became, whether or not there were inquiries made with the employer or in actual fact we just stopped the review.
Well, let's take it in steps. Do you accept that on no view could it be said, on no view at all, could it be said that in these circumstances averaging had been applied as a last resort?
No.
Do you accept that or not?
Yeah, I accept that we were not using averaging as a last resort.
Right. Okay. And the only advice that you've been able to identify is supporting the use of averaging in March of 2017 was an advice that said you could do it as a last resort.
Yes, that is what the advice said at that time. As I've said, I read the email from DSS to the Ombudsman is my recollection. I took from that DSS had said this is consistent with the legislative requirements and that we could make decisions based on the best available information in front of the decision maker.
Where there's no other information available.
In front of the decision maker at that point in time, and under administrative law, there was no duty to make further inquiries.
All right.
Where did that last bit come from?
That was advice provided from Annette Mussolino and Mara Stiglitz.
Thank you.
Thank you. All right, that document can be taken down. You state in your statement at paragraph 19, I think, that one of your role included reporting on the performance of the review process and, as appropriate, escalate issues to the service delivery roundtable. Do you recall saying that? What was the service delivery roundtable?
The service delivery roundtable was what we would call a tier 2 committee. So you'd have the executive committee and then a range of committees that reported through to the executive committee, and the service delivery roundtable was one of those committees.
Right. And when you say it was a tier 2 committee, what level of people were on it?
I don't recall specifically who was on it and membership change, but it would be secretary and or deputy secretary and Van Twos would be my expectation, but the department or agency should be able to check that in its records.
So secretary and deputy secretary as a minimum, ordinarily?
Yes.
Okay. And in reporting to the Service Delivery Roundtable, was it part of your role to report on the outcome of AAT decisions?
No.
Okay. Well, can I just ask you... Could the witness please be shown, and in your bundle, Miss Bundy, it's tab 16 of your main bundle, I believe. Exhibit 3544, doc ID CTH.2001.0006.1296. All right. Now, Miss Bundy, can you see that's an email from yourself, dated the 19th of April 2017?
Yes.
It's addressed to, among others, Damien Brazel and Annette Mussolino.
Yes.
And you state, and it's also addressed to someone called Alison McCann.
Yes.
Who was Alison McCann?
She was the acting general manager of the compliance division.
Okay. You see in that email you say, do you accept that you say in that email, hi Damien, Annette and Alison, see this week's SDRT report?
Yes.
You agree that's a reference to that week's Service Delivery and Roundtable report?
Yes.
And you say, we are going to pull together the list of the 10 set-aside decisions relating to OCI. We need to have a better feedback loop with these. I think where we aren't appealing and how we are going to manage and then ensure feedback goes back down regarding decisions. See that?
Yes.
If we aren't appealing, then we are accepting the decision is correct, which means there is either new evidence, that's okay, but if there has been something we shouldn't or shouldn't have done along the way from the ARO down, we need to address. Do you see that?
Yes.
All right. And so when starting with the comment about needing to address, what would need to be done to address the decisions?
So what this email was talking about was how do we have a better way to learn and take insights from AAT decisions. So when I arrived in the branch on my first day, it was raised with me that there'd been an incorrect position in a letter. And my recollection is I asked the team, how do we manage our quality framework around decisions? And there was an approach to managing our decisions with what we would call a quality check going up, but the approach to managing and reviewing AAT decisions down and seeing is there something that we need to take from that? It didn't appear to me to be a broad framework in place.
All right. Well, what about decisions to the effect that a fundamental aspect of the Robodebt scheme, such as averaging, was unlawful? Would that be something that would need to be addressed?
Well, that wouldn't be addressed through this process. That would be addressed through Legal Services Division.
So that was of no interest to you at all, whether or not...
It was of interest to me, of course, but it was the role of Legal Services Division to undertake legal analysis and provide legal advice to the department.
Right. And if that legal advice said that there was no error of law in a decision of Tier 1 AAT decision in respect of the lawfulness of a determination of the lawfulness of averaging, then that would be for AROs to address as well, wouldn't it?
So I think with the AAT, the facts and the circumstances always, can be different. And so if there was a particular matter of law that had come up within an AAT decision, and I think yesterday looked at the process between DHS and DSS, that would be considered between the agencies. Where we had accepted a decision that it was correct and open based on the facts and the evidence before the tribunal to make that decision, then we had to see, was there something that we needed to be doing differently from a process perspective?
Right. Will you just show the witness, please, Exhibit 3545, Doc ID CTH.2001.0006.1297, please. Do you recognise that as the Service Delivery Roundtable report that's attached to the email that I just showed you?
Yes.
And you would have prepared that report?
Staff in my branch would have prepared that report.
And it would have required your approval?
Yes, it would have required my approval and then my boss's approval.
And
my boss's approval.
And you would have reviewed it before approving it?
Yes.
Okay. Can we just call out the last two bullet points on the screen there, please? Sorry, third last and second last.
And if you want a hard copy, it's probably the tab behind the email you were looking at, which is 17.
Could I just ask you to read that to yourself, please?
Yes.
Bundy? Now, do you accept that this is an SDRT report where the SDRT is being specifically informed of the outcome of AAT decisions?
Of these particular AAT decisions, it wasn't normal practice to do that, but given the focus on OCI, we had included these.
Right. And the report specifically notes that one case questioned the use of averaging.
Yes.
So do you accept that, as at the date of this report, you were aware that there were at least one decision of the AAT calling into question the use of averaging?
In the circumstances and facts of that case, yes.
Right. And it was important enough that it be drawn to the attention of the SDRT?
I think matters related to OCI, it was important that they were included, whether or not it was specifically that case or the other case, which also had issues.
Do you have a recollection which case that was?
No.
Okay. That can be taken down. Can the witness please be shown Exhibit 3482, Doc ID CTH.3036.0011.7186. It should be in your tab, in your OCI cases bundle, tab 24. Ms. Bundy? You got that there?
Yes.
Have you had an opportunity to read this decision overnight?
I reviewed it, yes.
Do you accept that is a decision of the AAT on the 8th of March 2017?
Yes.
And do you accept that the tribunal decided to set aside a debt decision with directions that, one, no debt or debt component is able to be founded on extrapolations from Australian tax office records? Do you see that?
Yes.
2, the earnings components of any recalculated debts may be raised but must be based on and confined to any fortnightly salary records obtainable in the exercise of statutory powers. See that?
Yes.
And debt amounts, if any, as so varied, are recoverable debts not able to be waived. Do you see that?
Yes.
Commissioner, I apologise. Could I just ask the examination to be paused? The references that my learned friend's giving is not consistent with the bundle that we were provided. I'm just trying to locate the document. It's not being put up on the screen. Can it be put up on the screen?
Yes.
Your way through?
Please.
I think it's the first Carney decision on the 8th of March.
Now, just for reference, Ms Bundy, in your main bundle, behind tab 9, you should have an email which is exhibit 3537, doc ID CTH.3044.0003.3779.
Yes.
And do you accept, by reference to that email, sorry, that document, which is an email from Mr Brazel to yourself on the 27th of March 2017, and in particular, the description of the attachments to it, that attached to that email was the decision that you just had in front of you?
Yes, it says so on the attachment, so
I just asked you not to mention the case. Thank you. You accept that? It's the same case?
yes,
Thank you. All right. And you say you accept that that decision was drawn to your attention on the 27th of March 2017 by Mr Brazel?
yes,
All right. Can we go back to the decision, please? That was exhibit 3482, doc ID CTH.3036.0011.7186. If we could go, please, to page 3. Should be the last 4 digits, 7189. What's going on? Have you got the third page of that decision there, Ms Bundy?
yes,
So we're talking about the same decision.
yes,
Page 3. Okay, great. Can you see the section headed towards the bottom of the page? What is the law and how has the tribunal applied it?
yes,
Do you accept that that is indicating that what follows will be a consideration of the law?
in particular how the tribunal has applied it, yes,
And if we call out paragraph 22 on the bottom of that page, do you agree that it identifies the legal question that the tribunal was considering being whether fortnightly earnings and any overpayments based on the difference between such earnings and the amount previously paid in that fortnight can provide a secure legal basis for finding an overpayment or determining its quantum?
yes,
And the fortnightly earnings, he's talking about fortnightly average earnings in the preceding paragraph.
Oh yes, paragraph 21, do you see that?
yes,
Centrelink has relied on extrapolated fortnightly average earnings.
yes,
So the question squarely being considered by the tribunal is the lawfulness of the use of averaging to calculate the earnings.
yes, well, it would be setting out what is the law and how the tribunal's applied it, yes,
If we go to page 6, para 33. Call that out, please. See there that it talks about Centrelink not being absolved from its legal obligation to obtain sufficient information to found a debt. in the event that the first instance contact with the recipient is unable to unearth the essential information about actual fortnightly earnings. You see that?
Yes.
And then if we go to the next page, please, call out paragraph 37. To see the... Do you agree with me that the tribunal is identifying that the question that's been considered is not a question about the adequacy of inquiries, rather it is a question of the sufficiency of proof of the debt that's been alleged?
Well, what it's saying, it is a question of a proof rather than a threshold for inquiries. Yes.
Thank you.
It's not adequacy of inquiries, it's appropriateness of inquiries, which may be fine where there's a discrepancy, but it's not sufficient to give rise, or whether it is sufficient to give rise to an overpayment.
All right, now we go to page 10, please. And you can see the heading, how does this part of the law apply to the alleged debt on that page?
Yes.
And paragraph 54 says, the short answer to my question is that the law results in there being no provable overpayment or overpayment quantum on the facts before the tribunal. You see that?
Yes.
And the reason for that is explained in the subsequent paragraphs. In particular, paragraph 55 says the reason it does not establish either an overpayment or its quantum is due both to the lack of sufficient strength of evidence and to simple mathematics. And do you agree with me that in the paragraphs that follow, what the member identifies is that the use of averaging is not a lawful basis to calculate the debt?
I have to say I didn't, even reading it last night, fully understand everything with what's being said in the decision. I would say that on what is being said is that based on the facts before the tribunal, there is not sufficient strength of evidence to raise a debt.
Where in the passages to which I've directed you, Ms Bundy, does the member qualify the proposition that there's insufficient evidence by reference to the specific facts?
It says on the facts before the tribunal in paragraph 54.
Paragraph 54. Paragraph 54 says that the short answer to my question is that the law results in there being no provable overpayment or overpayment quantum on the facts. Oh, I see. So is it your evidence that you understood this passage to be that only in the specific facts of this case is or was averaging not a lawful basis to prove?
My recollection is I didn't actually read this decision. It was, as I understand it, what we would call a manual decision related to the manual process as opposed to OCI. And my recollection is that, and based on the email trail and the fact that it's 18 pages long, that I read the decision at the front and I didn't read the entire decision.
As the manager of the appeals branch, responsible for the AROs who had a duty to have regard to the decisions of the AAT, are you saying you did not read this decision?
There were 13,000 AAT decisions every year. There are 30% of those that are set aside. It is not possible with a branch of 400 people to be reading every AAT decision. Our focus was on OCI, which was the system.
You see, if you'd looked at paragraph 56 and 57, it would have told you, never mind the facts of this case, that the methodology just wasn't sound. And it was a lengthy decision setting aside a decision for reasons which extended to an assessment of the law as well as the facts. So how could it miss attention?
That's what we would rely on Legal Services Division to do. It is a very legalistic piece of writing. As I said, even reading it last night, I didn't quite understand it all.
Well, could we please go to page 16 of the document? We call out the section headed decision, please. Do you accept from me that this part of the decision clearly directs that on the redetermination of this particular matter, the calculation is not to be based on averaging?
Yes?
Right. Were the AROs in your branch responsible for implementing this decision?
I don't recall the process for implementing it. I don't think the AROs implemented it. It was usually the relevant business area in the agency that would implement it.
So being the agency that made the original decision?
Yes, but you probably would need to check with the agency as to how that works.
How could you tell which decisions were and weren't OCI decisions? Because it doesn't seem that the tribunal itself knew.
We specifically set up a flag on the system, and I don't recall if I'd asked for that to be done or it had already occurred before I commenced. And so the team were tracking that. It wasn't the normal way that decisions would be looked at. It was just given the focus on OCI at the time.
It seems odd because the manual intervention cases were part of the pilot for OCI and they were to test the methodology. So why would you not be interested in them, do you know?
There was confusion around things, but in particular, the focus at the time was that the system was the problem, the OCI system.
So it was just about the technology, or?
Yeah, that somehow the system had been automating things and that was the problem, and that's where people's focus was.
Well, I suppose there was the little matter of duplicating people's earnings to give them double the income and tell them that they weren't entitled to pension for 4 years and that sort of thing. I can understand how that would be a concern, but it just didn't cross anybody's mind to think about whether tribunal's decision in relation to the use of averaging as the default position would be an issue.
I was very alert to the issue of averaging, but more in the context of making sure as a whole that if there were particular processes that we needed to change, we could be looking at those, and not just in the context of averaging, but other matters that may have been coming up in those AAT decisions. Noting I was only in the appeals branch for about 11 weeks. All AAT decisions that are set aside are reviewed by Legal Services Division. And so I don't have an understanding of what Legal Services Division was doing with those decisions.
Even though what some of these decisions were saying was that the process of averaging itself should not occur. And that's a process issue, surely.
Well, I think that we were very focused if there were particular facts within the case that we needed to consider those, and if there needed to be a change in a process.
All right, thank you.
We just go back to Exhibit 3537, Doc ID CTH.3044.003.379. This is your tab 9, Miss Bundy. You'll recall, hopefully, that this is the email we were discussing earlier, in which you confirmed that the decision we've been discussing is the attachment to Mr. Brazel's email to you, dated the 27th of March 2017.
Yes.
And have you had an opportunity to read this full email chain, Miss Bundy?
Yes.
And you agree that throughout the chain you are being informed of various various decisions by the AAT to set aside debt decisions?
There is one decision in addition to the one Mr. Brazel sent.
Well, there's the one on the bottom of the email chain. See that?
Or maybe it's two.
And then, so there's one on the bottom of the email chain. There's another one on the first page, and then
Yes, so I think there's two. There's a third and a fourth.
okay,
Yes.
thank you. All right. And do you accept that the purpose of these various emails was to be monitoring what was coming out of the AAT insofar it was important to the online compliance system?
Yes, these were specific to cases that had come through or people have been asked to go online, yes.
Okay, and even though the decision we've been discussing wasn't under the OCI, Mr. Brazel thought it sufficiently important to this consideration that he specifically drew that decision to your attention in the last email on the chain, didn't he?
Yes, there was a connection, yes.
And so, therefore, surely, in that context, it was important to read that decision to understand what it was stating.
As I said, and I received, I think, the email at 9 p.m. on a Monday night. It was 18 pages long. We have thousands of decisions. It was a very busy time. My recollection is I looked at the decision statement. I perhaps reviewed, I don't recall specifically what I did. And I do, well, do I recall that or do I think that from reading it last night? It is very long and legalistic.
All right. Well, can the witness be shown this document, which should be behind tab 20 of your AAT decisions bundle, Doc ID CTH.3044.0003.3783, exhibit number 3478. Do you see that email, Ms. Bundy?
Yes?
Okay. Now, we go to the middle of the page. Can you see the email from Mr. Brazel to you Monday the 27th of March, 9:15 p.m?
Yes?
Do you recognise that as the same email we've been discussing just moments ago?
Yes?
All right. If we go further up the chain, email from yourself in response to Mr. Brazel's email, 27 March 2017. Your response is, and that's a response to Mr Brazel's question in the earlier email, are you aware of the attached matter also? Your response, nope, that must be a manual process one as we are only specifically tracking OCI. When did this come in and does Melissa, etc. know? Yes. See that? And I suggest that's a clear recognition by you that even though it's a manual process one, given its comments on averaging, you recognised that this was a significant decision.
Well, it was a set-aside decision, and I think I looked at the times between 9:15 p.m. and 9:17 p.m. And it's probable I would have opened it, but I would not have read further than the decision. And yes, given that it was about the averaging, that is probably why I said that, but I don't recall.
It's almost certainly why you said that, isn't it?
Yes, almost certain, yes.
Thank you. And do you see Mr Brazel's email and response? I'll look into where this is at. Was brought to my attention on Friday but have not escalated. Do you see that?
Yes.
And then your response at the top of the chain. We need to escalate this ASAP.
Yes.
In other words, as soon as possible.
Yes. People should be aware that another decision had been come in, yes.
Not only just another decision, a decision that had found it was averaging in the way that it was being used under the Robodebt scheme was unlawful.
Certainly at that time, that wouldn't have been the reason that I had said that, especially given the times.
So what would escalating it have involved?
Making sure that people are aware that there'd been another decision that had come in. It needed to be looked at and considered in light of all the other focus on the program.
People being made aware being which people?
It would be Annette as the Chief Counsel, potentially Chief Operating Officer. It would be, those people would be the ones I would be mainly referring to, and then possibly Melissa as well.
Melissa Golightly.
Yes.
Thank you. That can be taken down. Can I just take you, asked to be brought up on the screen, paragraph 159 of Ms Bundy's statement on page 29. Call that out. So, Ms Bundy, this is of course after your time in the appeals branch
Yes.
and your time being involved in the response to the Robodebt class action.
Yes.
And is this right? You were asked to, I'll state it in terms of your statement, you sought to understand the evolution of compliance activity and income averaging in the social security system.
Yes.
Were you requested to do that by anyone?
I don't think I was, no. I can't recall.
Okay, you just did it of your own volition?
I may have had a discussion with Annette about it, but I was there was a couple of reasons. Obviously the class action and historical information was relevant to the case and the lawyers understanding how we got from one place to another. And in addition to that, I had a personal interest in understanding how did this start.
Okay, well, on page 30 of your statement, paragraph 161, subparagraph E, you refer to a case of Benjamin Osgood and Secretary, Department of Social Security, 1997, AAT A5. Do you see that?
Yes.
Which you concluded dealt with averaging.
It considered it.
Did you review the decision?
I briefly reviewed the decision. My recollection is a compliance officer provided that. I provided that decision to the legal services, Lisa Keeling, who was assisting with the class action, who provided that to AGS, and it was used in the submissions as an indication of how averaging had been used in the past.
Can I ask that the decision be brought up on the screen, please? It should be in your tab 36, I hope, Ms Bundy, of your AAT bundle.
My version of that bundle only goes to 28, so
I've got,
you sure it's 36?
yes, unfortunately.
Which bundle is it? The
Should be the AAT cases bundle.
the AAT case bundle, right. And like Ms Hogan-Doran, I don't have that
Commissioner,
many
this is the bundle
tabs.
that I was provided, that I was instructed was provided by Officer Solicitors assisting to the Commonwealth.
Anyway, can it be got up
Yeah, it's up.
nonetheless?
Is this the Osgood case that you referred to in your statement, Ms Bundy?
Yes.
Okay. Can we go to the last page of the case, paragraph 35? Sorry, second last page, paragraph 35. Call out paragraph 35. To see there it says, this tribunal finds in the circumstances of this case that for the respondent to rely on inferences average fortnightly taxable income from other established facts to indicate the existence of undisclosed income is reasonable.
Yes.
Now, those words, from other established facts, would you accept that's consistent with what the Solicitor General said, that it might be permissible to engage in averaging where there's other evidence to support the inferences drawn from the averaging?
I haven't done an assessment on that paragraph against what the Solicitor General has said. In the past, we didn't use PAYG information at the time of this decision. It would have been people's tax returns that we obtained in terms of their information. So I'm not sure. Again, I didn't review this case last night, and at the time I only reviewed it briefly.
Right, so did you satisfy yourself that this case provides any support for the proposition that averaging can be used as the sole basis to calculate fortnightly income?
I did not do an assessment of that. As I advised, I provided the case to AGS, who provided it to council, and it was included in the submissions as support material to show how averaging had been used.
Go back to your statement, paragraph 161. Subparagraph D, you refer to a High Court decision of Harris. Do you see that?
Yes.
Did you undertake any review of that decision to ascertain whether it provides any lawful support for the use of averaging as the sole basis to calculate fortnightly income?
No. The purpose of this was to understand how averaging had been used in different ways in different contexts. This was about the context of an annual rate.
Right.
Noting there were payments in the program that had an annual rate.
Which payments are we talking about?
I think there's particular payments, Commissioner, that are calculated on an annual basis. I think they're the pension type based payments.
Yeah. Age pensions, but not New Start.
Not New Start.
Not youth allowance.
Not youth allowance. DSP, a disability support pension, and parenting payment single. But I don't.
But the expression used, I think you identify in Harris, was annual rate of income, and that has no bearing on most of the income support payments that just talk about income earned, derived or received, and the calculator takes you to the fortnight in which it's
Yes, there would be
earned or
a
received.
yes.
Okay.
Can the witness please be shown Exhibit 3580, Doc ID CTH.3504 0001.0187? Do you recognise that document, Ms Bundy?
Yes.
Is that one of the documents you identified? Sorry, is that email from Mr Robertson to yourself on the 22nd of July 2020 an aspect of the product of the research work that you did relating to the history of averaging?
Yes, from Ms Robertson, yes.
Okay, and if we can see the email, is it a Miss Robertson?
Sorry, can you repeat
It's a
that?
Miss Robertson?
Ms Robertson, yes.
Thank you. We can see that forwards an email from Andrew Thompson dated the 21st of July 2020,
Yes,
and that refers to a project done in 2008
yes,
involving a former staff member.
yes,
And if we go to, in the same document, the document with the last four digits 0191, do you recognise that?
yes.
And is that effectively the report of the review that's referred to in the covering email?
I don't think that's the report, no.
Well, the covering email referred to a former staff member undertaking a full national review of DMP, and this document is headed Review of Payment Review Branch Activities.
It maybe I just have to see the other pages to confirm that.
Well, it should be behind your tab 61.
61?
You flick through it. It might be tab 62, I'm told, in your version.
No. Yes. In particular, I took it's not page numbered. There's a document which is the 0207, PAYG and DMP, compliance reviews, consistent review procedures. I'm just trying to recall whether or not one's attached to the report or this is the actual review. I think that could be two separate things and one's attached to the review of someone else.
Oh, okay. Right. In any event, this is something you identified in the course of your investigations.
Yes,
And the document included attachments of some task cards,
yes,
which were instructions to staff on how to undertake data matching program reviews.
yes.
Okay. Can we go to within the same bundle, the part of the document with the last four digits being 0217? Call out the third paragraph. Do you see there, Ms Bundy, it states what may be done once employer documents are returned to Centrelink,
Yes,
and it states that the person applying this task card is then in a position to calculate the actual impact on the customer's entitlement. Do you agree with me on that? First sentence.
yes.
Thank you.
Yes,
If we call out the next section headed employer is unable to be located and the two paragraphs underneath that,
yes,
do you agree with me that what follows in this task card under the heading employer is unable to be located is dealing with a situation when the employer has not been able to be located by the compliance officer?
yes,
Right. And that, having read the earlier section that was drawn to your attention, under this task card, the starting point for a review using the data matching program was to contact the employer.
yes, that was the starting process, to attempt to contact the employer.
Which at the outset is obviously completely different from how averaging was used under Robodebt, correct?
It was a different method of collecting information. The same mathematical principle of averaging was applied.
And can you see under this heading, employer is unable to be located, it states, before deciding whether an employer can be located, investigating CSAs need to ensure they have followed every possible avenue to contact the employer.
Yes,
I suggest that is an obvious recognition of the need for extreme caution before calculating someone's fortnightly income based on annual ATO data.
what I would say is that it's the process that needed to be undertaken before you would calculate.
And it requires extensive steps to be taken before a conclusion could be reached that the employer was unable to be located. Do you agree?
There's a number of steps, yes.
It's extensive steps, aren't they?
It's fairly thorough, yes.
You said before it was a different method of collecting information, but the thing is that under Robodebt there was no collection of information apart from the ATO data, surely?
Not when the person didn't respond to contacts. Yes, there wasn't the process to then go and get the information. The averaging occurred at that point. With this, it was after contact attempts had been made.
All right, can we call out the next two paragraphs, please? Can you see the first sentence in that, the first of those two paragraphs commences with, if undertaking the appropriate searches to locate the employer?
Yes,
And that's obviously a reference to the searches described in the preceding section of the document we've just discussed.
yes,
So, in other words, unless after extensive searches the employer couldn't be located, only then could the ATO information be used by way of averaging.
Yes, that was after, or as I understand it, the employer did not respond, which was also the case in some circumstances.
Which is nothing like what happened under Robodebt, is it?
Well, the averaging occurred, there was no attempts to go to employers before averaging would occur.
Thank you.
My understanding is averaging occurred automatically if you didn't have a response from the customer.
There would be outbound contacts. So it changed, obviously, when there was the Ombudsman's report. It would occur if someone hadn't responded to the letters and then phone calls. Averaging would occur, although there were, from my recollection, is there's guidance about particular scenarios and fact scenarios when it wouldn't occur.
Okay,
That's how it
but
would
it
work.
would occur if the customer couldn't provide the information, even if they'd made contact?
Not necessarily. It would depend on whether or not the explanation for the discrepancy could be explained and the compliance officer thought that was sufficient.
Yeah,
It's
okay.
my understanding of how that worked. But the guidance material should be able to set that out.
All right, thank you.
Thank you, Commissioner. One last question, Ms Bundy. Page 12 of your statement, paragraph 36.
Yes.
That refers to a meeting on 27 April 2017
Yes.
with AAT members.
Yes.
Mr McNamara presented at that meeting.
Yes.
Were you present at that meeting?
Yes.
Do you recall AAT member Terry Carney being at that meeting?
I don't recall him being at that meeting, but during the class action I read his affidavit and then realised he may have been at that meeting, although I just need to check, I would have to check the dates of his affidavit, but I expect it was the same meeting, yes.
Do you recall comments by any AAT member present at that meeting about the lawfulness of averaging as it was being used under the Robodebt scheme?
No.
Thank you. Commissioner, that's the evidence.
Ms Hogan-Doran?
Ms Bundy, you gave some evidence that you commenced in the appeals branch on the 10th of February 2017. In your statement, you indicated you concluded in that role on the 30th of April 2017. So you're approximately how long in that role?
Nearly 3 months, but I think it's 11 weeks.
You gave some evidence today, you referred to providing a report to the Service Delivery Roundtable and that report was requiring your boss's approval. Who was your boss in that context?
It was Jim McMahon.
And what was his role?
He was the General Manager for the Debt and I think it was called the Debt and Appeals Division, but it had the Debt branch and the Appeals branch in the division.
Just on that issue and in relation to your role at the time in which you were the National Manager of the Appeals branch, what was the relationship between the Appeals branch and the Legal Services Division?
So the Appeals branch sat in the Information and Integrity Group and that had the authorised review officers that would do the internal reviews, and it had the staff that would help compile those documents. There was ongoing engagement with legal services given the connection between the AAT. Legal services managed appeals from AAT 1 to AAT 2 in consultation with the Department of Social Services. So there was ongoing engagement, but it was the role of legal services to provide legal advice. It was very much an administrative, operational branch, was the appeals branch.
Just before I go back to some of the other things I wanted to raise with you, just on that answer, talking about the Legal Services Division managing appeals from AAT1 to AAT2, the appeals division in the period in which you were in the role of National Manager was managing the appeals from the decisions of the AROs to the AAT1?
Managing the documents, so collating the documents. There wasn't submissions in AAT1 cases.
Or just on submissions, did your appeals branch prepare any submissions for the AAT1 decision?
I'm aware now that for Professor Carney's decision there was something prepared, but I don't recall that, and I think it would have been Legal Services Division that did do it.
At the time in which you were in the role, did the appeals branch receive the decisions of on AAT1 reviews?
It came through the system, so they would have had access to the system, but it came through the system. And you'd have to check with the agency how that system operated. I can't recall the flow.
Was your appeals branch routinely examining or involved in routinely examining the AAT1 decisions?
As I said, I think there was ad hoc approaches to reviewing decisions. There was a big focus in the agency on making sure they got implemented in a timely way.
Do you know, or is it your expectation that the examination of the AAT1 decisions would have been typically done by the Legal Services Division?
Yes, as I understand it, Legal Services Division review all set-aside AAT1 decisions.
All right.
But you'd have to check, that's correct.
Just going back to the scope of your role and appreciating it wasn't in the Legal Services Division, you gave some evidence yesterday about having had legal qualifications and having practised for a period. Was your role in the appeals branch nonetheless a legal role? And if it wasn't, how would you have described it?
No, it was definitely not a legal role. The National Manager prior to me was not legally qualified. I'm not sure whether or not the current National Manager is legally qualified. It was never expected it was a legal role. Just
before I pass from that issue, you gave some evidence about having worked in private practice after your admission. Just do you know, or doing the best you can, do you know when you did cease to hold a practicing certificate?
It was, I think, maybe 2011 or 12, but I hadn't practiced. I'd have to check. Because we were overseas and then went to Melbourne and I went to Department of Health. I can't recall.
Just to assist you, paragraph 7 of your statement, you refer to having been in corporate national manager roles from May 2014. Can we take it that you didn't hold a practicing certificate at least from that period?
Yes, I would like to just confirm in case I had a plan to go back and be a lawyer and decided to keep it, but I certainly didn't do any continuous learning education, so I doubt I did.
In your statement of paragraph 8A, if we could just have that called up, you set out there the key responsibilities for your role as National Manager of Appeals. I think, I'm not sure, you said your role was not a legal role. It's obviously, from the title, may we take it a managerial role, some kind of operational role. Was that consistently applied to all of those responsibilities?
Yes, well, in the role of SES, your role is really about leadership and assisting your teams to deliver on your responsibilities. And so, it was a very large branch of 400 people and with, a significant amount of direct reports too. So through your people, they assist you to deliver on your responsibilities. So it was very much a large leadership management role.
Just before I pass from that, the third one, develop strategies to enhance the internal review framework. You gave some evidence and answered some questions, and it's also dealt with in paragraph 32 and 42 of your statement that you suggested a need for a better feedback loop. You finished the role on the 30th of April 2017. Do you know whether that feedback loop you suggested subsequently was implemented? Taken
No,
up?
I don't know.
You gave some evidence today that when you started, Mark Withnell gave you certain advice. Remember that evidence you gave?
Yes.
Doing the best you can to assist the Commission. When was that advice given to you by Mark Withnell?
It would have been early February 2017 when I commenced, I expect, in the role.
Did you have day-to-day dealings with Mark Withnell at that time?
I wouldn't say day to day, no.
Can you assist the Commissioner by indicating anything more as to how that communication with you and Mark Withnell came about?
It may have been, I was talking to him about the appeals branch because I recollect that he used to manage it, but I don't recall.
All right. You were asked a question about being given advice about the duty to inquire by Mr Stipniks and Ms Musolino. Assisting the Commissioner, do you recall when you received that advice and in what context?
I remembered it was during my time in appeals branch, was the first time I'd had that conversation, and that advice was provided by Annette Musolino. I'm not sure if there was someone else at that meeting.
No further questions. Thank you, Commissioner.
May Ms Bundy be excused?
Yes, Commissioner.
Thanks, Ms Bundy. You're excused. And I think we will take the morning break there and come back at 22.
Thank you, Commissioner.
All rise. The Commission stands adjourned until 11:40 a.m. please be seated.
Yes, Mr Scott?
Commissioner, it's been drawn to my attention that a couple of the documents which I asked to be tendered as exhibits, I didn't provide document IDs for, and just to clarify the record, I should put those doc IDs on the record.
Well, you might recall you wanted to tender something that would be 3358B and 3358C, and I said, well, what are they? And then I never found out and I never did admit them. So do you want to tell me now?
Yes, please. So B 3588B should be the CTH.2000.007.5658.
And since this is just a poor human intelligence here, could you tell me what it was?
It's the covering email referred to, the covering email from Mr. Steepnick dated 2 March 2017.
All right, so that's B. What's C?
It should be doc ID CTH.2000.007.5660.
And it is?
The attachment to that first email.
All right, I suppose that will do.
That's it there.
That's admitted as 3358C.
And then D will be CTH.2000.007.5662. And it's the third attachment.
Okay, I had B as a covering email, C as an attachment and D as an attachment.
Yes, Commissioner.
Why is it the third attachment? I've only got 2 attachments.
A is the other attachment, Commissioner.
Okay, thank you.
Commissioner, could I just ask so that I'm following along? These are the documents that are footnoted at 122 to the statement of paragraph 146 of Ms Bundy's statement.
Is that right?
Is the document ending .5658 amongst the exhibits?
Yes, to both questions. As to the last of those 2 questions, that's 3588B.
Thank you. I'm indebted.
Thanks. All right, what now?
The next witness, Commissioner, is Mr. Damien Brazel, who I understand arrangements have been made for him to appear by video link.
Sure. And there he is. Mr. Brazel, can you hear me?
Yes, I can, Commissioner.
Will you take an oath, in which case you'll need a Bible or an affirmation?
No, affirmation, please.
All right, well, I'll have that administered. I might ask you to stand for that purpose.
Your response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thanks, Mr. Brazel. Take a seat. Mr. Scott?
Thank you, Commissioner. Mr. Brazel, would you please tell the Commission your full name?
Damien Patrick Brazel.
So it's Brazel, not Brazel?
Brazel, yes. Please.
Brazel.
My apologies, Mr. Brazel.
No problem.
You were issued a notice on the 15th of November 2022 by the Commission,
That's correct.
and you provided a response to that notice dated the 25th of November 2022,
Correct.
and that's a statement.
Yes.
And the contents of that statement true and correct to the best of your knowledge and belief?
Correct.
Commissioner, I tender the notice and statement, which should be Exhibits 3531 and 3532.
All right, they're admitted with those numbers.
Thank you, Commissioner. Now, Mr. Brazel, you hold an unrestricted practising certificate in the Australian Capital Territory.
That's correct.
You are currently a partner at a Canberra-based law firm called Griffin Legal.
That's correct.
Do your areas of expertise include administrative law, government advisory, and information and commercial law?
That's correct.
You were previously employed by the Department of Human Services, correct?
Yes.
And amongst those, your various roles there, they included role of General Counsel Commercial Law from December 2015 to June 2016. You agree with that?
Yes.
And during that time, you reported to someone called Annette Mussolino,
Yes.
who occupied what role at that time?
And that would have been either the Chief Counsel or the Acting Chief Counsel. I can't recall whether she was permanently in that role at that time.
Acting or permanent Chief Counsel of the
Chief Counsel,
of
but
the,
I can't recall whether she was permanently or acting in a role at that time.
Okay, thank you. But I'm just, for precision's sake, I'm just confirming when you're saying Chief Counsel, you mean Chief Counsel of the entirety of the Department of Human Services?
Yes.
Thank you. Then you took on a role of Deputy General Counsel for Privacy between June 2016 and January 2017. Is that right?
Until when, sorry, Counsel Assisting?
January 2017?
Yes.
And then thereafter, you took on a role of National Manager General Counsel Acting for FOI and Litigation for a period January 2017 to May 2017.
Yes, correct.
And who did you report to in that role?
Annette Mussolino.
Right. And that team that you were National Manager General Counsel for in an acting capacity, was it sometimes referred to as the FOIL team?
That's right, standing for Freedom of Information and Litigation.
And does that reflect the fact that, apart from freedom of information, one aspect of that team's role was litigation that the Department of Human Services was involved in?
Yes, from Administrative Appeals Tribunal Tier 2 and upwards.
Right. And would it be right that your team had carriage of matters that were on appeal to the General Division of the AAT and also appeals of decisions of the AAT to the Federal Court or higher? Is that right?
Yes, yes,
And in effect, you were the responsible lawyer for those matters, correct?
yes.
All right. Now, those matters during the period you were in that role would include appeals from or in relation to decisions of the AAT about debt decisions under the Robodebt scheme?
Yes.
Your team, did it have conduct of the Tier 1 AAT appeals?
No, we did not.
But did it have a role in relation to providing advice on whether to appeal those decisions, that is Tier 1 decisions of the AAT?
Yes, it did.
And conduct of any appeals to the Tier 2 level of the AAT, correct?
Yes, yes.
During your time in that role, was there ever an occasion where your team was involved in an appeal from a Tier 1 AAT decision about the Robodebt scheme?
No, not that I can recall.
Okay. Now, of course, you had knowledge of the Robodebt scheme at the time, didn't you?
Yes, I did.
And you're aware that a defining characteristic of that scheme was that it permitted debts to be raised against Social Security recipients based on a calculation of those recipients' fortnightly income using ATO PAYG data, correct?
Yes.
And that data would cover a period that was broader than each fortnight under consideration, correct?
That's how I understood it, yes.
Therefore, the income revealed in that data was averaged across each fortnight in those decisions under the Robodebt scheme, correct?
Sorry, can you say that again, Counsel?
Therefore, when it was taken into account, that data would be averaged across each fortnight to calculate fortnightly income of Social Security recipients for the purpose of those decisions. correct?
In terms of the debt decisions?
Yes.
Yes.
And it would therefore be a necessary feature of those decisions that they would be based on an assumption that the amounts revealed in that data was earned in equal amounts per fortnight, correct?
That's the logical conclusion, yes.
And that assumption was permitted for debt decisions in circumstances when a recipient of social security was thought by the department to not be able to be contacted by the department, correct?
Yes, I think that was one of the factors for how the now Robodebt scheme is run, yes.
And in those circumstances, was it your understanding that the compliance officer did not have a discretion to make inquiries with the recipient's former employers after failed attempts had been made to contact the recipient, correct?
That I'm not sure of. We didn't have day-to-day running of those debt decisions. That was done by the compliance area.
So just to be clear, you were not aware that under the Robodebt process, a recipient of social security, sorry, I beg your pardon, under the Robodebt process established by the department, a compliance officer who was conducting a review and had concluded that the recipient's former employers were not able to be contacted. They had no discretion.
I'm not sure if they had no discretion, but that's how I understood the program was administered, yes.
Sorry, I'll rephrase that, Mr. Brazel. I've just realised I've confused the question. I'll rephrase it and restate it and ask you to answer again.
So,
did you understand that under the process established by the department for the Robodebt scheme, that once a conclusion was reached that the recipient could not be contacted, the compliance officer then did not have a discretion to attempt to contact the recipient's former employers?
I'm not aware that they had no discretion, but I understand that was the process, yes.
Right. And by the process, you mean the process established under the policies and procedures of the department?
That's right. I've referred to usually as the operational blueprint.
Yes. And when you say you're not sure whether they had a discretion, are you referring to whether you're not sure whether they had a legal discretion?
Not a legal discretion. I'm not sure whether I can't recall what the operational blueprint provided for those processes.
Okay. Well, in any event, you were aware that under those processes, compliance officers conducting a review were permitted to calculate a social security recipient's entitlement based on an assumption that they had earned their income in equal amounts per fortnight. Correct?
Yes.
And thereby rely on the ATO data to average that data across each fortnight that was being considered.
Yes, that's how I understood it.
Right. Now, by that stage, you'd been in government legal practice for a number of years, correct?
Yes.
And had gained a knowledge of the principles of administrative law?
Yes.
And would have been aware that one of those principles is that for an administrative decision to be lawfully made, it has to be based on evidence?
Correct.
And you were aware, were you not, that the assumption to which we've discussed, that is, that recipients had earned their income in equal amounts per fortnight, under the Robodebt scheme, was based on no evidence?
Not at that time, no.
You weren't aware of that?
Oh, sorry, no, I disagree with the proposition at that time.
Right.
There was evidence from the ATO data matching process.
I see. So just to be clear, your understanding at the time in 2017, early 2017, that the ATO data provided evidence to support an assumption that the recipients earned income in equal amounts per fortnight. Is that right?
I think, yeah, that is my understanding of it, yes.
Right. And that data that we're discussing, to be absolutely clear, is data that would be amounts of income earned by a recipient over a period that would be broader than each fortnight under consideration.
Essentially, yes.
And it did not occur to you at all, is this right, that there was no evidence supporting those decisions from which it could be concluded that those amounts revealed in that data were earned in equal amounts per fortnight?
I'm not sure I can answer that in such general terms, Council. I guess at that time I was the cases that came to my attention through AAT Tier 1 reviews. Some of them used that concept of averaging, as it's called, and those processes, or that process did appear to be consistent with the law and the department's position at the time.
But Mr. Brazel, I beg your pardon. I'm sorry, I've done it again.
Thank you, Commissioner.
Mr. Brazel, when averaging was applied, I think you're agreeing with me that involved an assumption that the amounts being averaged were earned in equal amounts per fortnight, correct?
Yes, as the term averaging provides, yes.
And the ATO data didn't specify how much was earned in each fortnight, did it?
No.
So it couldn't possibly be regarded as evidence that those amounts revealed in the data were earned in equal amounts per fortnight, could it, Mr. Brazel?
Not on that basis, but as I understand it, this process was applied where the individual hadn't provided information relevant to particular fortnights, such as payslips or the like, and therefore, because that information wasn't available to a decision maker, the averaging process was applied.
But an absence of evidence is not going to provide evidence, is it?
No, Commissioner.
There's no magic presumption you can get out of the fact that the person hasn't responded, surely?
No, there's not.
And you would have been aware of that at the time, Mr. Brazel, correct?
Yes.
So you must have been aware that the assumption upon which these averaging decisions were based, that the ATO data was earned in equal amounts per fortnight, was not based on any evidence. Correct?
I'm not sure. I agree with the proposition you're making. I'm just, I guess, struggling with the application of that across the board, across all well, at least the cases we had visibility of in the FOIL team. And those ones were the cases where they were remitted or varied by Tier 1 AAT.
Well, can I ask you this, Mr. Brazel? In the absence of any other evidence as to the amounts of income earned by a recipient, over the course of a period under consideration, the ATO data couldn't provide an evidentiary basis for a conclusion that the amounts revealed in that data had been earned in equal amounts per fortnight, could it?
Not the ATO data, no.
Thank you. And you were aware of that at the time?
I believe I would have been, yes.
Thank you. Now, Mr. Brazel, I understand you have in front of you 2 folders.
That's correct.
One, a large folder, and another one should be called AAT decisions.
Your AAT bundle, yes.
Thank you. Mr. Brazel, I think it's tab 23 of your AAT cases bundle, which should be doc ID CTH.3761.0001.0223_R, exhibit 1569.
Yes,
Do you have that there?
I do.
And can you see on the screen in front of you the same decision of AAT member Carney in front of you?
Yes, I can.
And that's the decision that I've just referred you to?
That's correct.
Thank you. And just for context, Mr. Brazel, also in that large bundle that you've got, hopefully behind tab 9, should be a document exhibit 3537, doc ID CTH.3044.0003.379.
That's correct.
Okay. Now, do you accept that at the top of that email, it's at the top of that chain, it's an email from yourself to Miss Bundy,
Yes,
dated the 27th of March 2017?
correct.
And Miss Bundy, of course, was head of the appeals branch at the time.
That's right.
And it refers to attachments.
Yes,
Now, the version of the email on the screen has part of the description of the attachments redacted, but hopefully the version that you've got in front of you doesn't have that redaction.
that's right.
So you can see, thank you. So you can see that it refers to an attached AAT decision
Yes,
and that it's the same AAT decision we had on the screen just a little while ago.
yes,
Thank you. And so you'd accept that certainly by the 27th of March 2017, at the absolute latest, you're aware of that decision, correct?
yes, yes.
So if we can go back to that decision, which was, yes, we have that there. Do you recall reading this decision about the time of the email to Miss Bundy that we've just seen?
Yes, I do.
Do you recall the effect of what this decision said in relation to averaging?
Yes, and I reread it recently to remind myself, yes.
And do you recall that it clearly states that calculating debts on the basis of averaging is unlawful?
I believe, I'm not sure whether it says it's unlawful, but I believe Professor Carney that it was inconsistent with the social security legislation.
And if it's inconsistent with the social security legislation, it's unlawful, isn't it, Mr. Brazel?
Yes.
And that would have been clear to you when you became aware of this decision at the end of March 2017 at the latest.
Yes.
And if we go to page 16 of the decision,
Yes.
I'm just asking the operator to go page 16 of the decision. Thank you. And we call out the section headed decision towards the bottom of that page. Now, I'll just ask you read that to yourself, not aloud, and then I'm going to ask you some questions about it.
Yes, Council.
Now, do you agree that it identifies that the tribunal had in this decision set aside the debt decision and remitted it to the department?
Yes, with directions.
With directions, yes. And those directions are identified with the numbers 1, 2 and 3.
Yes.
And the first direction states no debt or debt component is able to be founded on extrapolations from Australian Tax Office records. See that?
Yes.
And this second direction is that the earnings components of any recalculated debts as may be raised must be based on and confined to any fortnightly salary records obtainable in the exercise of statutory powers to do so. You see that?
Yes.
Now, you would be aware, of course, that when the AAT set aside an administrative decision, it could give directions as to how the reconsidered decision, that is the remitted matter, was to be decided by the department. You aware of that?
Yes.
And if the department was unsatisfied with those directions, it could appeal the decision, couldn't it?
Well, it could appeal the decision, full stop, yes.
Yes, including if it was contrary to
Yeah,
law.
including the directions.
But if it didn't appeal the decision, it was bound to give effect to the directions, wasn't it?
That's correct, yes.
Legally bound, correct?
Yeah, that's right.
And also, if it considered the decision was legally incorrect, the appropriate thing for the department to do was appeal, correct?
Potentially in consultation with the Department of Social Services, yes.
If the department, okay, just to be clear, when you say in consultation with the Department of Social Services, are you referring to a situation where the Department of Social Services believes it to be unlawful?
Yes.
That is, the Department of Social Services reaches a conclusion that there is an error of law in the AAT's decision.
Well, it's, that it's not the correct and preferable decision. It's an administrative review, merits review. So there was a process by which if DHS formed a view that an AAT Tier 1 decision should be appealed, it was required to consult with the legal team in the Department of Social Services.
If it was considered that there was an error of law affecting this decision, then surely the appropriate thing to do was to appeal it, correct?
I'm sure that there's an error of law. It's that the decision reflects that AAT Tier 1, Mr. Carney, or Professor Carney, sorry, suggested that the debts shouldn't have been calculated in the manner in which they were, and has remitted it, obviously with these directions. And the consideration of whether or not to appeal fell into the department's processes that we had at the time to consider whether or not to appeal.
And the basis upon which Mr. Carney had found that the debt had been not properly calculated was because he formed the view that it was based on averaging, and averaging was not a lawful basis to calculate an entitlement, correct?
If the information had not been able to be obtained from, or hadn't been obtained from the applicant, yes.
Well, in any event, he concluded, did he not, and we can go to the detail of the decision if necessary, but he concluded that averaging is not a lawful basis to calculate a debt, didn't he?
That was Professor Carney's finding, and again, I can't point to the exact provision, but in this bundle, we also have a decision where averaging for part of a debt was accepted because information wasn't available, other information wasn't available to the department. So, yes, we have Professor Carney's decision here indicating that averaging is inconsistent with the Social Security Act, but in other decisions around this time, we also have the tribunal indicating that it was lawful.
Sure, and that would be a very good reason to appeal the decision, wouldn't it, to get consistency?
It's one of many principles that were considered in whether or not to appeal.
And to get a definitive legal view in the face of conflicting AAT decisions about the lawfulness of averaging, correct?
Potentially, yes.
Can the witness please be shown Exhibit 3473, which should be Doc ID CTH 3039.0021.2405. Mr. Brazel, it should be tab 15 of your small bundle, the AAT decisions bundle.
Yes.
Now, again, there's reductions, particularly having regard to the need to maintain confidentiality on the document, but I'm just going to ask you about the email at the top of the email chain that appears in that document, which is an email from someone called Aaron Barrell to yourself, CCing Brian Sparks, dated the 28th of May 2017.
Yes.
And it says, "Dear Damien, I attach the redacted AFAR." See that?
Yes. Yes.
What was an AFAR?
That is advice for further administrative review.
So the standard term to describe an advice on whether or not to appeal a Tier 1 AAT decision.
That's correct, yes.
And that advice was invariably provided by members of your team at that time.
That's correct.
And do you accept that the AFAR that appears to be attached to this email is the AFAR relating to the same decision that we've been discussing?
Yes.
Thank you. So you would have seen the AFAR
Yes.
and reviewed it on or about this date, that is the 28th of March 2017?
Correct.
Okay. Well, can we go to Exhibit 3483, Doc ID CTH.0010.0001.0020?
And you
That
going to
should
give
be
any guidance where we might find that?
Tab 26 of the AAT decisions bundle, Commissioner.
Thank you.
No, I'm sorry. It'll be 27.
24.
Oh, everyone else is 24. tab 24 of your bundle, Commissioner, and Mr. Brazel's. Have you got that, Mr. Brazel?
Yes, I do.
Thank you. And you agree that is the AFAR that's attached to the email that we've just discussed,
Yes, it is.
relating to the decision we've been discussing?
That's correct.
And if we go to the second last page, section header determination, we call that out. You can see the checkbox, the matter does not involve an error of law or manifest error of fact, is checked. And you accept that the person providing this AFAR, Mr. Barrell, and you can see his name on the last page of the document, being the person, and also being the person who forwarded you the AFAR,
Yes.
a seconded lawyer in your branch,
Yes.
has concluded that there was no error of law in the decision that we've been discussing.
Yes.
And therefore, he agreed with the conclusions of law reached in the decision of Mr. Carney that we've been discussing, correct?
Yes.
Including that calculating social and security entitlement based on averaging is unlawful.
Yes. And yes. Sorry.
And so, as of the date of this AFR, the team you were responsible for had formed the view that it was unlawful to calculate social security entitlements using averaging, correct?
No, I can't agree with that statement. No.
Did you disagree with Mr. Barrell's conclusion?
No, I did not.
So if you didn't disagree with his conclusion, you accepted as of the date that this AFR was provided to you that it was unlawful to calculate social security entitlements using averaging, correct?
That is, I certainly see the logic of what you're saying, Council, yes.
You agree with my proposition?
Yes, I do, with your proposition, yes.
Having formed that view, after reviewing this AFAR, did you communicate it to any other lawyer within the Department of Human Services?
The process by which these AFARs were conducted relied on members of my team. So there were certain practice directors which dealt with areas of law, for example, child support or debts. And so certainly this AFR had come to me following that process. I can't recall specifically what steps I took with this AFR. I forwarded it. Oh, sorry. I was just checking the email. But I recall, I'm pretty sure yes, I forwarded it to Ms. Bundy, as you indicated, on the 27th of March. And I would likely have perhaps consulted with colleagues in the program advice and privacy branch, given it related to issues of interpretation of, or the issue of averaging.
Well, it would have been, it involved a conclusion of law that a fundamental aspect of the Robodebt scheme, which had been the subject of substantial media attention, was unlawful, didn't it?
Yes, and I was well aware of the media attention, yes.
So surely it would have been imperative from that point to draw that to the attention of, firstly, Miss Mussolino.
Yes.
Did you?
I don't know. I don't recall, but my usual practice would have been to do so, yes.
Can you think of any reason why you wouldn't have?
No, and that's yes, that's the point I'm making, yes. And it perhaps would have also come up in discussions with Mr. Stipniks as well.
Right. And are you aware that notwithstanding this decision, the department continued to employ the practice of averaging in its Robodebt scheme?
At this stage, I'm not sure. I know there were, not that I was involved, but I knew there were changes being made to the scheme and how it was administered. But on the point of averaging, and again, I can't recall specifically, but I know, or I recall I had some general discussions with Mr. Stipniks in the program advice team about this, and understood from him that the process was lawful.
That is, he told you that the AAT had got it wrong. Is that right?
I'm not sure he said it in those words, but that was the position being taken, yes.
And the department was thereby perfectly entitled to disregard the decision of the AAT. Is that right?
It didn't disregard the decision, it implemented the decision.
Well, disregarded the conclusion of law made by the AAT. Didn't it?
I don't think it disregarded it. This was one of several cases where averaging was being, I guess, challenged by the department. By the AAT Tier 1.
As a lawyer that... sorry, I beg your pardon.
Sorry, no, continue, Councillor, sorry.
You sure there wasn't anything further you wanted to say?
No, it's fine.
You, as a lawyer that had been in government practice for a number of years by that stage, you would be well and truly familiar with the Commonwealth's model litigant obligations, correct?
Yes.
Right. Did you have a view about whether it's consistent with Commonwealth's model litigant obligations to decline to appeal a decision of the AAT involving a determination of law that it disagrees with, and then proceed to continue a process which in that decision the AAT has concluded is unlawful?
I'm not sure I turn my mind to that point, as you phrased it there, Council. We always seek to conduct ourselves in accordance with model litigant rules. And this issue is being agitated in many forums, as you mentioned before, in the media and the like as well. I was also responsible for FOI in the department at the time. There was an ongoing ombudsman report into this area as well. And so I can't recall exactly what was on my mind at that time, but I would suggest that there are a lot of moving parts in a lot of areas of the department considering the scheme at that time. And as I said, I know there was some changes being made to the scheme. But as to where, I can't recall whether that went to this issue of averaging at that time. Sorry.
Would you agree with me that it's plainly contrary to the obligations of the Commonwealth as a model litigant to continue with a process which an administrative tribunal has concluded is unlawful without any appeal by the Commonwealth against that decision in circumstances where its own internal advice concludes that decision involved no error of law?
I'm not sure I agree with that proposition entirely, in that I can see where you're suggesting that this was one case of the AET, perhaps, and it was in this series of cases the only one that had, I guess, given any very detailed reasonings as to why the decision was made. And looking back and with hindsight, perhaps I didn't turn my mind to the AFAR, noting, and I'm not, I guess, trying to absolve myself. It had been prepared and cleared and then provided to me. And at that time, hadn't, I guess, appreciated the point you raised earlier in terms of the potential error of law that the decision carried.
Do you recall Australian Institute of Administrative Lawyers conference in July 2017 at which Barrister Peter Hanks presented a paper commenting on the lawfulness of averaging?
No, I don't, sorry.
You don't recall any discussions among members of the department about that paper?
No. What stage of 2017 was that? Sorry.
July 2017.
At that stage, I moved out, and I could have been at the Australian Public Service Commission by that stage.
Okay.
So sorry, I might not have realised that was going on.
Look, just while we've got that document, can I just ask you this? Under determination, the second point is the matter does not involve an error of law or manifest error of fact. So, as we've discussed, that settles that the writer didn't consider that Mr. Carney was wrong in concluding that ATO data on its own could not establish a debt. So how do you get to the next point, which is that it doesn't involve an important legal or policy principle, given that you had a department which was busy using this on a regular basis in a way that it hadn't done before? How could you reach the next conclusion?
Commissioner, in fairness to the witness, it's not his document. You've asked him whether he would reach this conclusion.
Well, presumably, you shared the conclusions in it, or did you not? Did you think about how that conclusion could be reached consistently?
Well, that conclusion, or I guess the results of the AFR Commissioner would be shared with the appeals branch and the decision implemented. And I know there are some further documents in the AAT bundle discussing the implementation of that decision, and given the direction that ATO data could not be provided, and there's some discussion around how the decision can be properly implemented without averaging being available, because there was a period of time relevant to this case where there were no payslips or other evidence available apart from the evidence of the ATO. And so in the absence, by withdrawing that ATO evidence, essentially the department, because of the direction, was unable to, I don't want to say, it was able to implement the decision, but only to a certain point, because it basically wasn't able then to deal with that period of time where there was no further information available because the department was excluded from using the ATO data.
We'll get to that.
Sorry, just let me have a little longer. You may have missed my point, which is if you accept that the decision is right on the law, that ATO data on its own cannot provide a secure legal basis for finding an overpayment, how could you not regard it, and I'm speaking with the general you, how could you not regard it as involving an important legal or policy principle, because this was how the department was actually functioning on these OCI matters?
Yeah, looking at it now, Commissioner, I agree with your proposition there. Yes.
All right, thank you.
Thank you, Commissioner. I think before the Commissioner's second question, Mr. Brazel, and we'll get to the email chain shortly about difficulties which the department perceived in implementing this decision. But I think you made the point that one of the difficulties which the department had with this decision was that it was of the view that it couldn't perform its function if it was precluded from averaging. Is that what you were saying before? That is,
yeah, for a certain period of time where there was no other evidence available to it.
Doesn't that self-evidently indicate that there was an important legal or policy principle raised by this case, which is whether or not the department could rely on averaging in circumstances where the department considered it couldn't do its function without averaging?
Yes, I agree with that, Councillor.
Okay. That document can be taken down. Could the witness please be shown Exhibit 3485, Doc ID CTH.0010.0002.0234, which should be tab 28 of the AAT cases bundle, I think. Sorry, 26. 26, I beg your pardon. You see that's an email chain concluding with an email from Mr. Barrell on the 2nd of June 2017.
Yes, Councillor.
Go to the last email in that chain. Sorry, yes, the earliest email in that chain, which is on the second last page. Now, do you accept that this chain is talking about the implementation of the AAT decision that we've been discussing?
Yes, and I also, just for clarity, I note it was after I'd ceased acting in this role.
Ah, okay.
Which was on the 21st of May.
I see. Well, I won't suggest you're responsible for what follows then. Mr. Brazel, but there are questions that I would like to usefully ask you.
Certainly.
Thank you. So the start of this chain is an email from someone called Kathy Keary, dated the 30th of May 2017. Do you agree with
Yes.
that? And
Yeah.
she says, I'm doing an AAT implementation where the AAT has requested we obtain income verification from 4 employers in order to recalculate the debt.
Yes.
And an AAT implementation, is that the process whereby someone from the department reconsiders the decision after it's been remitted to the tribunal? Sorry, from the tribunal.
Yes. So, I mean, that wasn't an area I was directly involved in, but yes, a decision would need to be implemented, and if it was remitted, the decision's getting remade, and on this occasion, in accordance with the directions which we had discussed earlier.
And then the next email on the chain on the previous page should be an email from Mr. Barrell, dated the 30th of May 2017. If we call that out, please. And it refers to the earlier email, noting
Yes.
that apparently Ms. Keary has been unable to obtain income verification from one of the applicant's employers, such as to substantiate the debt in the matter contemplated by the tribunal.
Yes.
And the question is there a process we follow in these instances? On the face of the tribunal decision, it appears to me that if we cannot base the debt on salary records, the debts are not recoverable. Would we then write off the debt? Agree with that? That's what it
Yes.
says. Okay. Then we can go to the next email on the chain, and it spans 2 pages. If we could call out the full email from Mr. Sparks, dated the 30th of May 2017. Who is Mr. Sparks, Mr. Brazel?
Mr. Sparks he headed up the Tasmania office. So he was I believe, a deputy general counsel level lawyer based in Hobart. I think at a small office there from memory. And Mr. Sparks was also what we call the practice director in the area of debts.
Okay. And to whom did he report starting with when you were in your role in Foyle, did he report to you?
Yes, it was, yes.
And would he then have reported to your successor after you left that role?
That's correct.
Okay, thank you. Now, have you read this email, Mr. Brazel?
Yes, yes.
Without going through it in chapter and verse, do you agree that it is explicit advice by Mr. Sparks to act contrary to the direction of the AAT by proceeding to average on the basis that further evidence can't be obtained?
Sorry, Counsel, I lost you mid-sentence there, Counsel. Can you repeat that, please?
Okay, perhaps I should break it down in steps. So this is an email responding to a question about what to do in circumstances where, after the tribunal has remitted the matter, on the basis that calculating the debt based on averaging is unlawful, and further attempts have been made to get evidence from employers, and those attempts have been unsuccessful.
Yes.
And notwithstanding the decision and direction of the AAT that we've discussed, Mr. Sparks explicitly recommends that averaging be applied in those circumstances. in that case?
I mean, yeah, that seems clear on the face of what is written there, yes.
He cheerfully says, regardless of what the AAT1 said in this instance, and he makes a reference to cases where AAT1 has sensibly considered the law, so one draws the inference he thought they just weren't sensible.
I know what you're saying there, Commissioner. Yes. I don't necessarily agree with it, but that's what you're saying.
Do you agree with me that it is explicit advice from a lawyer recommending that the department act contrary to a direction of the AAT?
I mean, that's I think one interpretation. I obviously can't get into Mr. Sparks's mind here.
But my question is about the effect of what his advice is, having regard
Yes.
to the directions.
So yes, and it was the I guess the direction that was provided in that decision, which I guess at this time was seen as I guess the limiting factor in this specific case.
Which really illustrates the point. If the direction produced difficulties for the department and the department considered it to be wrong in law, then it should be appealing it. Correct?
Potentially, counsel, yes.
It's not open to the department simply to say, well, we disagree with the decision, so we'll just ignore it.
No, that's not an option.
In your time in the Department of Human Services, did you ever encounter a situation where Department of Human Services gave explicit advice recommending actions contrary to a direction of the AAT?
Not that I recall, no.
Is this the first occasion you've ever seen of that occurring?
Well, yes, and I know I've only seen this as part of this bundle.
Yes, and as I said earlier, I'm not suggesting you're responsible for this. It's after you...
Yes. No, yes, appreciate that.
But I'm just trying to ascertain whether this is or was a cultural problem within the department at the time. And am I understanding your evidence that this is, to your knowledge, the first time that you've ever seen it occur?
Yes.
All right, thank you. If we could go to the first page in the bundle and call out the email at the bottom of the first page. So that should be the page with the last four digits, 0234. It's an email from the officer who commenced the query at the start of this chain on the 2nd of June 2017. Do you accept that, Mr. Brazel?
Yes.
And do you accept that the effect of that email is Mr. Sparks' recommendation was accepted and the debt was recalculated in accordance with his recommendation?
That appears to be the case.
Thank you. Commissioner, that's the evidence of the witness.
Yes, Ms Hogendorf.
Could I have, I'm sorry I don't have the exhibit number, CTH 0010 0001 0020. It's the AFAR concerning dated, I'm not sure if it has a date, 24 March 2017. Mr. Brazel, just looking, if you could just go, if the operator go to the last page of that document. Mr. Brazel, at the bottom of this document and in the bottom of the, similarly so in respect of the documents of this nature in the bundle, it has this under the prepared by details, it then has a section cleared by, what looks like an automated field, choose title, click to enter date.
Mm-hmm. Yes.
Can you assist the Commission at all in respect of that aspect of that document?
In relation to these debt matters, that would in the usual course have gone to the practice director for debts.
And in the period in which you were in the role, appreciating that you finished in the role on 21 May 2017, do you know who that was?
That was Mr. Sparks, who we have referred to earlier.
All right. I don't have any other questions.
Thank you.
Sorry, Commissioner, I've just been handed a note. Can I briefly just take the instruction from my solicitor?
All right.
Junior. I'm sorry, Commissioner, this doesn't relate to this witness. May the witness be excused.
Yes, thanks for your time, Mr. Brazel. You're excused.
Thank you, Commissioner.
Now, we can end that link, thank you. It is 10 to 1. I'm wondering whether we might come back at 10 to 2 rather than try to start somebody. But Mr. Gregory, you're here. Who have you got? Sorry? Okay, and is he on video when he...
Everyone is in person.
Oh, okay.
There are 4 witnesses.
All right. What's your preference, to start now or to...
10 to 2.
10 to 2. All
Commissioner,
right.
just in respect of the 4 witnesses that are listed now for this afternoon, I've communicated to my friends, or sought to communicate to my friends, that Mr. Grinsell-Jones is not available on Friday. So if we can ensure that he can be taken today.
Okay, bear that in mind. Thank you. 10 to 2.
All rise. The Commission stands adjourned until 1:50 p.m. Royal Commission is now in session. Please be seated.
Commissioner, before the lunch and adjournment, I told you Mr Grinsell-Jones wasn't available Friday. I'm also instructed Mr de Burgh is not available Friday, but I'm assured by the Senior Counsel assisting that he will finish both of those witnesses today. That's his endeavour.
Thank you.
Thank you, Commissioner. Can I attend to one matter of housekeeping from this morning? It's for the record, really. The Exhibit 3482 was referred to with an incorrect document ID number. The correct document ID number is CTH.3761.0001.0223_R. It is the decision of Professor Carney of 8 March 2017.
Thank you.
Commissioner, the next witness is Robert Hurman.
Mr Hurman, will you take an oath or an affirmation?
An affirmation.
All right. If you'd stand up and that will be administered.
Your response is, I do. You solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you. Take a seat. Yes, Mr Gregory.
Thank you, Commissioner. Mr Hurman, can you tell the Commission your full name, please,
Robert Alexander Hurman.
and your current occupation?
I'm a director within the Department of Health and Aged Care.
And your professional qualifications?
I have a Bachelor of Applied Science in Human Movement Studies and a postgraduate diploma in health promotion.
You were served with a notice to give evidence NTG-0140 dated 21 December 2022 and produced an updated statement in response dated 16 January 2023.
That's correct.
Commissioner, on the draft exhibit list, it would be convenient if I tendered the exhibits relating to Mr de Burgh, Mr Grinsell-Jones, Mr Hurman and Ms Richards. They are numbered in draft 3589 through to 3814.
Yes. The documents from 3589 to 3814 are admitted as exhibits with the numbers in the exhibit list. Thank you.
Mr Hurman, in January 2016, you were employed in the Department of Social Services.
Do you mean 2017?
Sorry, 2017, I do.
Yes, I was.
And you became aware on about the 11th of January 2017 that the Ombudsman had commenced its own motion investigation into the online compliance intervention program carried out by the Department of Human Services.
Yes.
And when you were notified of that, you received a copy of the letter from the Ombudsman to the Secretary of DSS, Mr Finn Pratt.
Yes.
And it set out in broad terms the scope of the investigation which the Ombudsman proposed to undertake.
Yes.
And the scope of that investigation included adherence to relevant legislative requirements and accuracy of debts being raised by the platform.
Yes.
You were ultimately involved in the drafting of the letter from Mr Pratt to the Ombudsman in respect of the draft report of the Ombudsman.
Yes.
And that drafting involved a number of versions and revisions.
Yes.
And the final version of that document, I'll have it brought up. It is DSS.5/0003.001.0715 behind tab 162 in the third volume. Exhibit 3767. I take it you have the hard copy of the document there before you, Mr. Hurman?
Yep.
While that's being brought up, you will recall, and you can observe from the document in front of you, that Mr. Pratt's letter dated 4 April 2017 in the third paragraph said this: "The department is satisfied the system is operating in line with legislative requirements and there have been no changes to the way DHS assesses PAYG employment income." Yes, if the third paragraph could be called out. And the second part of that paragraph, sorry, the next paragraph, please. Affirmed that the Ombudsman acknowledged the system was accurately identifying and raising debts based on the information available to DHS. You see that?
Yeah, I can see that.
In respect of the first proposition, that the department was satisfied the system was operating in line with legislative requirements, you were aware of an advice from Ms Pulford in late 2014 to the contrary?
I'm aware of the 2014 advice I think you're referring to.
Yes.
Yep.
Which said that legislative change would be required to introduce a program which relied upon averaging to prove a debt.
I don't think it talked about legislative change, but I think it sort of talked about the averaging of income not being consistent with the legislation.
Right, well, you understood that to mean that averaging income over a period of time was not in conformity with the legislation which permitted the establishment of debt.
That is what the 2014 advice says, yes.
Yes, which is not that the system would operate in line with legislative requirements, is it?
No.
No, it's precisely the opposite of that, isn't it?
There was subsequent advice.
I'm talking about the 2014 advice. It was precisely the contrary of what was represented in that first sentence.
Yes.
All right. The second line indicates there have been no changes to the way in which DHS assesses PAYG employment income. You knew from your role in the Ombudsman, in responding to the Ombudsman investigation, that was untrue?
I'm not sure about that. I'm not sure that I did know that.
Well, what did the OCI program do to your knowledge in respect of PAYG employment income?
It calculated a debt for a person based on the information that it received from the ATO about a person's income. I guess I'm not aware that was a change necessarily.
You weren't aware that was a change to the process of calculating debts?
So, I mean, I think I've seen in material here that there is statements that say that it has been used as a process as a last resort previously to OCI.
Yes, but OCI didn't use it as a last resort, did it?
I think it was my understanding that it did.
In how many percentage of cases was it applied then, if that was your understanding?
I don't know the answer to that question.
And where did you get that understanding from, that it remained a last resort?
I think from the Department of Human Services and advice within the department.
Who in particular?
I don't recall. That's a very long time ago, sorry.
Well, it was a significant representation to make to the Ombudsman, wasn't it? That there had been no change to the way DHS assesses PAYG employment income.
Yes.
You'd want to be sure about the correctness of the representation to the Ombudsman.
Yes.
And you're not now able to identify where the information came from in respect of that representation.
Yeah, I'm sorry, I can't recall from that period of time.
Based on what you've just said, a more accurate way to say, represent your understanding would be OCI continues to apply income averaging to raise debts as a last resort, as the department has always done.
Yes, I guess so, yes.
All right. In terms of the final sentence, the system is accurately identifying and raising debts based on information available to DHS. Is that a representation in respect of the application of average PAYG data?
I imagine so, yes.
Well, you knew that to be false then, didn't you?
I think I know it to be false now. I'm unclear of...
How do you know it to be false now, but not then?
I don't know. I've been looking at the documents and I mean, I think it's clear from the 2014 advice that the income averaging isn't in line with the legislation.
That's one issue. This is accuracy. And I'm suggesting to you that averaged income does not accurately identify or raise debts because it's averaged. That is, it doesn't accurately reflect earned income.
Okay.
You accept that?
I accept it doesn't accurately reflect earned income over the period, yes.
And you understand that a debt is raised where someone receives more than they are entitled to based on what they actually earned.
Yes.
So how do you say that statement was true if it referred to PAYG average data?
I think that relies on the 2017 advice that talks about, in the absence of other information, the Secretary making a decision based on the information available to him or her.
Yes, no doubt a secretary made a decision based on information available to them, but how was it accurate, given what you've just said about the difficulty with averaged income?
I mean, I think that sentence is talking to the calculation of the calculation step, based on the information that's available.
What calculation step? The calculation of debt?
Sorry, can you repeat the question?
What calculation step are you referring to?
Like once the income has been apportioned, the calculation from that point.
That is, the maths were correct once the average was calculated?
I think so.
Well, that's at least a misleading statement then, isn't it, if it's not false? Because it conveys that, in context, it conveys that debts are being accurately calculated.
I mean, this is talking about a statement that the Ombudsman has made, isn't it?
This is a statement in a letter by FinPrat in which you were involved in the drafting of,
Yep.
which, as it says, notes what is contained in the draft Ombudsman's report.
Yep.
And I'm suggesting to you that it is not true to say that the system is accurately identifying and raising debts based on the information available to DHS.
The revised version of the report include improvements which acknowledge that the system is accurately identifying and raising debts based on the information available to DHS. Sorry, can you repeat the question?
It's not true to say that the system was accurately identifying and raising debts based on the information available to DHS, was it?
It's not raising debts consistent with the income over the period. Yes. I don't believe
you
that was
splitting
intended
hairs
to
here?
be a... No, I'm just trying to... I probably drafted
It's a very
this...
straightforward statement, Mr. Hurman. I'm suggesting to you it's untrue. What's your position?
Well, my reading of that sentence is that it's talking about what the report itself says.
We can agree so far. Is it true?
No, not in terms of the 2014 advice, the calculating based on the fortnight in which the income was earned.
Right. But it's not true as a matter of simple mathematics either, is it?
Sorry, I thought I agreed with you.
Okay. Having agreed with me that that statement is not true, why were you involved in drafting a letter which gave the impression that the department agreed with the statement?
I'm not sure. I think that is just trying to acknowledge a point made within the Ombudsman's report itself.
But what's the purpose of writing it there? You could have written any number of things which you acknowledged about a draft report, but this paragraph deals with an assertion that the scheme complies with legislative requirements, an assertion that it does not involve the way in which DHS assesses PAYG income, and the specific noting that the system accurately identifies and raises debts. There is a clear purpose to this paragraph, isn't there, Mr. Hurman?
What's that?
It projects a defence of the scheme which was untrue in each respect.
I accept that it is a defensive sentence, yes.
A defensive paragraph,
Yes.
and in each respect, the defence was factually untrue or legally untrue insofar as it related to legislative requirements.
Yes.
Right. My question then is, why were you involved in the drafting of a letter in response to a public report which defended OCI from the perspective of DSS when you knew those things were untrue?
So, I mean, I can't really recall my motivations from the time because it was 6 years ago, but, you know, in so far as the 2017 advice talks about the Secretary making a decision based on the available information, I think it reflects that.
Was any pressure placed upon you by anyone in the department to make untrue representations to the Ombudsman under the hand of Secretary Finn Pratt, AO PSM?
No, not that I recall, no.
You did this of your own volition?
I'm sure I would have drafted it or asked someone to draft it, yes. And I cleared it and accept responsibility for it.
And you say that there was no pressure on you within the department to write a defensive response?
No.
Then why would you do it?
I don't know, I thought it was a fairly standard kind of letter to write in the circumstances to acknowledge the more positive aspects of the report. And our response was, yeah, I mean, I can't recall any pressure at all.
Can't recall any discussion about the need to defend the program?
No, it's a long time ago. I don't think...
Well, surely you would remember it if it occurred.
That you're probably right, yes. Yep.
You would have realised that someone in the department was pressuring you to write something which you knew to be untrue.
Yes.
And you say you can't recall that?
I can't recall that, so yeah, probably did.
You would accept that making untrue representations in a letter under the hand of the Secretary to an Ombudsman would very strongly conflict with the obligations on you under the Code of Conduct?
Yes.
Well, that would be a very strong reason not to do it, wouldn't it?
Yes.
But you still did.
I mean, I really don't think that I was presenting something that I thought to be untrue.
How could you maintain that the system was accurately identifying and raising debts, given your evidence here today about the role played by averaged income not being an accurate reflection of actual income?
Because we had separate advice on using the use of average income in circumstances that are more specific to the OCI, the Robodebt arrangements.
You're saying the 2017 advice from Ms Pulford was more specific than the 2014 advice in respect of OCI?
Yes.
Have you read them recently?
Yeah, yep.
Do you maintain that?
That they are more, specific to OCI.
Well, do you maintain the 2017 advice was more specific to OCI than the 2014 advice?
Yeah, I think so, yes.
What about the general caveats at the start of the advice?
Can you remind me what they were?
We'll come to them in detail. Perhaps I should start chronologically to identify other things that occurred. I take you to Exhibit 3602. It is tab 11A in your bundle. You have it there?
Sorry,
DSS.5031.0001.0001. It's on the screen Mr. Hurman.
Yep, that's good, thanks.
You can see that at the bottom of the page there is an email from Simon Jordan to Mark Jones, copying in Ms Pulford, 18 December 2014, which contains what follows as the 2014 advice.
Okay.
And you've had the opportunity to read that recently?
The 2014 advice?
Yes?
Yes.
All right. And if we go to the second page, so there's no mistake about it, you can see that the proposal to smooth the debt over an annual or other defined period, this is the last paragraph of the substantive advice, may not be consistent with legislative framework described above. In order to correctly determine a relevant debt, it would be necessary to consider the amount of income received in each relevant fortnight in order to apply the income test to that fortnight. You see that?
Yes, I do, yep.
All right. And that reflected what you said here today about your understanding of the accurate calculation of debts according to the legislation.
Yes.
Right. And we can see, if we go back to page 1, that Mr Grinsell-Jones received this advice from Ms Metz, and then it was sent to Ms Halbert, and then it came to Ms McGurk and yourself. You see that? You had this advice on the 12th of January 2017.
Yes, I can see that.
2 days after you became aware of the Ombudsman's investigation.
Yes.
No doubt read it?
I have read it, yes.
No, you read it at the time.
Most probably.
Well, you were assigned responsibility for the response to the Ombudsman's investigation along with Ms McGurk, weren't you?
Yes.
And that was why you received it.
Yes.
So you would have read it at the time.
Yes.
It was part of your job to read it.
Yes.
You understood it,
Yes.
and you understood the conclusion.
Yes.
And it would have become immediately apparent to you at that point that for over 18 months, OCI, or its predecessor, the manual system, was operating contrary to advice that had been given in December 2014.
I'm not sure whether I made that realisation, but
What other realisation could you have come to, Mr Hurman?
I'm not sure.
There is no other realisation available, is there?
Okay.
Well, do you accept that or not?
Yes.
And it would have been front of your mind because you appreciated that 2 of the matters identified by the Ombudsman in respect of its own motion investigation were those that I identified to you earlier. Adherence to relative legislative requirements and the accuracy of debts raised on the platform.
Yep.
And here was your first advice that you had received, which indicated it did not adhere to relevant legislative requirements and was likely to raise inaccurate debts.
I'm not sure if that was the first advice I received or not.
Did you get one before the 12th of January?
I'm not sure when I received the 2017 advice. I was also on leave for a fair portion of that January.
You received the 2017 advice on 2 February 2016, I suggest.
Okay.
Because in fact it was drafted on the 24th of January, 2017. It was drafted on the 24th of January 2017, 12 days after this.
Okay.
You seem surprised by that.
Yeah.
Have you reviewed the documents in preparation for your evidence?
Yes, I should have paid more attention to the specific dates I received things and when they were drafted.
Commissioner, just conscious that Mr Hurman was referring to paragraph 20, which specifies his leave dates.
I'll come to that, Commissioner.
Thank you.
So this was the first advice you received, given the other one wasn't drafted until 12 days later?
That makes absolute sense, yes.
Yes. And having received it, you would have appreciated that the program was operating contrary to the 2014 advice.
Yes.
and that it was likely to raise inaccurate debts.
Yes.
All right. Now, the departmental meetings occurred in respect of the Ombudsman on 16 and 18 January, but you were on leave for those dates
That's correct.
and you didn't attend those meetings.
That's correct.
I take you to Exhibit 3612 DSS.5113.0001.0051. It's behind tab 22. This is an email you prepared on the 2nd of February 2017 with a list of proposed dot points. You can see that.
Yes.
And we can see the first paragraph is Online Compliance Intervention, OCI.
Yes.
And the first 3 dot points relate to that topic. Now, as at this date, 2 February 2017, you appreciated the very significant criticism of the scheme in the media. It had been going for about 2 months, from December through January.
Okay, yes.
You knew that your minister and the Minister of DHS were making public statements in defence of the scheme.
Yes.
You were aware that the department's position, therefore, was consistent with its minister's statements,
I would have been.
which was to defend the lawfulness and accuracy of the scheme.
I'm taking your word for it. I don't have specific recollection of minister statements and that sort of thing, but yeah.
Right. We go to the first dot point. You say senior departmental staff were given a run-through of the Human Services Online Compliance Program system at TOP on Wednesday, 18 January 2017, and are comfortable that the current process is lawful and clear. You see that?
Yep.
How did you know that?
I thought I received it in other documentation at the time.
What was the nature of that document?
Perhaps an earlier version of this. I'm not sure.
Did someone else draft this document?
No, I would have drafted this document, but it is likely something that built from previous versions.
In your preparation to give evidence, have you identified an earlier version?
I don't think so.
Right. You weren't present at the meeting on 18 January
No, I
2017.
wasn't, no.
You were on leave,
That's right.
and that walkthrough occurred 6 days after you were provided with a copy of the 2014 advice,
Okay, yep.
and 6 days before Ms Pulford generated the 2017 advice.
Okay.
So how could you be satisfied, or how could you represent that senior departmental staff were comfortable the current process was both lawful and clear in circumstances where there had been no contrary advice and where the advice indicated the debts were likely to be raised which didn't exist?
I'm unsure.
Are you representing a factual position here or a departmental defensive line?
I had thought that this was based on the 2017 advice, so I was surprised to hear that came later.
Yes,
Yeah.
because it couldn't be based on the 2017 advice, could it?
Not if it came later, no.
And so it must have been based on either a defensive departmental policy line in the face of the Ombudsman's investigation, consistent with the Minister's statements to the public, or it must have been based on something you were told about that meeting. Those are the only two options, aren't they?
Yes.
The people who attended that meeting were Ms McGurk, Ms Halbert and Ms Wilson, the Deputy Secretary. Did you speak to any of them about the extent of their satisfaction or comfort with the lawfulness and clarity of the program?
I don't recall.
Would you have done so?
I wouldn't have spoken to Ms Wilson. I may have spoken to Ms McGurk or Ms Halbert.
And so the options remain: you either spoke to Ms McGurk or Ms Halbert to obtain that information about the meeting you did not attend, or you adopted a defensive departmental line.
Yes.
And you can't.
Commissioner, my friend has already canvassed other alternatives in fairness to the witness, and particularly in circumstances where he's not separately represented. There is at least another potential source that he has raised in his own questions.
No, I've lost that, so do you want to be more explicit, or are you clear, Mr Gregory?
Not entirely.
Well, plainly, I don't wish to suggest the answer to the witness, so
No,
it may be that it's something I can deal with at the end.
All right, thank you.
Before you wrote that, Mr. Hurman, you were aware that the Prime Minister was interested in a report from your Minister, Minister Porter, and the DHS Minister, Mr Tudge, about an update on the online compliance intervention program?
I don't recall, but
If you turn to tab 15 in your bundle, Exhibit 3606, DSS.50001.002.2780.
so what tab?
15.
My numbers aren't matching up.
All right, it's on the screen.
Okay, thank you.
I think your name might have been redacted here. Do you recall receiving this email?
I don't recall receiving it, but it's likely that I would have.
And it would have informed your understanding of the political sensitivity of the topic which was in the media at that point in time.
Yes.
And it would have informed how you went about the response to the Ombudsman's investigation.
Not necessarily, no.
We go then to Exhibit 3613, DSS.5113.0001.0600. You can see that the email in the centre of the page is from Ms Pulford to Ms McGurk, 24 January 2017.
Yes.
And it contains what we have referred to as the 2017 advice.
Yes.
And at the top of the page, it was forwarded to you on Thursday, 2 February 2017.
Yes.
All right. Turn then to the topic about the introductory paragraph. You can see there, Ms Pulford reiterates, you've asked about whether using income averaging as a last resort to determine social security debt was lawful in circumstances where no other information about a person's circumstances are available. We are providing this advice on a general basis without details as to what information source is being used and for what period. We would appreciate your treating this advice on this general basis. You see that?
Yes.
You understood that to be a very significant qualification on the advice that followed?
Yes.
Understood that there appeared to be an obvious inconsistency between what followed and what you read on the 12th of January 2017 in respect of the 2014 advice.
Yes.
And you later came to ask Ms Pulford for a bridging paragraph about how she might explain the obvious inconsistency.
I think I called it a joining paragraph, but yes.
Yes. And that was for the purpose of providing the 2014 and 2017 advices to the Ombudsman,
That's right.
because they had specifically asked for it.
They had asked for advice in relation to the use of income averaging, yes.
And you always understood, didn't you, that the advice you received on 12 January 2017 from 2014 related to that topic?
To income averaging, yes.
Yes. That is, there would have been no reason for you to withhold it from the Ombudsman at any point in time.
I initially took the view that the 2014 advice wasn't in scope because I considered at the time that the request from the Ombudsman was more about income averaging as a last resort.
If we could go to Exhibit 3636, DSS.5018.0002.4233. This is a lengthy email trail, Mr Hurman, which reflects the conclusion you just came to, that the 2014 advice was not within the scope of the Ombudsman's request. Can we go, please, to page 4235? You'll see at the bottom the request from the Ombudsman represented by Ms McLeod.
I can see it, yes.
Yes. Ms McLeod indicated that the Ombudsman had identified an issue they need to raise with DSS, and it concerns the authority for averaging income across a full or part financial year where the dates of employment cannot be verified in order to recalculate a person's social security entitlement and therefore an overpayment requiring recovery. See that?
Mm-hmm.
If we go over to the next page. And you can read that to yourself. See, the request was in broad terms. Any legal advice has received about averaging income. You see that?
Yes, I can see that.
It wasn't confined to last resort propositions, was it?
No, but it mentions using average income as a last resort earlier on.
Well, DHS said that, but that's not what the Ombudsman asked for, was it?
Well, it does say immediately after that, we would like to understand more about the authority to do this.
Yes, as an introduction to the request, and the request was in broad terms and it wasn't confined to a last resort, was it?
Well, I initially took it to be about as a last resort, and that's the position that I initially took.
So having read the 2014 advice and the 2017 advice,
Yes.
you decided that it was the 2017 advice which ought to be given to the Ombudsman
Yes, because of the use of last resort.
in something DHS had said to the Ombudsman, not something that was requested,
Well,
or limitation requested by the Ombudsman.
In the introduction to we would like to understand more about the authority question.
What's the downside, in your mind, of providing the 2014 advice to the Ombudsman?
Yeah, I don't know. I mean, I think after this, there was further consultation with Legal Services branch, and ultimately, Mr. de Burgh and I accepted the position that both pieces of advice should be provided.
One of the downsides of providing the 2014 advice was that it indicated the scheme was operating outside the bounds of legislation, correct?
Yes, it does. But yeah, the 2017 advice deals more specifically with the last resort question.
All right. Having accepted then, after being told by legal services, particularly Mr Grinsell-Jones through Ms Pulford, that both should be supplied, you asked for the joining paragraph or the bridging paragraph to explain the obvious inconsistency.
Yes, to explain the differences, yes.
Well, inconsistency.
Yes.
Yes. And the upshot was between 21 and 22 February, yourself, Mr de Burgh and Mr Grinsell-Jones were all in the discussion about whether the 2014 advice should be provided to the Ombudsman, and that was copied, to your knowledge, to Ms Wilson at one point.
I'm not sure if I've seen anything copied to Ms Wilson previously.
I can take you to tab 52, DSS.5023.0002.2781, Exhibit 1372. You can see there the sequence of events which leads to you sending an email to Ms Hulbert and Mr de Burgh towards the top of the page. Kath, you may not be aware of this one. We are liaising with Legal's our response, and then at the top of the page you can see Ms Hulbert forwards it to Ms Wilson.
Yes, this is about the response that came in, yes.
The request for legal advice from the Ombudsman.
Yes, it would have the request from the Ombudsman down the bottom of that trail, yes.
Thank you. And could we go then to tab 53, DSS.5113.0001.0588. Exhibit 3639, thank you. You send an email to P&I Coordination and Mr de Burgh. You can see that, and the attachments are the 2014 and 2017 advices.
Yes.
And it is the draft response to the Ombudsman after you accept legal advice that both were within scope.
Yes.
And you make the distinction between the generation of an accurate debt amount on the basis of full information and the obligation by the Social Security law to take action to adjust a rate of Social Security payment despite not having full information to generate an accurate debt amount. You see that?
Yes.
And by your own words, you accept that making a decision to adjust a rate of Social Security despite not having full information would generate, not having the full information to generate an accurate debt amount was something which was acknowledged by you at the time. That is, the absence of full information wouldn't lead to the accurate debt generation.
Could you repeat that question?
Your draft letter tries to explain the inconsistency in the advices, but in doing so acknowledges that the absence of full information might not generate an accurate debt amount.
Yes, compared to if full information was available.
That's right.
Yep.
And you understand that if an accurate debt wasn't generated, that the scheme would be alleging debts which might not be owed by people.
Yes, I think that the 2017 advice goes to what to do if information is later provided.
Yes, let's not jump ahead.
Okay.
How did you consider that alleging and recovering debts from people which might not be owed could be lawful?
Based on the 2017 advice.
How did you consider then that it would be fair, even if it was lawful?
I don't have a response to that. I don't.
Well, it's grossly unfair, isn't it?
It's too. Yeah, I mean, I think that the position is that it was the person's responsibility to provide the information. But yes, I agree, it would create a debt that is inaccurate if full information had in fact been provided.
And it was therefore unfair for the department to try and recover it.
Yes.
You go on to say the advices are consistent, but address different levels of information to ground administrative decision-making by the Secretary. You see that?
Yes. Sorry. Yes. No. Sorry. Yes, I found it.
Are you leaving that, Mr. Grover?
Yes.
Well, I had a question. How could you possibly say the 2014 advice indicated the method of generating an accurate debt amount on the basis of full information? It was about averaged income and nothing else. There was nothing about full information in it. Well, we can go to it if you like.
I think that's the 2014 advice describes the process of basically it sets out the rate calculator step within the legislation. I think that's what that's trying to say.
Well, what's the full information?
The full information would be information on the person's income over the various periods.
But the advice was in response to a request to advise whether averaged ATO income could be the basis for raising a debt.
Yeah.
And it responded to that. So they were just talking about averaged ATO income. That's hardly full information, surely.
So sorry, this sentence, I think that the sentence is saying that the advice received in 2014 talks about the process of rate calculation under the Social Security law. Mm-hmm. Sorry, I'm just reading it out now.
Yeah, the 2014 advice actually talks about what the Act requires. That's a significant difference, it's true.
Yes, and it describes the method of generating an accurate debt on that basis.
On the basis of full information. So are you saying that the 2014 advice actually considers the Act and that's full information, and the 2017 one doesn't bother to consider it, so it's just skipped that vital point? Surely
I think
not.
the use of full information in the context of that sentence is referring to all of the income information about the person over the fortnightly periods.
Okay, so you're asserting that the 2014 advice was based on the position where full information about the person's income over the fortnight was available?
No. I'm saying that I think that sentence is referring to the description within the 2014 advice. The 2014 advice, it basically requires full information. It says that you need to make the decision based on the fortnightly income.
Sure.
And so I think that sentence is saying that the 2014 advice relates specifically to the calculation of debt when full information is available. And so the 2014 advice later comes to the conclusion that income averaging is not in line with the legislation.
The 2014 advice, I said to you already, was based on instructions which asked what the position was
Yeah.
as to averaging on the ATO data.
Yes.
So it was directed to that question and it said that that was not permissible.
Yes.
It wasn't directed to the question of, if you have full information about the person's income, is it okay? It didn't
That's
consider.
right. Yeah. Sorry, I might be misunderstanding.
Well, I don't understand you. I don't understand how you could refer to the 2014 advice as being concerned with the position where there was full information.
I mean, it indicates the method of generating an accurate debt amount on the basis of full information. I think it's just setting out the steps of calculating the debt.
It refers to the steps of calculating a debt in order to point out that averaging isn't consistent with it.
Yes.
Yeah, okay. All right. Is there anything else you want to say about it? Because what you say in that email makes no sense to me at all about 2014 advice being based on full information. So, but we may have explored it to the max. So here's your chance if you've got any better explanation.
Commissioner, perhaps the witness might be given an opportunity to read it in full again. He hasn't received or been given these documents before giving his evidence today.
This is the email again, or?
1372, yes, as I understand this document is.
Certainly.
Sorry, I'm confused about what's happening right now.
All right. I had asked you why you in that email drew a distinction between the 2014 advice and the 2017 advice, in that the latter related to the situation where there was, the 2014 advice related to the situation where there was full information. I asked you why you said the 2014 advice related to the situation where there was full information when it was about averaging based on ATO data as to income.
I think that sentence is just describing the 2014 advice, which includes a description of the method of calculating the debt based on full information.
I don't know if you want to pursue this, but
Mr. Hurman,
to you,
surely
Mr.
you
Brazel.
understood the 2014 advice dealt with the question of whether it was lawful to calculate a debt based on average income rather than actual earned income in any given fortnight.
Yes, yes,
Yes. That was the question to which the 2014 advice was directed.
yes,
And you're referring here to the basis of full information.
yes.
Full information is not averaged income, it is actual information about earned income, isn't it?
That's right.
Yes.
That's right. And
So, your statement that the 2014 advice relates to the process of rate calculation under the Social Security law and indicates the method of generating an accurate debt amount on the basis of full information,
yes,
which could not be averaged income.
no,
Right. That is, it is something less than full information.
yes,
And you're attributing the concept of full information to the 2014 advice in contrast to less than full information in respect of the 2017 advice.
sorry, could you say that one again?
You are attributing the concept of full information to the 2014 advice in contrast to less than full information in the 2017 advice. In this paragraph.
In the paragraph, I think what I was attempting to do, and I may not be explaining this very well, in coming to its conclusion, the 2014 advice describes how the rate of payment and debt is calculated, and that required a fortnightly piece of income. And I think that is what that sentence is trying to say is that the 2014 advice, it, does require the 2014 advice, in coming to that conclusion, describes the process of a fortnightly calculation based on full information.
As the lawful way to do it.
Yes.
Right. And what you're saying is that the inconsistent 2017 advice permits a calculation on averaged income as a last resort, lawfully.
Yes.
That's what you're saying.
Yes.
Was that the reason why you didn't want to give the 2014 advice initially?
No, I can't recall, but based on the email that I've put in here, I considered it to be out of scope.
That is, out of scope after Ms Pulford had said she thought it was in scope. That is, the author of both documents.
She provided the email and suggested that it should be included, yes.
That is, the author of both documents told you clearly that she considered both advices to be within scope.
I'm not sure if she was the author of the first document, but it certainly came from the same team that she worked in, yes.
It was second counselled by her.
Okay, yes.
Right. But you came to a different view and were only
Yes, and then
forced to reconsider it once she went to Mr Grinsell-Jones.
Well, I came to a different view. I put that view to my supervisor,
Mr de Burgh.
Mr de Burgh, that's right. Then we consulted again with Ms Pulford. I can only assume that he directed me to do that or asked me to do that. And then she has consulted with her branch manager and reiterated that they considered both pieces of advice should be provided.
And you realised at that point that if you did not provide both pieces of advice, you would be acting contrary to very recent legal advice within your own department.
I can't say what persuaded me at the time, but as I read the document, I think there is a note in what she gave back that said that you shouldn't read it down based on the earlier context, and that sounds very persuasive to me as to why it should have been provided.
Were you generally feeling at liberty to disregard Ms Pulford's view about what should be provided in terms of legal advice to the Ombudsman?
No, I mean...
Well, if we go then to the 23rd of February, the same date as this, later in the afternoon, the discussion which followed led to you drafting that response and attaching the 2014 and the 2017 advice to be sent to the Ombudsman.
Yeah, that's my recollection, is that we then drafted something with both pieces of advice.
And you learned later that afternoon that, in fact, despite what you had drafted in consultation with Mr de Burgh, only the 2017 advice was sent to the Ombudsman.
I did learn later. I wasn't sure whether it was the same day or not, but yes.
I suggest it was the same day. If we could have Exhibit 3642 brought up, DSS.5051.0001.0068. You've read that, Mr Hurman?
Yes.
All right, you can see that on later that same day, the message from the P&I coordination team at DSS sent to the Ombudsman a revised covering statement and only the 2017 advice.
Yeah, I can see that, yep.
For completeness, it was in this form. Exhibit 3643, DSS.5051.0001.0070. Which effectively extracts the content of Ms Pulford's advice to Ms McGurk of 24 January 2017, correct?
Yep.
And so when you received that email, or were copied into that email that afternoon, you appreciated that someone in DSS had changed the draft developed by you and Mr de Burgh based on the legal advice from the legal department through Ms Pulford that both had to be provided, correct?
I must have, yes.
You must have.
Yep.
That would have been a significant thing, given your conclusion that only one part of the picture was being sent to the Ombudsman.
Yeah, I don't recall that day, but I must have concluded, if I wasn't told in some other way, that someone had decided to only provide the 2017 advice, yes.
And that was done contrary to legal advice within the department,
I think
as you understood it?
the recommended approach was to provide both pieces of advice, yes.
It was contrary to the position that you accepted, that both were within scope?
Yes.
It was contrary to the draft letter that you sought to join two inconsistent advices?
Yes, the passage, yes, yep.
It must have come as an immense surprise to you that that happened somehow.
I don't recall. I probably wouldn't be that surprised that something that I had drafted was someone took a different view up the line.
But you were responsible for the DSS response to the Ombudsman's investigation together with Ms McGurk.
Well, I was responsible, and I guess everyone above me also was responsible.
What are you getting at here, Mr Hurman?
Just that we operate in a hierarchy, and while I have responsibility, all of my responsibilities also are the people above me also are responsible. And
What are you trying to say? Who changed it?
Well, I understand that Serena Wilson made a decision to change it, or the Deputy Secretary, based on another email that I think is part of my evidence. And yes, she sort of is higher in the chain than me within DSS.
You appreciated when you realised that Ms Wilson had changed the position from the department and provided only the 2017 advice, or given a direction to only provide the 2017 advice to the Ombudsman, that created a potentially misleading position of the department.
Yes.
Contrary to her obligations under the Code of Conduct?
I think she obviously took a different view, or may have taken a different view as to what was in scope.
What was what?
In scope.
In scope.
For the question.
Yes. But you can see from your position as being responsible for the response to the Ombudsman's investigation how that could create a misleading impression in the Ombudsman's mind about the DSS position, correct?
Sorry,
Yes.
could you say it again?
This had the potential to mislead the Ombudsman, didn't it, into thinking that DSS was always comfortable with the approach?
Yes. Yep.
Yes. What did you do about that potential misleading of the Ombudsman, Mr Hurman?
I don't think I did anything about that.
Why not?
Because that approach to provide the 2017 advice on its own had been made at a more senior level than me.
Does that mean that you have no duties under the Code of Conduct?
No.
Does it mean that you were prepared to ignore your duties under the Code of Conduct because the decision had been made at a higher level?
No, I guess I didn't think about it that way. I considered that my Deputy Secretary had made a decision and that was the decision that had been made.
You had been considering the position since 2 days earlier, the 21st, the 22nd, and had finally landed on the position that this was within scope. And it was now obvious to you that potentially misleading representation was being made by your department to the Ombudsman and you did nothing. Is that your evidence?
Well, I must have at least thought at some stage that it was potentially not in scope. So I may have been, I think it would be odd for me to not accept that someone else could have had a different view when I previously had had that different view myself.
It's contrary to the advice of your own department.
There are a lot of people within the department, and Ms Wilson was one of them at the time.
It was contrary to the advice of your own department. Surely that must have triggered some movement on your part.
It was contrary, sorry, I mean, I think that there were different views at different times.
Did you change your view because Ms Wilson had decided not to send it, or did you maintain your view?
I don't recall.
Were you concerned about the unfairness of the scheme with the nature of this defensive response to the Ombudsman?
I don't recall a concern in relation to that response.
We can go to Exhibit 1385, please. Tab 61, DSS.5051.0001.0119.
Commissioner, could I just indicate these early numbered exhibits, I should say, are documents which are read in my list and are all documents that the witness has not seen beforehand, may need additional time to review.
Okay, Mr Gregory?
If you do want time to review them, Mr Hurman, please say so. If we go to the bottom of the page, you see an email from Ms McLeod, Friday, 24 February 2017.
Yes.
So this is the day after, 3 days after the 2017 advice was provided in response to the previous request by the Ombudsman.
Yes.
It is on the Friday and we are now on the Monday. Ms McLeod gets to the point. On 20 January 2017, DHS provided our office with the attachment, which is an executive minute briefing the Minister for Social Services and Minister for Human Services dated 12 February 2015. On page 10 of the document it states, and you can read that for yourself over to the next page. You can see there that Ms McLeod makes no mistake about the breadth of the request for DSS legal advice. She asks for a copy of the advice from DSS about the legislative change that would be needed and any other notes, documents or emails that relate to this advice. Correct?
Yes.
Now, in preparing the response to this request, you didn't set about obtaining any other notes, documents or emails that related to the 2014 advice, did you?
Not that I'm aware of.
You didn't set about obtaining any other notes, documents or emails that related to the executive minute that was referred to there?
I don't recall.
If you had, you would have provided them, no doubt.
No doubt.
And you know
Well,
that
if
they
I had
weren't
located
provided.
some, yes.
Yes, you know that they weren't provided.
I know that they weren't provided, that's right.
Yes. Can you explain why you didn't engage with the Ombudsman and obtain other notes, documents or emails that related to the 2014 advice, despite the direct request?
No, I don't recall. Sorry.
Were you treating the Ombudsman with some disregard?
No.
You can see a pattern, I suggest, Mr Hurman, whereby the moment that the Ombudsman notifies DSS of its investigation and the scope of it, officers within DSS, including yourself, set about embarking upon a proactive defensive strategy which leads to the ultimate assertion in the letter by Mr Pratt to the Ombudsman that the scheme is lawful, that it calculates debts accurately and it hasn't changed the way debts are calculated.
Yes, I think there was, some of the material was provided on a defensive basis, I guess.
Yes, and additional advice was sought from Ms Pulford to get around or contravene the 2014 advice, I suggest, and you were aware of that?
I don't know that it was to get around anything.
I suggest you were reluctant to provide the 2014 advice to the Ombudsman, despite obviously knowing it.
Commissioner, I'm interrupting because the transcript doesn't appear to be transcribing this passage of evidence.
The audio's out. Okay, I'm told we should keep going. The audio is working and the transcript will catch up. But maybe we'll just wait to see the transcript catching up before we do anything. Okay, I'm told that you should be able to ask questions and have them recorded now, but there is that gap there where you'd asked a couple and they seem to have disappeared into the
Okay. Thank
labyrinth.
you, my learned friend. Mr de Burgh, I suggest to you that there
Hurman.
was a common understanding within DSS from the time that the notice of the Ombudsman's investigation was received to go on the front foot and defend the scheme as being both lawful and accurate in the raising of debts.
I don't recall a direction to be on the front foot in that way.
Did you have that understanding?
I don't recall that particular bias, if you like.
How do you explain Ms Wilson's intervention then to provide only the 2017 advice?
I wouldn't explain her intervention.
What impact did it have on your decision making?
I'm not sure it had already been, that question had been responded to. Do you mean for future decisions?
Yes.
I don't recall an impact on future decisions.
The document which was attached to this email to you and Mr de Burgh is described as .06 Minister Brief #2, and it was the executive minute. You agree?
It's a minute from the Department of Human Services.
I could have Exhibit 3646 brought up, DSS.5051.0001.0121. You'll recall receiving that at the time of Ms McLeod's second request for all advice and associated documents.
Yeah, I've seen it in the...
Yes? If we could go to page ending .0130. This was the passage to which Ms McLeod referred at the bottom of the page. Last dot point. You recall that?
Yeah.
And you appreciated when you received it that in fact no advice had been received from anyone in DSS and between the 2014 advice and the Ombudsman's indication of its own motion investigation.
Sorry, could you repeat the
There
question?
was no additional information or advice about the lawfulness of the scheme after Ms Pulford's 2014 advice and prior to the Ombudsman's indication of its own motion investigation.
That's my understanding.
Right. Given the extent of the Ombudsman's request for documents, that is, the advice, and surrounding documents, can you explain why having the original document, that is, the executive minute, and having, as it were, been caught out by the Ombudsman about the provision of only the 2017 advice, you didn't engage to obtain all other documents relevant to the 2014 advice, sorry.
No, I can't recall. I may have just jumped to the conclusion of this is where we need to provide the 2014 advice.
You'd already reached that conclusion the day before, hadn't you?
In relation to the earlier request?
Yes.
Well, yes.
Yes. After 3 days of to and fro and discussions about whether or not it was within scope, You reached that point where you decided personally that it was,
Yes.
and then the very next business day, the Ombudsman says, to be specific, this is what I was referring to and I'm asking for everything. You understood the position that DSS was in following the second request.
I think I thought that this was the 2014 advice is what was referred to in the that's what this is broadly related to, though I don't think it talked about legislative change.
What didn't talk about legislative change, Mr. Hurman?
The 2014 advice talks more in terms of the lawfulness of averaging as opposed to changing the legislation to make averaging lawful.
All right. But one necessarily leads to the other, doesn't it?
Yes, so I'm just saying that like the 2014 advice didn't specifically talk about legislative change, and I think that there's, in drafting this minute, there's an extra jump in there, I guess.
Yes, it might be revealed, that extra jump, by any other notes, documents or emails that relate to the advice.
I don't recall the request at the time, and I don't recall any decision to not seek out extra information. I may have just acted too quickly given the time frame for some of the responses.
Well, you had until the 1st of March to provide the response.
And when did I receive it? The 27th of February?
27th of February, that's right.
That's a fairly short time frame for something that goes through levels of clearance.
Did you consider you could ask for an extension to provide the second part of the request?
I don't recall. As I said, it was 6 years ago.
But it was obvious from that executive minute that DSS has also advised legislative change would be needed to implement the initiative. That must have existed somewhere.
I'm not sure. I think I jumped to the conclusion that the 2014 advice says it's unlawful. And so there's an assumed statement of us saying legislative change is required. I'm not sure.
Where's the assumption?
So this says that DSS has also advised that a legislative change would also be needed.
And as you say, that was not expressly said in the 2014 advice.
Yes.
So did you go looking for the documents that relate to that?
Not that I recall.
Why not? Given it was a specific request from the Ombudsman.
I'm not sure. I thought that they were probably referring to the 2014 advice, and that the phrasing in this minute might have been slightly incorrect.
Did you talk to anyone about that?
I don't recall.
Did you understand that Ms. Halbert, who we see in a number of the emails, was involved in the preparation of the executive minute?
I think there's an email between myself and Ms. Halbert on this matter, where I had drafted a response to it, and she provided some more information.
Yes, so you understood that she was involved in the provision of advice in respect of the executive minute? Was
she? This executive minute is from quite a while ago, isn't it?
The email that you are referring to, where Ms Halbert suggests changes to your draft response, indicated to you that she was involved in the provision of the original advice about legislative change, doesn't it?
Is it possible to bring that up at all?
Exhibit 1390, tab 70, DSS.5026.0001.004_R. 0004, thank you. You've read that, Mr Hurman?
Yes.
It's clear that Ms Halbert's response conveys to you that written advice in commenting on the brief was provided.
Yes.
That is the executive minute to which we've just referred.
Yes.
One which refers to DSS advising legislative change was required to implement the proposal.
Yes.
So, being informed by Ms Halbert that she was involved in commenting on the brief which indicated that DSS advised legislative change was required, and noting very correctly, as you do, that that was not said in the 2014 advice, what attempts did you take to locate that written advice?
I don't recall making any attempts to locate it.
And can you explain why not?
No. I think I was probably just caught up in providing the advice.
Caught up in?
Like in my mind, in terms of that being the answer to the question.
Did you not read the question?
I must have.
Yes. Are you speculating when you say that you were caught up in your mind? Or guessing?
Yes, it's a long time ago. I apologise.
Because another explanation, and I suggest it to you as your motivation, was that you were not interested in being upfront with the Ombudsman about all of the DSS advice in respect of the need for legislative change. You were in fact trying to conceal information which reduced the scrutiny of whether the scheme was lawful.
I don't think that's the case.
But you sitting here now can't give another explanation from your actual memory.
No.
I take you to Exhibit 3658, DSS.5031.0001.0062. You can see at the bottom of the page on the 28th of February at 6:22, you draft the request to Ms Halbert for the response to the Ombudsman. See that?
Yep.
And you draw this distinction, which you've drawn today, that the request was based on a premise that we have advice about legislative changes that would be made for online compliance, which we do not. Do you see that?
Yes.
That's a positive assertion that there is no written document,
Yes.
no written advice that legislative change was required.
Yes.
How did you arrive at that factual position if you didn't investigate?
I may have assumed that they were referring to the 2017 legal advice. I'm not sure.
You go on to say the background to DSS position document explains why that is not the case. You see that?
Yes.
And you go on to say it's also proposed to send the document that combines the 2017 advice already provided with the 2014 legal advice referenced in the background.
Yes.
Why would you put the 2014 advice as referenced in the background?
Sorry?
You say there the 2014 legal advice referenced in the background.
Yeah.
What you're doing here is proposing that you give to the Ombudsman the 2017 advice which they have already received from DSS and then reference the 2014 legal advice in the background.
No, I think that says provide both pieces of advice, and I thought that referenced in the background is referring to the background to DSS position document described above.
With the 2014 legal advice referenced in the background, was plainly a reference to providing the 2014 advice in the background, that is, in a diminished position in respect of the 2017 advice.
That's not how I read that.
Well, why would it be necessary to give the Ombudsman the 2017 advice again? They weren't asking for it, were they?
I'm not sure. We had it ready.
Well, you agree they weren't asking for it.
I agree they weren't asking for it, that's right.
So why would you give it again and reference the 2014 advice in the background?
I think providing full information on the two pieces of advice.
Full information? Why didn't you conduct an investigation then into what Ms Halbert said was in writing?
I'm not sure.
I suggest to you that what you were doing was again attempting to portray to the Ombudsman that DSS had satisfied itself of the legality of the scheme despite the 2014 advice.
Yes, I think we had not satisfied ourselves at that time.
Right. But given that the Ombudsman wasn't asking for your level of satisfaction or not and was asking for the advice, no doubt so it could make up its own mind, why didn't you just give all of the documents and the 2014 advice without the DSS spin?
To provide the full context.
Except that you didn't provide the full context, did you?
What do you mean?
We've gone through how the Ombudsman specifically asked you for all documents related to the need for legislative advice, and you've said that you didn't bother to get it.
Yep.
So you weren't providing full information, were you?
To provide both pieces of advice.
And you were prepared to provide your response in draft form on the 28th of February, the same day you received information about the request, not 2 days later after you'd spent your time looking.
That's true, yep.
Yes. You had no intention of providing full advice to the Ombudsman about the DSS legal position and all documents related to it, did you?
I'm not sure. I don't know why I missed that point.
Well, it's clear from the documents that you adopted a course where you were not full and frank with the Ombudsman. Correct?
I don't think that was my intention.
I didn't ask you what your intention was. I said it's clear that you adopted a course which was not full and frank with the Ombudsman.
Yes.
You actually had the instructions, at least, for the 2014 advice. We know from an earlier email that you actually had them. They were sent to you. Why didn't you at least give the instructions so that the context for the 2014 advice was obvious and whether or not it was full information?
I'm not sure, sorry.
One of the people involved in redrafting your draft was a Kristen Lumley,
Yes.
and you recall that she made extensive changes to some of the factual assertions contained in your draft.
I recall she made some changes, yes.
Did you consider them to be substantial?
I think there were a number of changes.
Yes, did you consider the number of changes to be substantial?
I'm not sure.
Okay, if we can go to Exhibit 3657. DSS.5031.0001.0062, tab 80. You can see at the bottom your draft response at 6:22 on the 28th of February, which you forward to Ms Lumley on the 1st of March early the next morning, in which she replies with suggested changes taking into account Ms Halbert's feedback. She said that she thinks it flows better with the bottom paragraph moved up and a new dot point 3,
Yep.
which was an important part of the 2017 legal advice. You see that?
Yep.
And again, emphasis is being placed on the 2017 legal advice when the Ombudsman has not asked for it and it has already been provided.
I'm not sure that that's emphasis, but yes, she's referring to the 2017 legal advice.
What would you say was a reference then to an important part of the 2017 legal advice if it was not emphasis?
I think she's just describing a change within the structure of the document.
By reference to an advice which the Ombudsman didn't ask for.
Yes.
It only had the tendency to emphasise the more recent advice and the current DSS position, correct?
Yes.
Which was not what the Ombudsman asked for.
Correct.
Right. And you can see at the top of the page, the attachments to the email are the Minister brief, that is, the executive minute to which we referred, and the background to DSS position on online compliance, and then the combined 2014 and 2017 advice document. You can see that.
Yeah.
Right. And you send it to Mr de Burgh for his clearance. And you can see that what you have pasted in red in this document is Ms Halbert's earlier response to you.
Yeah. I can't see it, but...
Right, perhaps if that can be withdrawn.
Yes, that is restating the comments from Ms Halbert.
Which included the provision of written advice commenting on the executive minute.
Yep.
You could hardly be so caught up in your head as to miss it a second time, Mr Hurman.
Yes.
And if we go then to the attachment, tab 81, exhibit 3658, DSS.5031.0001.0076. You can see that?
I can see it. Yep.
And you recall that that's what the attachment was to your email to Mr de Burgh for his clearance?
Yes.
And if you go over to the second page, please, _0002. You originally wrote, given the passage of time, it is unclear whether DSS's understanding of the measure in late 2014 was incorrect or DHS later amended the measure to address DSS concerns. Do you see that?
I can see that, yes.
Now, it would have become clear had you included the instructions to the 2014 advice, which set out what was proposed at that point by DHS.
Sorry.
You would have been able to make clear whether DHS amended the measure to address DSS concerns by a comparison between the proposal as it was provided to DSS for its opinion in 2014 with the executive minute 2015, which set out the nature of the process, with information about the current nature of the process.
Perhaps, yes.
Well, not perhaps, definitely. How could it not?
Sorry, could you... So comparing...
You were able to assert that it was unclear how this got through the gate, whether DSS understanding was incorrect or DHS amended the measure because you removed the factual premise on which the 2014 advice was given. The one reference point which answers the question.
Sorry, I'm really struggling to follow what you're saying.
In the summary of the 2017 and 2014 advice which was ultimately given to the Ombudsman, the factual premise on which the advice was given was removed because it was summarised, correct?
The factual advice...
The factual premise on which the advice was given, that is, the nature of the DHS proposal in respect of which Ms Pulford second counselled the 2014 advice, was removed from the document provided to the Ombudsman.
Yes.
And in order to understand whether DSS properly understood the measure on which the 2014 advice was given, or DHS later changed the measure to accommodate the concerns about it being unlawful, you would need to know the factual basis on which the 2014 advice was given.
Yes.
Why was it removed?
I don't recall.
Was it so that you could say, we aren't sure what happened here?
I don't recall.
Because it was within your capacity to identify what had in fact happened, wasn't it?
Yes.
But you didn't.
No.
And in fact, a contrary proposition is inserted by Ms Lumley over on the previous page. Following this, DHS took DSS concerns into account and made adjustments to the process. Do you see that?
Yep.
On what factual basis was that advanced?
I can't recall. I think there's... I think that is information that Ms Halbert, provided me in the email that we talked about earlier.
Go back to tab 70, exhibit 1390. This is Ms Halbert's email. DSS.5026.0001.004_R. You see that?
Yeah. Yes.
Are you saying that those two lines are the basis on which that representation is made to the Ombudsman?
I think so. That's
All right. And you could have made your own mind up about it by comparing the facts of the proposal for the 2014 advice with the facts set out in the executive minute with your own understanding of the OCI process as it was in February 2017.
yes, I guess so.
And you didn't do that?
No.
And you didn't do that in the context where you didn't look for the written advice in respect of the executive minute?
I have no evidence that I looked for it.
All right. Can I take you also to Exhibit 112, tab 64, DSS.8001.0001.3405. This was the document you referred to earlier where you understood that Serena Wilson made the decision not to provide the 2014 in response to the first Ombudsman's request.
Yes.
Right. And you can see that Ms Pulford emails you and copies Mr de Burgh and Mr Grinsell-Jones in on the 28th when you are dealing with this issue, and refers to a discussion that you had with her, it seems, on that day. Do you recall that discussion?
No.
She says, as a result, you believe the advice we provided in 2014 concerning the accuracy of raising debts based on averaged income is relevant. I pause there. That was her position too in respect of the first Ombudsman's request, wasn't it? Because she volunteered the 2014 advice.
That was her position, yes.
That's right. Did it surprise you that she was asserting that it was your position now?
No. Well, I don't know that I was surprised at the time, but I wasn't surprised when I read this
All right.
now.
It goes on to indicate, the point you make, that the 2014 advice does not suggest legislative change, but you believe DHS was advised by DSS's policy area in the context of subsequent discussions that legislative change would be needed to support the proposal. And DHS brief provided in early 2015 mentions this. Now again, this is the third reference to the possibility of notes or documents which relate to DSS advice that legislative change was required. Again, I suggest to you that was not lost on you in your decision not to obtain the documents for the Ombudsman.
It refers to discussions that legislative change would be needed. Yes.
All right, okay. Ms Pulford goes on, since then DSS policy has become more comfortable with DHS's approach of using smoothed income, given it is being applied as a mechanism of last resort where no more accurate information is available. You see that?
Yes.
Now that's effectively her restating what was in the 2017 advice, correct?
Yes, and attributing the DSS policy area, which would include myself, as being comfortable with that.
Yes, but you actually had no information or documents that, prior to Ms Pulford's advice, DSS ever became more comfortable with it.
Not that I have located in here.
And of course, you understood the 2017 advice to involve attempts to contact the person in respect of whom the debt was being raised.
Yes.
But having received the executive minute, you understood that too was a feature of the proposal back in 2015.
contacting people or
Yes.
not contacting people?
Yes.
If it's in there, yes.
And that really nothing had changed in that respect. Last resort and people not responding. I can take you line and verse through it if you like, but
I accept your...
yes.
Yep.
So you knew then that there was an artificiality about the change of position, correct?
I'm not sure that I did know that.
Did you ask any questions about it? Apart from a bridging paragraph when you were faced with the inevitability of having to provide both to the Ombudsman.
I think that's probably all that I asked of the service branch.
And it goes on, this appears to represent a change in DSS position, although it doesn't represent a change in the legal position. Now, in your draft letter to the Ombudsman, did you fully and fairly state that there was no change in the legal position from the 2014 advice?
I don't think so.
Why not?
I'm not sure.
Why leave that bit off? It was critical.
I don't know.
And you will recall after some extensive reworking of the draft, it was sent to Ms Wilson for her clearance through Ms Halbert.
Yes.
Ms Wilson made a change for the term apportioning rather than smoothing in the ultimate draft letter, yes. And then the combined 2017 advice and 2014 advice document was sent to the Ombudsman.
Yes.
And in fact, the 2017 advice was put at the front and the 2014 advice summary was at the back.
Okay.
Well, that's true, isn't it?
Yes.
That's how the document was prepared,
Yes.
with the 2014 advice in the background,
At the back, yes.
as though to emphasise the importance of the 2014 advice, which was non-responsive to the Ombudsman's request.
2017 advice.
2017 advice, which was non-responsive to the Ombudsman.
Perhaps, yes.
Yes. I suggest to you that there was a pattern of behaviour from the start in January 2017 by people within DSS of which you were part, and it was designed to establish the lawfulness of the scheme in the representations that it made to the Ombudsman, irrespective of the true position.
I think it was... We tried to put it in a positive light, I guess.
Yes, but it's a bit hard to put a positive light on something that you understood was being conducted unlawfully, according to the advice that had been given in 2014 for a period of 18 months, and was unfair, according to your view.
But I think we were relying on the 2017 advice.
Yes, that's clear. But that was obtained only after the Ombudsman started asking questions about lawfulness and accuracy, wasn't it?
I think the final advice was then. I'm not sure when it was requested.
All right. It was requested by Ms McGurk, the person you worked with in your response to the Ombudsman's investigation on about the 18th of January. I suggest you knew that.
You suggest I knew that it was...
That there was a need for the department to obtain further advice to justify the lawfulness of the scheme.
I knew that the advice had been requested, yes.
And you knew that it had been requested after you received the 2017 advice. Sorry, the 2014 advice on the 12th of January, 2017.
After I had... yes.
Yes. What I'm suggesting to you, Mr Hurman, is that you well understood from the Deputy Secretary level of Ms Serena Wilson down to Ms Halbert, to Mr de Burgh, to yourself, that there was a concerted effort to respond to the Ombudsman's investigation by asserting both lawfulness and accuracy of debts raised under the OCI scheme.
I think, yes, we were providing the intention was to provide the advice that, or to emphasise the 2017 advice that it was lawful, yes.
And accurate.
Yes.
And that there'd been no change to the system.
Yes.
And that the DSS was comfortable with it in 2015.
I'm I'm not sure about that.
as a result of changes made to the scheme and DSS getting a better understanding of what the scheme involved?
You're referring to the comments from Ms Halbert.
The covering letter that was sent to the Ombudsman attaching
Yep.
2017 and 2014 advice.
Yep.
Yes, all of those representations were made in the context where no real effort, I suggest, was put by you to establishing the true position.
I think I jumped to the 2017 and 2014 advice in responding to the second request, yes.
I can see that. What I'm suggesting to you is your motivation for doing it was that there was a departmental position which was unconcerned with the true position of lawfulness or accuracy or fairness and wanted only to assert to the Ombudsman that it was lawful, accurate and fair.
I don't recall a departmental position like that.
Thank you, Commissioner.
Ms Hogan-Dory?
Commissioner, given the time, I'm just going to take the witness to two relevant documents. The first is, could I ask, the following document, which I understand is available, DSS.6500.0001.0003. It is a document dated 19 January 2017. I don't know whether I understand this document will become available. It is a document produced by the Commonwealth to the Commission, but I understand it is not in evidence. And of course, in those circumstances, may indeed not have been available to counsel assisting in his preparation. Mr. Hurman, you recall you were asked some questions about the phrase lawful and clear earlier on in your evidence.
Yep.
The phrase lawful and clear. Do you remember those questions? Just as a general proposition?
Yeah, yeah.
All right. I think the effect of your evidence was that there had been a departmental meeting that had occurred during your period of leave.
That's correct, yes.
And your period of leave was about 16 January and the meeting was on the 18th of January.
That sounds right, yes.
And just so that I just want to reframe, give you an opportunity to think about the context. 18 January, a meeting you didn't attend,
Yes.
but you then sent an email which referred to what occurred at that meeting. Do you remember that?
Yes.
All right. I don't have that email or that reference to hand, but that's the passage of evidence I'm asking you about. If you go down halfway down that page to the section where the words Gary Knox commence, brackets input has been cleared by Emma Kate via phone, new line payment integrity and debt strategy, new line for information, online compliance intervention, brackets OCI, brackets first dot point, senior departmental staff were given a run through of the Human Services online compliance system at capital T, capital O, capital P on Wednesday, 18 January 2017 and are comfortable that the current process is lawful and clear.
Yes.
Do you recall this email?
Not specifically. I can't see that I was included on any of the,
Do you know what PPFG coord stood for?
that would be, I think that was the name of Kath Halbert's group at the time. Sorry, I can't recall what it stands for, but I think that's probably who. PG coord. So that would be Payments Group coord. Sorry. Yep.
Right, and that was the group in which you were a director?
Yes. Yes.
Right. So, just so I understand your evidence, sitting here now, having looked at it perhaps for the first time for some time, you're not sure whether you saw it at the time.
It's likely that this is something that I would have updated in future cases, and that information there about the 14 January meeting where I was away.
18 January?
Yeah, sorry, did I say 14? 18 January meeting where I was away, I would have potentially used that in future, emails of similar nature.
All right. Who was Gary Knox?
Gary Knox was another director within our branch, and I think he oversaw my section for the period while I was on leave.
I see. All right. That's all I wish to ask about that document. Commissioner,
I'll
the
make
other
it an
document.
exhibit just to keep it on the
Sorry,
record.
I'm sorry, Commissioner, I didn't hear you.
3814 capital A.
Well, thank you, Commissioner. The other document, the witness could be shown Exhibit 82, which is DSS 5032 0001 0009, which is an email from Ms Pulford at 4:37 p.m. on 22 February 2017. I'll just wait for that document to come up. Mr Hurman, it's probably somewhere in your bundle, but I can't. Now, I wish it was.
It's up now?
Yes, but I can't see it.
Oh, okay.
It's quite faint. I might ask the operator to see if they can extract that first. Thank you. Do you recall you were asked some questions in particular by the Commissioner? Sorry, I'll start that again. You recall you were asked some questions by my learned friend, Senior Counsel Assisting, about, and you gave some evidence about obtaining a joining paragraph from Ms Pulford in relation to the 2014 and 2017 advices.
Yes.
Right. Looking at this email, is this the joining paragraph to which your evidence was referring?
Yes.
I understand it's a tab 16 of your bundle if you need to see the hard copy. You see, Robert, I note that the 2014 advice includes a significant email trail where the question was being refined, query whether this would be removed from what is provided to the Ombudsman, as it is arguably not in scope. Then she goes on to say, suggested joining paragraph ...
Yes. Yep.
I just want to focus on the first sentence. The 2014 advice relates to the process of rate calculation under the Social Security law and indicates the method of generating an accurate debt amount on the basis of full information. You were asked some questions by the Commissioner in particular about a sentence
Yep.
which used the phrase full information with respect to the 2014 advice. Is it likely that this is the source of your use of that sentence in that email about which you were asked some questions?
Yes, it is. Yes.
All right, thank you, Commissioner. I'm not going to ask any further questions in those.
So the end result is you were prepared to tell the Ombudsman that because you were simply adopting what Ms Pulford had told you, or did you think about the phrase, or what's the end result?
I can't recall, but I tried to describe what I thought that the phrase meant earlier, without much success, unfortunately. But yeah, I think that is the basis of what we responded with.
But you think what, sorry?
That's the basis on, that is the joining paragraph that ultimately we included.
Okay, so would it be fair to summarise that you adopted what Ms Pulford said without a clue as to whether it was right or not?
Well, no. I thought I knew what the sentence means.
And it's what you told us before, is it?
Yeah. I don't think you agree.
Commissioner, I'll just follow up on that question. Mr Hurman, you're not a lawyer, is that right?
I'm not, no.
And you don't have any legal training?
No.
You understood Miss Pulford was a lawyer
Yes,
with extensive legal training.
yes,
May we take it that when you received that paragraph from her in which she was describing the effect of her two advices that she had previously provided to the department, it was safe for you to rely upon what she told you?
yes.
Right. Thank you, Commissioner.
Good bit of leading there, Ms Hogan-Doran.
Commissioner?
That's all right.
Yes, I'm conscious it was a little leading, but I'm also
Fair
conscious
enough,
that he's
that's all
not
right.
separately represented and the allegations that have been put to him today by counsel assisting were not foreshadowed.
Okay, thank you. Mr Gregory?
No re-examination. Can Mr Hurman be excused, please?
Yes, thanks. You're excused, Mr Hurman.
Thank you.
Commissioner, I note the time and I also note my previous indication about the availability of the two Commonwealth witnesses. My learned friend had proposed to interpose Mr West between them. I wonder if that was still the plan.
I'm going to be upsetting someone, I think, is the answer.
Well, I'm not buying into this. You work it out.
I can get through Mr Grinsell-Jones and one other witness.
I'm going to make a bid for the two Commonwealth witnesses
I appreciate that.
so that they can return to their families for the start of their holiday tomorrow.
What's Mr West's availability on Friday, do we know?
I think he's in a similar position, I've been told.
That he can't make it Friday, or?
Mr Beecham is...
Oh, Mr Beecham, what's the... He would be?
I've taken some instructions. It would be his preference. We understand these things, as Mr Gregory indicated, but...
God bless you, Mr Beecham. I said, God bless you, Mr Beecham.
Thank you.
Well, it looks like we might push ahead with the two Commonwealth witnesses. I'm sorry about that, but we'll make sure that he gets on. Can we assure him in the morning of Friday?
Yes.
Okay, morning Friday. Thanks, Mr Beecham.
If we could have Mr Grinsell-Jones next, I think.
Commissioner, just while the witness is coming down from upstairs, I'm just going to confer with my learned friend in relation to new documents,
Sure.
so in case it slows down the balance of the afternoon.
Yes. The lifts might be being recalcitrant, I think.
This goes on the table.
So, Mr Grinsell-Jones, yes?
Yes.
Mr Grinsell-Jones, will you take an oath or an affirmation?
An oath, please.
Okay, stand up, please, and we'll get that administered.
Please place your right hand on the Bible. Your response is, I do. Do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Mr Gregory.
Thank you. Mr Grinsell-Jones, could you tell the Commission your full name, please?
It's Alan Reginald Grinsell-Jones.
And were you served with a notice to give a statement NTG-0142 dated 21 December 2022?
Yes, that's correct.
And you produced a statement in response dated 16 January 2023.
No, the statement I have produced is dated the 23rd of January 2023.
Right. Was that an updated response which included...
It was an updated response which incorporated the document identification numbers as produced to the Commission.
But was otherwise unchanged from...
In all other respects is unchanged.
Thank you. And is the contents of your statement dated 23 January 2023 true and correct to the best of your knowledge and belief?
Yes.
Right. You indicate that you were a branch manager of the Legal Services Branch Executive from 1 November 2016 to 3 June 2018 in paragraph 17 of your statement. As a branch manager, did you have substantial responsibility for overseeing a large number of lawyers within DSS?
I'm sorry, could you repeat the question?
As a
Just
branch,
the last part, yes.
As a branch manager, did you have responsibility for overseeing a substantial number of lawyers within DSS?
Yes, I think by my head count there were 35, but there were at least 30 at that stage.
The point you make in your statement is that you relied on your senior lawyers to deal with the advices that came through largely and didn't involve yourself in the detail of them.
No, that's correct.
Right. You became aware, though, in January 2017 that the Ombudsman had initiated its own motion investigation in respect of the online compliance intervention scheme conducted by the Department of Human Services.
I don't know, it was January 2017. I think the first time I became aware would have been in February 2017.
Can I take you to Exhibit 3062? Now, you have two bundles there. It might be in the larger bundle behind tab 11A. DSS.5031.0001.0001.
Sorry, what? 11A?
11A. It has also come up on the screen, but I see you have it there. It is an email trail which commences at the bottom of the page on 18 December 2014, which forwards legal advice of Mr Simon Jordan, which had been second counselled by Ms Anne Pulford, you'll see over on the next page.
Yes, I can see that, and I can see that it was sent to me, but I don't recall that it mentioned the Ombudsman inquiry in that trail.
Right, yes. Now, Anne Pulford was a lawyer in the team that you supervised.
Yes.
She was one of the senior lawyers in the team.
She was an executive level 2 lawyer in that team.
Right. The advice was forwarded to you by Ms Melanie Metz on 12 January 2017. Ms Metz is described by her footer as a principal lawyer in the Legal Services Branch.
Yes, that's correct.
And was she a lawyer that you were supervising effectively as branch manager?
Yes.
The email to you refers to Kath, who we see you forwarded the email to the same day, about 6 minutes after receiving it. That's Kath Halbert.
Yes.
She was a group manager, I understand, within DSS at the time.
That's my recollection, yes.
Ms Met's reference to Ms Kath is in these terms. I think this is the advice that Kath is referring to. And there obviously is some background information to this sequence of emails which indicates that Ms Hulbert has referred to an advice and Ms Met seems to have located it and forwarded it to you.
Yes.
What do you recall of the background to the sequence of emails?
Unfortunately, in relation to that sequence of emails, I cannot recall.
Do you recall that the Ombudsman's letter to Mr Pratt was the 10th of January 2017?
No, I don't.
Right. And do you have any recollection about why Ms Hulbert would be interested in an advice going back to December 2014 at that time?
No, I'm sorry, I don't.
You later came to appreciate that Ms Pulford was asked to provide an advice in respect of the legality of the OCI scheme, that is in February 2017.
Yes, I'm aware that advice was provided by Ms Pulford in 2017, January.
And undoubtedly that put some context to this particular advice that had been second counselled by Ms Pulford in 2014.
My recollection is that the two devices were on different questions.
You discussed with Ms Pulford at one point when she sought your direction or assistance about whether both the 2014 and the 2017 advice ought to be provided to the Ombudsman in response to an Ombudsman's request for legal advice relating to the lawfulness of the scheme.
Yes, I recall that discussion, but that was in later February 2017 after the Ombudsman had issued the notice requesting documents in February 2017.
And you've no doubt seen the email exchange between yourself and Ms Pulford that relates to that discussion about whether the 2014 advice was within scope.
There were two separate discussions I had with Ms Pulford, one on I think the 21st of February and then the subsequent one on the 22nd of February.
Yes. The 21st of February related to the question of what she should do about providing the 2014 advice to the team who was responding to the Ombudsman?
That wasn't specifically related to the 2014 advice. It was a general discussion around the question of providing legal advices generally to the Ombudsman.
Surely, though, in order to assist Ms Pulford, you must have sought some context from her.
At that stage, there was a discussion. The next day, we had a discussion about the two legal advices which had been identified by Ms Pulford and sent back to the line area, indicating this is what we believe should have been supplied to the Ombudsman in respect to that request.
That is, when you say we, your view was that both advices ought to be supplied to the Ombudsman in response to the Ombudsman's request.
My advice that the Ombudsman request was clear. They were seeking advice as on the Pacific Debt Matching Scheme, and both advices were clearly in scope, in my view.
Yes. That undoubtedly required you to at least have a broad understanding of both advices.
I needed to understand what the subject matter of the advice was without necessarily knowing the specific details and the reasoning of the advice.
Did Ms Pulford indicate to you any concern about potential inconsistency with the advices?
No, my recollection is that her position was that the advices were not inconsistent. They were answering two different questions.
And did you engage with her about that in order to form your position on whether they both should be provided to the Ombudsman?
No, I don't recall engaging with her about the subject of the matter of the advices. My advice to her was just purely to say that I thought both of those were within the scope of the request, as whilst they were different questions, they were in respect of the same subject matter.
Yes. The 2014 advice came to the view that calculating debts by reference to averaged PAYG data might not be within the legislative scheme for raising debts. You recall that?
I can't disagree with you on that. As I said, I have only reread the advices again in the last couple of days in preparation for this.
All right. In the context then, and I take it by this point in February 2017, you understood that the Ombudsman had initiated the investigation.
Yes, I did. I think that from my recollection and from my review of the emails, the first time I became aware of the Ombudsman investigation was on the 21st of February.
Right. You understood, of course, by that point there was significant media attention in respect of the lawfulness and the fairness of the scheme?
I can understand there has been significant media attention. Whether there was at that point in time, I can't recall.
Do you recall that the Minister for DSS, Mr Porter, and the Minister for DHS, Mr Tudge, were making statements in the media which defended the continuation of the scheme?
No, I can't recall that.
How long have you been employed in the Commonwealth Public Service?
I joined the public service in 2008, in September 2008.
And over that period of time, that is from 2008 through to 2017 when we're concerned with these events, did you notice that a department of the ones that you were in tended to fall into line with statements that the media was, that the Minister was making in public?
No, I didn't. I mean, I was responsible for the legal area, not for the policy areas, and if they were making statements in line with the Minister's statements, then I certainly wasn't aware of that. Oh, sorry, I'll rephrase that. I may have been aware of it at the time, but I can't recall any specific issues.
All right. Given the significance of an independent investigation by the Ombudsman into this scheme, and that the advice had been given by Ms Pulford in January 2017, did you consider that it would be appropriate to obtain external legal advice on the question of the lawfulness of the scheme or the accuracy of the debts that it raised?
No, I didn't give consideration to that. I don't recall it ever being raised as an issue.
Was it a common practice that advice from an external law firm or the AGS would be sought on significant questions of law which related to schemes run by the department?
It wasn't uncommon. I could describe it as that. It was certainly happened from time to time.
Do you recall discussing with Ms Pulford any concern about the merits of her advice or her degree of confidence
Okay, and the last question was about the merits of Miss Pulford's advice, whether you'd had any discussion with her about it, Mr Grinsell-Jones?
The answer is no, I didn't have any discussion with her about the merits of it. I relied upon the advice of those senior lawyers. I'd only taken on responsible for Social Security in November 2016, so I was quite new to that area of law.
What was your background?
My background, I was an employment lawyer in private practice for a number of years, then moved into the public service in the childcare area and headed up various branches across various departments over a period of about 8 years.
Thank you.
Commissioner, there's no transcript still, I'm just noting.
I'll just get it checked whether it's going to come up. I'm told that the bit that seemed to be missing before will be on the final transcript, even though it never turned up on the live feed. I'm told it's all right, that it will come good at some stage, presumably.
Yes, thank you, Mr Grinsell-Jones. You recall that following the provision of the 2017 advice to the Ombudsman by a policy section, the Ombudsman specifically requested information about advice that legislative change was required to implement the proposal, and having a discussion with Ms Pulford about that.
Yes, that was a request for advice which I think came in on the 28th of February 2017.
It might have been a bit earlier than that, but in any event, you recall it?
I recall there was a second request for advice did come through.
All right. Well, you might be right, actually. I think I've misread 23 for 28. Can I take you to Exhibit 112? It's behind tab 64 in that volume, DSS.80001.001.3405. This is the sequence of events on the evening of the 27th through to the 28th of February 2017.
Sorry, what was the document number again? 3405, yes.
Thank you. You'll see at the bottom of the page that Ms Richards sends you an email at 8:43 a.m. on 28 February 2017.
Yes.
And the content of it is brought up on the screen. It is, at this point, the last email in a trail which contains the Ombudsman's further advice. Made 24 February 2017, about advice that legislative change was required. And you can see from what she said to you on the 28th of February in the morning that she asks you to contact Kath Albert, that's right?
No, at this stage I thought she just asked me to locate the relevant advices.
All right. She said, I spoke to her quickly last night and they're looking for advice that bridges explains why our approach has changed from the view that legislative change was required to the view that it wasn't. Can you start by locating the relevant advices, please? You see that?
Yes.
And your response to that was to forward the email to Ms Pulford, who then replied to Mr Hurman, Mr de Burgh, and copied in yourself.
Yes.
In her response, Ms Pulford explained what may have been perceived as a difference between the advices, but you can see that she concluded in that middle paragraph commencing since then that this appears to represent a change in DSS position, although it doesn't represent a change in the legal position.
Yes.
Did you understand when you received that Ms Pulford was maintaining that the raising of debts by reliance on averaged income would not fit within the legislative scheme?
No, I don't recall understanding that at all. As I said, this was just an email that I was copied into in response to the second Ombudsman's request for documents.
Can I take you to tab 76, exhibit 3655, DSS.5113.0001.0609. This is an email trail which commences in the afternoon of the same day, where there was a request from Ms. Dura through Lydia Ross to know if someone from Legals could attend the meeting with the Ombudsman tomorrow, and that makes its way to you at about 5:13 p.m. You see that at the top of the page?
Yes.
She says that she had provided you with the relevant background docs and the AGS advice. Do you recall what those relevant background documents were and what the AGS advice was?
No, I don't.
That was done by email or in person?
Well, I did a search of all the emails in that relevant period, and there is nothing which would meet that description.
Yes.
So whether she provided to me physically, I can only speculate.
Was she a lawyer within your branch?
Susan was one of the other EL2 lawyers within the Social Security part of my branch, yes.
Right. You indicated, of course, that you were happy to go.
Yes.
Do you recall preparing for the meeting with the Ombudsman by referring to the advices of Ms Pulford or the 2014 advice and the 2017 advice?
No, I don't recall preparing for the meeting by referring to those advices. This was a meeting I recall being called by the Ombudsman to discuss the second Ombudsman's request on the 28th.
And you understood that request related to advice in respect of legislative change,
Yes.
given at a much earlier point?
Yes, but this email was dated 5:13 on the 28th, and the meeting was actually cancelled very early on the morning of the next day, so I didn't need to prepare. The meeting was called off by the Ombudsman's office.
Right. And you can't now recall what those documents were referred to in the email from...
No, I can't recall.
All right. There was the earlier email I took you to, a reference to Ms Richards, Janine Richards. Can you just explain her position in respect of yours?
Janine was my immediate supervisor. She was at that stage head of, I can't recollect the title, but it was not even a branch. It was a part of the department which contained about 6 different branches, including legal, HR, investigations, corporate, and possibly 1 or 2 more. It was a very, very large section of, well, it was over 200 staff members within that one particular. Sorry, I don't know what I can't recall these days what the word for a division of other branch is.
A group?
Yes, a group. Thank you very much.
Right. Yes, thank you, Mr Grinsell-Jones. I have no further questions.
Thank you.
And apparently there's no other questions. Mr Grinsell-Jones can be excused.
Excused, yes, please, Commissioner.
Thanks, Mr Grinsell-Jones. You're excused.
Thank you.
The next witness is Mr de Burgh.
I did ask for him to be ready, so I'm hopeful he'll hear.
Thank you.
check here. Is that what you want? Yeah.
Mr de Burgh, will you take an oath or an affirmation?
Oath?
All right, would you stand, please?
Please place your right hand on the Bible. Your response is, I do. Do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Take a seat. Mr Gregory?
Thank you, Commissioner. Can you tell the Commission your full name, please?
Sorry?
Your full name, please.
Russell Ian de Burgh.
And you were served with a notice to give a statement NTG-053 dated 24 October 2022.
Yes.
And you provided a revised statement dated 27 October 2022 and a supplementary statement dated 20 January 2023 in response.
I think the revised statement was the 11th of January.
All right.
Is that what you said?
It might have been, no, I said the 20th, but there may have been
The
an updated version which
Yes.
with document IDs.
But the supplementary statement is the 20th of January, yes.
Thank you. Yes. Are the contents of your revised statement and supplementary statement true and correct to the best of your knowledge and belief?
Yes.
You were involved, amongst other things, in the DSS response to the Ombudsman's own motion investigation in early 2017.
Yes.
In terms of the hierarchy of your role, Mr. Hurman was below you or reported to you,
Yes.
and you reported to Ms. Kath Halbert, who was a group manager,
Yes.
and Ms. Kath Halbert reported to Ms. Wilson, who was a deputy secretary.
Correct.
Right. Do you recall when it was that you first became aware of the Ombudsman's own motion investigation?
So I think it was in early 2015,
17?
early 2017.
To your understanding, Mr. Hurman and Ms. McGurk were assigned the responsibility of dealing with the department's response to the investigation?
I'm not aware of Ms. McGurk's involvement.
Okay. Beyond then, Mr. Hurman, was anyone else involved, to your knowledge?
So there, at one stage, some edits were made by Ms. Lumley, who I think worked for Mr. Hurman at the time.
Right, we're talking about a response ultimately to the Ombudsman in respect of a second request for legal advice. That's the document you're referring to?
Yes.
All right. Okay. To put the Ombudsman's investigation into context, you were at the time aware of the significant criticism in the media about the scheme, which was the subject of the Ombudsman's investigation.
I don't recall whether I was at the time.
Did you keep up to date with the media relating to the department generally?
Yes.
How did you keep up? Sorry.
Particularly in relation to the work that I was doing, yes.
How were you kept up to date by media?
So my own general observations of the media, but also the department had a daily email would come around with relevant media articles.
Department-specific media articles or portfolio-specific media articles?
Portfolio specific.
Right.
Yeah.
That is, articles relevant to DHS as well as DSS?
I would think so, yes, but certainly in relation to DSS.
And was that produced by Icentia?
That is a name that I'm familiar with, but I don't remember whether that's who was doing it at the time.
And did the daily media updates of portfolio relevant media include statements by ministers or media related to public statements by ministers?
So it certainly had newspaper articles. I don't recall it having ministerial media releases included in it, but if they had made a statement that had been picked up in a newspaper or radio, then it would be in there.
Do you remember that Minister Porter and Minister Tudge were making statements in the media in defence of the OCI scheme carried out or implemented by DHS at the time?
I remember yes, but I don't know whether that was happening in early 2017. I don't remember how much I was aware of that.
Do you recall that about this time there was an ANAO announcement of its own investigation or audit of the scheme, the costings underpinning the scheme?
No, I don't have a recollection of that.
What about a Senate inquiry in respect of the scheme?
I don't recall whether that happened at that time.
Do you recall it happening?
I recall it happening.
Right. An Ombudsman investigation into the lawfulness and accuracy of the scheme was obviously a matter of significant relevance to DSS with its legislative oversight.
Yes, we would respond to it, yes.
And indeed adopt a position in that response about the lawfulness and accuracy of the scheme.
Sorry?
DSS would not merely respond, but would adopt a position in its response. That is, not merely provide information, but provide a position about the lawfulness and the accuracy of the scheme.
Yes.
Right. And was it clear to you in your involvement with the response to the Ombudsman's investigation that the DSS position from a very early point was to defend the lawfulness of the scheme and to defend the accuracy of the debts raised in the scheme?
So if you mean by the early stages, you're talking about 2014-15?
I'm talking about after the Ombudsman foreshadowed or indicated to Mr Pratt on the 10th of January 2017 that it commenced its own motion investigation into the scheme, that from that very early point the Department of Social Services adopted a position whereby it would defend the lawfulness of the scheme and defend the accuracy of debts raised by the scheme.
I think the response to the Ombudsman outlines legal advice that we had at the time. And that formed the basis of the response that we gave and the view that we had.
Yes, we'll come to the sequence of events first, but are you saying that it was the 27 legal advice which informed the Department's response?
To the Ombudsman's?
Yes.
Yeah, the response is in two parts, and yes, it quotes from the 2017 legal advice.
The response doesn't quote from the 2014 legal advice.
No, I don't believe it does.
The 2014 legal advice, though, was significant to the terms of the Ombudsman's investigation, wasn't it?
It's certainly relevant to it, and it was provided as part of the Department's response.
Well, ultimately, but not initially, was it?
I think the 2014 legal advice. In the Department's first response?
Yes.
I haven't been provided with a copy of the Department's first response, but from the second response, it appears that it wasn't included.
All right, we might have to take you to it. But before we get to that point, at this time you were a very senior person within DSS. You held an SES appointment?
Yes.
Level 1?
Yes.
Right. And you understood, of course, that it was very important not to mislead the Ombudsman by any of the responses that DSS gave to the Ombudsman's questions.
Yes.
Not only was it important from a departmental perspective, but you had personally obligations under the APS Code of Conduct, which would have precluded, or ought to have precluded, any misleading statements being made to the Ombudsman.
Yes.
All right. Do you recall that the 2017 advice was sought by DSS of Ms Pulford after the Ombudsman advised Mr Pratt of its investigation?
I'm not aware of the sequencing of the advice.
Right. You ultimately saw, though, the 2014 advice and the 2017 advice.
I ultimately...
Saw both advices.
Yes. Yes, they are included in the response, yes.
And when you saw the 2017 advice, you would have appreciated that it was prepared on the 24th of January 2017 by Ms Pulford. Look,
Sorry, can I
it may
check
be
the
the
date?
case that I have to take you through the documents, but I'm just trying to get a feel for how familiar you are with them.
Wow. 24th of January, yes.
All right. In response to a request by Ms McGurk.
Yes.
And you were involved in discussions between the 21st and 22nd of February in response to an Ombudsman's request about whether the 2014 advice, second counsel by Ms Pulford, was within the scope of the request.
Yes.
Your initial view, and that of Mr Hurman, was that it was not.
Not relevant, yes.
Right. And how did you come to that view, given the breadth of the Ombudsman's request for legal advice?
As I recall, it was because we felt the Ombudsman's advice was primarily about the department's current view.
Okay. The large volume to your left contains a number of tabs. Could you turn to tab 47, please? Exhibit 3636 DSS.5018.0002.4233. Now the end of this email trail was not to you, but you can see that if you go to the top of the page, dot 4234, you can see Mr Hurman emails you Tuesday, 21 February 2017 at 4:27 p.m. Russell, see below information and attachments from Anne. Anne has advised she considers the older advice is in scope. I can see how she would draw that conclusion given the last sentence that says, quote, any legal advice it has received about averaging income for social security overpayment calculations, either in the past or in the context of the OCI, end quote. You see that?
Yes.
And Mr Hurman expresses his view. However, I think this looks at the sentence in isolation only and ignores the earlier context. The earlier part of the email says DHS has told us it always used averaging as a last resort. We'd like to understand more about the authority to do this. You see that?
Yes.
And Mr Hurman said that he thought the Ombudsman is not seeking the other piece of information, but suggested a response which said, in response to your request regarding any legal advice about the use of income averaging as a last resort, we provide the attached legal advice. Do you see that?
Yes.
Yes. When you read that, did you form the opinion that the broad scope of the Ombudsman's request had been refined by the response of Mr Hurman?
Did the passage that you've just read out?
Yes.
I think we were seeking to provide the relevant advice, and that's what this is referring to.
But no, this request was any legal advice that has been received about averaging income for social security overpayment calculations, either in the past or in the context of OCR. You see that?
Yes,
That was the Ombudsman's request,
yes.
right? That plainly captured the 2014 advice, didn't it? Which related to averaging in the past.
So I think in the context of this, there was some backwards and forwards with our legal area. And that resulted in the final decision of what advice to release.
Yes, that doesn't answer my question, but I'll take you up on your answer. And the final decision was that both were within scope.
I think so, yes, although I don't think that's in this email, but yes, that's my recollection.
All right, but you've seen some emails to that effect,
Yep.
yes. And what is conveyed here that you can now see is that Mr Grinsell-Jones informed Ms Pulford that he considered that both advices were in scope.
Yes.
Now, that wasn't conveyed directly to you, but you recall Ms Pulford sent an email conveying effectively the same thing.
Yes.
Yes, all right. But my question was directed towards Mr Hurman's email to you, and I was suggesting that it's obvious from the way in which he phrased that he was seeking to limit the Ombudsman's request beyond its plain terms. Or you didn't see it that way?
Well, I don't now recall what I thought at the time, but I think that it's not necessarily the case that that's what was happening. I think that in the course of providing information to the Ombudsman, we are looking to provide the most appropriate advice, and that is what is happening in this email trail, where I guess the policy program area that Rob and I were involved in is talking to the legal area as part of that process of trying to work out what's the most appropriate advice to give. Of all of the possible things that could have been provided, what was the most appropriate?
And what had happened was that in the preceding email, the author of the 2017 advice had provided you with the 2014 advice, or provided Mr Hurman with the 2014 advice and indicated that she thought it was within scope.
Yes.
That must have been a very powerful consideration for the decision about what the legal department thought was within scope in respect of a request for legal advice.
Yes.
Related to averaging, yes.
Yes, and then that was backed up in the later email from Mr Grinsell-Jones.
Yes, because your view accorded with Mr Hurman's view that the 2014 advice was not within scope.
Yes.
Yes. Why did you come to that view, given that the author of the 2017 advice said the opposite?
Well, I don't now directly recall, but I think it would be about trying to provide the most relevant, appropriate advice. And at this time, that's what we were thinking that would be.
And the advice that said that the scheme wasn't within the legislation in the first place wasn't relevant?
Well, I think in the end, based on the advice that we got from Ms Pulford and Mr Grinsell-Jones, we agreed with their view that yes, it was relevant.
I'm just struggling to understand how you could have ever thought it was not relevant.
Well, so my understanding of the 2014 legal advice is that it doesn't recognise that the averaging is being done as a last resort. So that's my understanding of the difference between the two pieces of advice.
Okay, well, there's problems with the premise, but moving aside from that, what it says plainly is that averaging, never mind the context, does not fall within the legislative scheme. Isn't that more important than where the qualifications about last resort come into play? In other words, last resort or not, it just says it's not within the legislative scheme.
Well, I guess I would think that the questions you're asking are about the specifics of legal advice, and so that is why, in the end, we agreed with the advice from our legal area that it was relevant.
Okay, so the best I can do with what you've told me is you had some notion that because the 2014 advice didn't talk about use of averaging as last resort, it was not relevant.
Well, we also had more recent advice, the 2017 advice, which I would think would also have come into our thinking about what is the most appropriate information to provide in response to the Ombudsman's request.
They weren't exclusive. The fact that you had a 2017 advice didn't prevent you from providing the 2014 advice.
I agree, and that's why, in the end, we agreed that both advices were relevant.
You see, a possible view is that DSS was really not very keen for the Ombudsman ever to lay eyes on the 2014 advice because it showed from the very beginning this scheme was known not to fall within the legislative competence of DHS or DSS. Possible view? Got any comment?
I can see that, but there's nothing in the emails that suggests that. The emails have a plausible but not ultimately taken suggestion of a way forward.
All right. Mr. Gregory?
What then do you make of the decision not to provide the Ombudsman with the 2014 advice, despite the legal position and despite your ultimate acceptance of it being within scope?
So as I mentioned earlier, I have not seen the response that went back to that first request, only the second request, which implies that the 2014 advice was not provided.
We could turn to tab 56 in that bundle, Exhibit 3642, DSS 5051.0001.0068. You can see that on the 23rd of February 2017, there is an email from the P&I coordination area to the Ombudsman in response to the request for the advice, which includes Mr. Hurman as a recipient.
Yes?
Surely Mr. Hurman came to you and discussed with you the fact that despite your joint view, ultimately, that both should go, only the 2017 advice went.
I don't I mean, that would seem a reasonable thing, but yeah, I don't have any emails or recollection to that effect.
When was it that you became aware of the second advice?
Of the second request from the Ombudsman?
Yes, sorry, the second request. My apologies.
So I think that is when the second piece of, so the second request is the 24 February
Yes.
from the Ombudsman, and at some point after that, I was made aware of a second request.
Do you recall when you were made aware of the second request and you realised that the 2014 advice had not been provided, wondering why that had been the case, given your discussion with Mr Hurman and with Ms Pulford over the 21st to the 23rd?
No, I don't have a recollection of that.
Surely it would have been significant to you in terms of the department's position about the importance of not misleading the Ombudsman and your own duties or obligations.
I expect that at the time I would have known either before the first response was sent or soon after I would have known why the 2014 advice wasn't included.
And why is that?
No, I don't recall now, but I'm sure that at the time I would have known, yes.
And you haven't been able to find an email which records it?
No. I haven't. No, I don't have even this email that is the response to the Ombudsman. Well, I wasn't copied into it. I don't have that, and I haven't been able to find any emails that lead up to why the 2014 advice was removed.
Do you recall discussing this with Ms Halbert or Ms Wilson?
I'm sure I would have discussed it with Ms Halbert, but I don't recall that now.
Are you able to say now, though, that the decision not to include the 2014 advice in the response to the first request to the Ombudsman must have been made by either Ms Halbert or Ms Wilson?
Well, I don't have any recollection of that, but they are the senior officers involved and they cleared the second response to the Ombudsman, so they probably were involved in the first response to the Ombudsman.
Well, did you make the decision?
Not that I recall. No, and I mean, I don't recall.
You don't recall whether you decided or not ultimately on whether the Ombudsman received the 2014 advice?
So I think the
response
emails
to the
that
first request.
I think the emails that I've been able to that I've seen are that Mr Hurman and I agreed that both pieces of advice should be included in the first response.
And you didn't change your mind?
I have no recollection of that, and there's no emails that I've seen to that effect.
So the options are therefore someone above you who has overridden your decision or someone below you who has not followed your decision?
Yeah, I mean, that seems reasonable, yep.
Right. Can you comprehend a circumstance in which someone below you would not follow a decision of SES level 1?
I can comprehend a decision, but I mean, it doesn't seem like it would have happened here. There's emails from Mr Hurman agreeing to release both pieces of advice.
The likely explanation, isn't it, is that either Ms Halbert made the decision or Ms Wilson made the decision.
Yeah, I guess, I mean, I don't want to be obstructive about this. Like, I don't have a recollection, but yeah, I mean, I can see why that would be a reasonable thing to think. And certainly they were involved in the clearing of the second piece of advice to the Ombudsman. So it would seem reasonable that they were involved in the first response as well.
Surely you appreciated having arrived at the position that the 2014 advice was within scope and therefore responsive to the Ombudsman's request, that providing only the 2017 advice had the capacity to mislead the Ombudsman about the historical position?
I think the position we reached, was that it was better, more complete for the Ombudsman to have received both pieces of advice. Yes.
And to do so incompletely created the potential for a misleading representation to the Ombudsman.
Okay. Yes.
Surely that concerned you.
I'm sure at the time I was aware of why the 2014 advice was not included, and but I don't recall that now.
You don't recall whether you were concerned or not?
I don't recall why it was not included or how I came to know about it, or
even whether you were troubled?
No, I don't recall that.
You could turn to tab 61, DSS.5051.0001.0119. Exhibit 1385. You'll see that an email has been forwarded to you by Ms Newman and to Mr Hurman on the 27th of February, which at the bottom of it attaches the second request for legal advice.
Yes.
And surely you read that and realised that in fact when the Ombudsman asked you for the first legal advice, it was asking very broadly because of the information already in its possession and in its possession since 20 January.
Yeah, which was the view that we had to the first response, yes.
And you realised that in fact, because the Ombudsman knew about the earlier advice, according to the document that it had been provided, it needed to provide a second advice because the 2014 advice and documents related with advice about legislative change had in fact not been forthcoming from DSS.
Yes.
Right. Surely you realised at that point that the Ombudsman's need for a second request was because of the creation of a misleading position in the first response. The department had been caught out, hadn't it?
Yeah, I don't know how to answer that question.
The Ombudsman had to disclose its hand about its information.
Yeah, further information was provided by the Ombudsman asking a follow-up question, yeah.
Asking the same question in very direct terms, displaying why it knew that there was earlier advice.
Yes?
Yes. Now, you know from your involvement, if you turn to the second page of that, that what was requested was the advice from DSS about the legislative change that would be needed and any other notes, documents or emails that relate to this advice. That is, the advice that legislative change would be needed. Understood that?
Yes.
It was a very specific request in respect of a particular piece of advice, correct?
Yes.
But it was broad in the sense that it asked for everything relating to the advice.
Yes.
Not just the advice.
Yes.
Right. You know from your involvement that in fact only the portion of the document of the 2014 advice, which did not include the factual premise on which the advice was given, was provided.
Sorry?
You know from your involvement that what was provided to the Ombudsman in response to this request was a combined document which extracted the 2014 advice out of its context and the 2017 advice out of its context.
Yeah, they were put into a different document, yes, into a Word document.
My question is they're taken out of context because only the advice part of the 2014 document was given to the Ombudsman,
Okay.
not the factual premise on which the advice was sought, correct?
Yes.
And so that tends to distort the extent of the application of the opinion, doesn't it?
Because the question wasn't included.
Yes.
Including the question would probably make it more complete, yeah.
Well, it would indicate the factual basis on which the advice was given and the extent to which the advice applied to factual circumstances, wouldn't it?
Yes.
And to only give the answer and not the question would mean that there would be an incomplete understanding of the application of the advice.
Okay. Yes.
You accept that as a matter of logic.
Yes.
It's not a matter of law, is it?
Yeah, I guess I'm just wary that there's a implication being made that that's why it was done, and I don't recall that.
I'll come to the implication shortly, but let's deal with the factual premise which precedes it.
Yes.
You accept the factual premise.
Yes.
And so this is the second occasion on which DSS has provided a response to the Ombudsman which doesn't give the full picture.
Okay, yes.
All right, you can see a pattern emerging here, can't you? If you can't, say so.
Well, yes, we provided the first advice. The Ombudsman had to come back for a second, ask the question a second time, and then I agree that including the question in the 2014 advice would make it more complete.
Yes. And the Ombudsman didn't just ask for the advice, it asked for all notes, documents or emails that relate to the advice.
Yes.
Yes, none were provided, were they?
No.
No. A third occasion where there's been less than a full response.
Well, none were provided. I don't know whether there were some that should have been provided but that weren't,
Well,
other than the question that you've talked about.
you can see that there was an attachment to this email, a minister brief.
From the Ombudsman?
The attachment from Colette Newman. Russell asked me to forward this on to you. You can see that it's really addressed to Mr. Hurman, but you've asked it to be forwarded
Yes.
to him.
An attachment?
Yes. You can turn over to the next page, tab 62.
Yes.
And you can see that it is Exhibit 3646, an executive minute from the Department of Human Services to the Minister for Social Services for action. You can see it.
Yes.
You recall the document?
Not from the time, but I do since it's been raised in the Royal Commission context.
And you asked for it to be sent to Mr. Hurman
Yes.
in the context of this question from the Ombudsman.
Yes.
Because what the Ombudsman is referring to is the executive minute
Yes.
and the advice which is reflected within it.
Yes.
And if you go to the page that ends 0130, page 10 of 17 at the bottom, you'll see that the last dot point identifies where the Ombudsman gets that idea from.
Yes.
And you appreciated that at the time, which is why you asked that it be forwarded to Mr. Hurman.
Well, I would have asked for it to be forwarded to him because he was going to prepare the response.
And so having read that, you can see clearly there that DSS has also advised that legislative change would also be needed to implement the initiative. You see that?
Yes.
Now, this is a document which is prepared up to the 12th of February 2015 and signed by the Minister on the 20th of February 2015.
Yes.
Plainly, there would have been documents which existed in respect of that representation and development of the executive minute by DHS to the DSS Minister.
I would think so.
And yet none were located or sought.
None were provided to the Ombudsman. Sorry, I don't know whether any were sought or located. I don't have any information to that effect.
Right.
But certainly none were provided to the Ombudsman.
So if you accept, of course, that they are likely to exist, given the fact that this is the development of an executive minute of this nature by DHS to the DSS Minister, and the clear representation, no doubt in considered language within it, can you point to a reason why that was not done? Is why these notes were not provided.
No, I cannot.
Do you now accept that there is an emerging pattern in the DSS response?
The response to the Ombudsman, yes. I mean, given this, it seems narrow, yes. And so, is that a pattern? I don't know, but yes, it certainly seems a narrow response.
It's an incomplete response.
Well, this is what the events that are being talked about here in 2014, 15 predate my time in this role, and so I wouldn't have known about any documents, but it would seem that there were some.
Yes. You're very familiar with the processes of departments in developing ministerial briefs, and that's the basis on which you say it would seem that there must have been some other documents.
Yes?
Yes. My question is then, given you were here and involved at the time, whether you can explain that this is just a coincidence or a clear pattern of behaviour by DSS in response to the Ombudsman.
I don't have a recollection that there was a deliberate attempt to do that.
Right, can I take you to tab 70? Exhibit 1390 and DSS.5026.0001.004. You can see that on the 28th of February, you're copied into an email from Ms. Halbert, where she indicates we did provide written advice in commenting on their brief.
Yes?
See that?
Yes?
So you knew at the 28th of February that there were documents in existence which commented on the brief.
Yes?
It bespeaks a deliberate position, doesn't it, not to provide those when there is a very specific request made for a second time in response to an incomplete and potentially misleading first response by the department.
Well, I mean, I don't recall that.
There is no
I don't
reason...
know what to...
Sorry, I'll let you finish.
No, I don't, other than I don't recall it, I'm sorry, I don't know how else to answer the question.
There is no reason not to provide the documents that Ms. Halbert specifically refers to there to the Ombudsman, is there? No logical reason.
No. I mean, there are practical reasons you could think of, but no, if they were there, why, it would seem reasonable they should have at least been looked at and thought about whether they should have been sent to the Ombudsman. And I don't have any notes to that effect.
No, it's clear that it wasn't done indeed, correct?
Well, I can't find anything that says that it was, yeah, and then it was not. There was nothing here that suggests that a search occurred.
And can you explain why not?
No, I can't explain why not.
Even though there had been a very specific request for them and you knew they existed, you can't explain why not?
No.
You see, Mr de Burgh, it's not just that they weren't provided as what I've described as the third occasion in the sequence, it's the fact that they were known to exist 2 days before the response was due and no action was taken to search for them. That suggests a deliberate choice, doesn't it, by those considering the response to the Ombudsman?
Okay, I accept, yes.
Right? And as you knew at this point in time, the 2017 advice had already been provided to the Ombudsman, but was not re-requested by the Ombudsman in its second request, was it?
Okay.
Right.
Yep.
We can go back to the document if you want to check.
I mean, okay.
But the Ombudsman was abundantly clear
Yep.
about what it wanted.
Yep.
It wanted the advice that said legislative change was required for the proposal which became OCI.
Yes.
And it required all documents related to it to be produced.
Yes.
But you know that in fact, DSS again provided the 2017 advice.
In the second response and
Yes.
the 2014 and 2017 advice. Yes. And a explanation about the change that had occurred between those two pieces of advice.
Yes. Given that the Ombudsman didn't ask for the 2017 advice again, why was there a deliberate choice by DSS to provide it again and provide it in a context which made it, which increased its justification or legal validity?
Well, the second response to the Ombudsman, in the context of that response, it explains why the 2017 advice, how it came about because of updated knowledge and changes since the 2014.
Yes, that's not my question. My question is why, given that the Ombudsman didn't ask for it again and didn't ask for an explanation about the circumstances, did the department see fit to provide it again and give an explanation justifying its validity?
Well, I think it is in the context of the response.
Mr de Burgh, you'll recall that you gave answers where you were talking about your consideration between 21 and 22 February about the extent of the request and whether you were truly responding to it, the first request for legal advice. And your initial view was that the 2014 advice was not truly what the Ombudsman was after and it wasn't the most relevant and wasn't the most appropriate. And you were being very careful to respond to the terms of the Ombudsman's request as you understood them. Has all that gone out of the window in respect of the second request?
Well, in the respect of the first response, the final decision, or the final decision that I have, is that they both should have been provided.
Yes, but the reason why you initially considered it not to be relevant was because you read down the terms of the request of the Ombudsman. You adopted a very narrow approach to it by confining it to remarks made prior to the terms of the specific request. Now, you were persuaded otherwise, but that was your view about how to respond in the most appropriate and relevant way, correct?
Yes.
You now receive a second request which is abundantly clear in what it seeks. And what you are saying is that DSS adopted a different approach to that, you particularly, where you broadened the scope to make sure that the 2014 advice was seen in the proper context of the 2017 advice, and there was a detailed explanation about the 2017 advice.
I'm not sure. I mean, I agree that partway through my thinking of the first response, I had thought only the 2017 advice was relevant. But by the end of that process, I had been persuaded otherwise. So having a broad application for the second response, I think, is consistent with the final decision on the first response. Both of them had broad interpretations.
Well, you've agreed with me that the 2017, the second advice, was very specific in its scope in respect of what it was after.
Yes.
Yes. But the department adopted an approach to say, well, we're going to give you much more than that. And not all of what you've asked for.
Yes, I mean, I would think that that would be because it would put the department's understanding into context.
Surely the notes that surrounded the advice, the written response to the executive minute would do that far better and be far more responsive and far more relevant.
Well, I mean, I haven't seen them, but I can see the point that you're making. Yes, I agree.
You agree. And so we have another 2 or 3 occasions where there is either an inconsistent approach, an incomplete approach, or an explanation which seeks to justify the 2017 advice beyond what is being requested. Do you now accept that there is a pattern from DSS in the nature of its response to the Ombudsman's requests, which 1, seeks to uphold the legal validity of the OCI scheme, and 2, seeks to uphold its accuracy?
That was the latest advice that the department had. It would seem appropriate to, and therefore informed the department's view, it would seem appropriate to provide that information. I'm not suggesting that.
You weren't being asked for it this time.
Yeah, I'm not suggesting that that should be at the exclusion of providing other advice, but I'm not sure that it's right that we shouldn't have provided the 2017 advice or sought to put earlier advice into context.
How do you come to that view, given the specific nature of the request from the Ombudsman? They weren't asking for context, were they? Of the 2017 advice, at least. They already had it.
Yeah, I mean, I think, so I have seen an email from Ms Pulford which seeks to explain the difference between the 2014 and 2017 legal advice. And because while on the face of it, they appear contradictory, Ms Pulford has provided an explanation about why they are not. And we provided both pieces of advice to the Ombudsman, so they're able to form their own view, but it would also seem relevant to provide the department's view.
Well, they weren't able to form their own view, truly, were they, because of the points you have already accepted. One is that you provided the answer, not the question, in respect of the 2014 advice. And the second is you didn't provide all of the documents that related to the advice referred to in the executive minute about the need for legislative change. I suggest your answer is not true.
Which part of the answer?
The answer which said that we provided both pieces of advice to the Ombudsman so they're able to form their own view, because you were still doing an incomplete response.
Well, I think providing the advice does allow the Ombudsman to make their own view. So I don't agree that it's not true, but I agree that if we had provided even more advice to more documents to the Ombudsman, they may have been able to do that even more.
How did they come to the view, that is the Ombudsman, about the true extent of the 2014 advice without the facts?
Well, they have the advice and they have the additional information that was provided in the response.
That is, they have Ms Pulford's explanation about how she provided the 2 apparently inconsistent pieces of advice.
and an explanation in the response to the Ombudsman that explains over time the changes that DHS made to the program and changing understanding that DSS had about what DHS were doing.
The point of the way in which the response was provided to the Ombudsman was to preclude the Ombudsman independently testing the reliability of those assertions which were made after the 2017 advice was provided. It just couldn't independently test them, could it?
I'm not sure. I mean, I agree that if more information would have been provided, then that may have been able to be done more by the Ombudsman, but I'm not sure that they weren't able to do it on the information that we had provided.
You were asking the Ombudsman to take your word for it about why the advices were consistent.
Well, they had the advice. They could have formed their own view had they, and maybe they did.
Well, they didn't have the advice that related to the executive minute, did they?
Apart from the 2014 legal advice, we didn't provide any of the other documents relating to the minute, no.
And the minute was clear about what the advice was.
Yes.
Yes. And as Ms Pulford explained to you, the 2014 advice didn't say legislative change was required.
Yes.
Whereas the executive minute did.
Yes.
And so there is a gap in the advice process, obviously.
Yes, it would appear so, yes.
And Ms Halbert confirmed it in the document that's on the screen.
Yep.
And so, again, I suggest to you that the response, carefully drafted by DSS, required the Ombudsman to take its word that everything was okay in terms of the scheme's lawfulness.
Okay, by not providing any other advice, yes.
Right. Well, why did DSS adopt that approach instead of being full and frank with the Ombudsman in respect of its direct requests?
Yeah, I don't recall why it was responded to in this way, and I can't find any emails to suggest why it was done like that. There's nothing to suggest that documents were found but that weren't provided to the Ombudsman.
Well, there is. The 2014 advice wasn't provided on the first round and it was found.
Yes, and
Yes.
yes, sorry, in relation to the minute and documents that surrounded the minute.
Yes, but nor is there any evidence that anyone looked for it.
That anyone looked, correct, I agree.
Even though everyone knew they existed.
Yes.
Right. I suggest to you very clearly, Mr de Burgh, that as an SES Level 1 person, you understood the department's position was at all times to provide responses to the Ombudsman which supported the lawfulness of the scheme and the accuracy of its calculation of debts.
We had advice to that effect, and that's what was provided to the Ombudsman.
You also had advice to the contrary effect.
Well, I don't think that's the case. I think Ms Pulford's advice shows that the difference between the two pieces of advice.
You understood, though, that what Ms Pulford said on the first occasion was that averaged income was a notional figure, really, that would be assumed to be actual income for the purpose of calculating an entitlement.
Yes.
Right. How is it fair to someone to have a debt alleged against them on the basis of income that is notional rather than what they actually earned?
Well, I guess you introducing a concept of fairness, we're talking about legal advice, and the legal advice in 2017 suggests that under the right circumstances, it is legal.
Will you answer my question, please?
Is it fair that it occur like that?
How is it fair to someone to have a debt alleged against them on the basis of income that is notional rather than what they actually earned?
So you're asking, you're wanting like an opinion now of whether I think it's fair? Is that the question?
That's the question.
Well, I mean, yeah, based on my understanding of what happened, in many cases, it appears that it was not calculated correctly and debts were raised, and that's not fair.
Yeah. And that's the effect of Ms. Pulford's advice, that averaging income creates a notional figure which doesn't reflect true income.
Well, I think the advice is the
2014 advice.
That's what can happen, yes.
Yes. Not only would it be unfair, but it would be contrary to the law.
Yeah, I think the 2014 advice suggests that under the way it's currently being done, or the way that DSS thought it was being done, that it would be contrary.
Yes, the use of averaged income in the calculation of entitlement and therefore debt.
The way that it was being done, yeah. I mean, my understanding is that it was because it wasn't being done or the thinking was that it wasn't being done as the last resort.
So are you saying that it is fair to do it as a last resort, but unfair to do it as a first resort?
Well, it's certainly, as I understand it, legal to do it as a last resort. Is it fair? Well, I think it becomes unfair when the debt is incorrectly calculated.
And it would be incorrectly calculated if it wasn't based on actual income.
Potentially, yes. Not necessarily, but yes, potentially.
Well, in what circumstances wouldn't it be?
Well, couldn't there be a circumstance where the notional allocation created the same result as if the actual income had been known?
That's the position on which you say potentially?
Yes.
All right. Did you turn your mind to how often that might occur?
No. I mean, I've agreed to, well, I've made a comment about fairness. I'm not seeking to, try and say that it would always be calculated correctly. I'm not trying to do that.
All right. And that's my next point. The concept of notional or averaged income, or notional income as a result of averaging of PAYG data, doesn't permit an accurate calculation because the hypothetical situation you described would be so rare.
So, yeah, I mean, in my position, I have no actual involvement in this process. So I'm not speaking to you from somebody who was there at the time and knows what's happening. But from my understanding of it, it would appear that, averaging the income would come up, with a different debt amount. But yeah, I mean, that's not a professional view from having any involvement in this.
Well, you did have involvement in it, and in the final letter that was signed by Mr. Pratt on behalf of the department, there was a specific reference to the note that the final draft of the Ombudsman's report accepted that the scheme accurately calculated debts on the information before the decision maker.
Sorry, can you repeat that?
Take you to the document. in the third volume to your right, behind tab 162, Exhibit 3767, DSS.50003.001.0715. You can see that there.
Yes?
You see the third paragraph, the department is satisfied the system is operating within legislative requirements. You see that?
Yes?
Now, that of course could not be based on the first advice, but had to be based on the second. That assertion,
Yeah, it's certainly consistent with the 2017 advice, yes.
and inconsistent with the 2014 advice.
Well, as I say, my understanding is that the two pieces of advice were not related to the same situation. So I'm not sure that it is inconsistent with the 2014 advice.
Right. I'll put this to you, but if you want to go to the documents, we can. The factual premise of the 2014 advice allowed the opportunity for a person to respond to the discrepancy and explain it. The executive minute referred to the opportunity for a person to respond to an asserted discrepancy and explain it. And in both cases where they did not, the ATO data would be apportioned and treated as actual income. You accept that or not?
Okay, yes?
You can see the importance of the factual foundation of the opinion.
Well, maybe it would be helpful to turn to the paragraph that Ms. Bulford drafted that explained the difference between the two pieces of advice. But I agree that this third paragraph is presumably referring to the 2017 advice.
Yes. And I'm suggesting to you that there is in fact no relevance whatsoever to the suggestion of the last resort qualification, because at every time there was a reference to DSS advice which did not support averaged income, it was given in the context whereby a recipient had an opportunity to explain the discrepancy, and if they did not, the averaged income would be applied. You understand what I'm putting to you?
I understand what you're putting to me, but I suspect you're going beyond my level of knowledge of the specifics then of the advice.
Well, it's plain on the face of the documents.
Well,
Plain on the face of the executive minute, and it's plain on the factual circumstances in which asked the question in 2014.
so when Ms. Bulford explains the difference between the two pieces of advice...
Not coming to that, you are confusing a sequence of propositions. I'm suggesting to you that the 2014 advice was given in the context where a recipient had an opportunity to explain a discrepancy, and where they did not, average data would be applied in the calculation of a debt. Do you accept that as a proposition?
Well, I mean, if that was the question that was asked, then I accept it. Sorry, I don't have that.
Well, it's now 5:45.
Yep.
You've
So
had
I'm
the
accepting...
opportunity to prepare for some months. I can take you to it if you like, but I hear no objection about what I'm putting to you.
Yep, so I'm accepting it.
Right? And of course, the executive minute that you asked to be forwarded to Mr. Hurman contained the same opportunity, correct? And so, in the context where a distinction is sought to be drawn between the 2014 and the 2017 advices, though there was some saving provision because it was a last resort, that averaging could be used as a last resort where someone didn't respond, I'm suggesting to you that is logically artificial. And you must have known it at the time.
I think at the time we thought the two... I suspect that we did think that the two pieces of advice were contradictory and yet referring to the same issue, which is why we asked our legal area for an explanation, and we were provided with an explanation.
Yes. And I suggest to you that you appreciated the explanation was artificial in the factual context in which the advice was given in the executive minute and the advice was given in 2014. It just didn't make sense.
I don't recall thinking that at the time. We asked a question of our legal area, we were provided with a response.
And so we move to the second line of paragraph 3. There have been no changes to the way in which DHS assesses pay-as-you-go employment income. You can see that.
Oh, yes.
That representation was untrue because the executive minute made clear that there was a very significant change to the way in which PAYG information was used in the calculation of debts.
Where does that come from?
The document that you asked to be forwarded to Mr. Hurman, the executive minute, you recall I took you to the last dot point,
Yes,
which said that DHS have advised legislative changes required to implement the measure.
yes,
You recall what was set out as the measure which became OCI,
yes.
and in respect of which the Ombudsman asked the question. And in those dot points, it referred to the change in the way in which PAYG information was treated in the calculation of income and therefore debts.
I don't know. I mean, I'd have to go back and look. I mean, if you're suggesting that this is not true,
I am.
then I'd need to go back to that minute. I'm sorry, I just can't.
That's all right. Well, will you accept this at least while we're looking for it? That even Ms Pulford's explanation referred to the idea that DSS had become comfortable with the changes that were in place.
DSS had become, that DHS had made some changes and DSS had also increased its knowledge of what was happening.
Yes. And the reference to changes that had been made by DHS surely suggested some different treatment of PAYG data.
I don't know that.
Well, on what basis was this representation made to the Ombudsman?
I don't know.
Was it made without any evidentiary foundation to your knowledge?
No, I don't know.
If you can go to tab 60 in volume 1.
Sorry?
Tab 60, volume 1, exhibit 3645, cdh.3008.0016.7790, and again go to page 10 of 17. And if you go down to the 4th dot point and read it to yourself.
The proposal uses information, that paragraph?
Yes, thank you.
Yes?
And then go to the last dot point and the first sentence.
Yes?
There was a clear indication of a change in the way DHS used PAYG data in the calculation of debts.
The last dot point, there may be a need to change of policy to enable the use of ATO data in this way.
Yes. The 4th dot point set out the changes in the way ATO data was used, and the last dot point identified the possibility of policy change to enable the use of the data in that way, and also that legislative change would be needed to use the data that way.
Yes.
Yes. And yet, DSS, through Mr Pratt, represents to the Ombudsman that there has been no change to the way in which DHS assesses pay-as-you-go employment income.
But the minute suggests that it may be required. It doesn't say that it did happen.
You're confusing the question of whether there is a need for policy change with the change in the way that the information is used. The fourth dot point sets out the way in which the change would be applied to the use of the information.
It's saying we're not going to depend on customer and business information anymore. We'll use the ATO data as our primary evidence rather than just a trigger, as it has been in the past. Looks like a change, doesn't it?
Yeah, but isn't the sentence asking about, in the letter from Mr Pratt, no changes in the way in which DHS assesses PAYG employment income?
Yes, Mr de Burgh.
So it's about how it's being assessed, whereas this dot point is asking about accessing where the information comes from that is then assessed.
No, it's saying now we rely on it as our primary source of information,
Yes.
where we didn't in the past.
Yes.
So we are going to treat it differently.
Does it say the latter bit of that?
Yeah, it says in the past it was relied on as a trigger. Now, in other words, there may be something to see here. Now we are going to rely on it as our primary evidence.
Yes. But I guess I'm just not sure how that is contrary to this sentence here, which seems to be talking about not where does the income information come from, but how it is assessed.
This isn't just about where it comes from, it's about how it's treated. It's about treating it as primary evidence of employment income.
The ATO data?
Yes.
Yes.
Okay.
Yes.
So you're now assessing it as primary evidence of income. In the past, it was just used as a trigger to perhaps identify a discrepancy somewhere. That's what that paragraph is saying. It's a pretty fundamental change when you stop relying on customer and employer information and you now use this data not just as an indicator for inquiry, but as the primary source of evidence.
Yes, I agree that that is what the minute is saying the proposal is about. And maybe it's my interpretation in the Mr Pratt letter and interpretation of what assessors means in this context. And I think that's the difference, where we have different understanding of what it means.
Well, what do you think assessors means?
I think it means how the calculations are performed. We have this information, this raw data, it then needs to be interpreted, calculations need to be made. That was, when I read this sentence, that is what I thought it was talking about.
Okay, well, the calculation's done on averaging now as standard practice where you haven't got other information. And you haven't got other information because you haven't asked anymore. Isn't that a bit of a change? Once you ask the employers, now you don't.
I agree that that is a change, yes. And sorry, when I read the sentence and it talked about assessing, I thought it was what happens after DHS has got the income information. But I agree that this suggests that there is a change to how it gets that information.
DHS gets the information from the ATO, doesn't it?
Under this proposal, yes.
Yes. Did it get it from somewhere else in the terms of the third paragraph of Mr Pratt's letter?
Did it get it from somewhere else? No, I think I agree that this proposal is suggesting a change. rather than in how the ATO income data is used. I'm not meaning to suggest otherwise. I'm saying that when I read this letter, it's talking about the way in which DHS assesses pay-as-you-go employment income.
They're not going to assess it like the tax office, are they? It's not that kind of assessment. It can only be a synonym for how it uses it, really, can't it?
How it uses it,
Context?
that's
Yeah.
right.
And it changed how it used it.
Oh. Well, it changed how it, yeah, that it now used it as the primary source, yes.
So the representation in the letter is not true.
Well, yeah, I think this is a bit, I don't agree to that because of how I read the paragraph.
The paragraph asserts three things. The scheme was lawful, nothing had changed, and it raised debts accurately. Read it to yourself.
Well, there have been no changes in the way DHS assesses pay-as-you-go employment income. That's right.
Yes, and the next sentence.
Yes?
It is a representation on behalf of DSS that the scheme is lawful, nothing has changed in terms of debts raised under the scheme, and the debts raised are accurate. That is the proper context of this letter in response to the Ombudsman's draft report.
Well, I think your characterisation of the second of those 3 points, I think, is broader than what this letter goes to.
But there is no other way to assess PAYG income data in this context except in reference to calculation of debts,
Yes?
right? So how are we different?
Because this is, sorry, I thought you suggested that DHS had not made any changes to its practices in the second of your 3 points. And I think it doesn't, that goes further than what this says. This says that DHS hasn't made any changes to how it assesses PAYG employment income.
What is not expressly stated at the end of that sentence but is clearly conveyed are the words in respect of the calculation of debts.
Okay.
You understand that's what is intended by that passage?
Yes, it's clearly talking about the operation, including the calculation of debts. Yes.
The way in which DHS assesses PAYG employment income in the calculation of debts.
Yes, how it assesses it. Yes, which I think goes to the conversation we had just earlier about what that means. But yes.
How it uses the information to calculate entitlement.
Well, how it calculates the entitlement, yes.
And therefore the debt.
Yes.
All right. And I'm suggesting to you there plainly was a way in which there was a change in the way in which DHS used PAYG employment income to assess entitlement and calculate debts. In fact, that was the case. There had been that change.
In the initial information that was used, yes.
And this sentence represents, in fact, there had been no change.
As I say, I mean, I hadn't had this, I don't recall ever having seen this letter before. It hasn't been provided to me before today. And my interpretation of this sentence is that it's talking about the methodology of once we have the information, how do we calculate it?
Calculate debts.
Yes. How do we calculate debts?
Yes.
Yes.
We're all agreed that that's what the sentence refers to, the use of PAYG data in the calculation of debts. What I'm suggesting to you is the sentence represents there's been no change to the way in which DHS does that, when that is not true, there had been a change. Because averaged income was used to calculate entitlement. Do you agree or disagree?
I think I don't know.
Does it follow?
This dot point, the fourth dot point.
You can read the first dot point as well if you like.
I'm sorry, I just don't know enough about how DHS, in terms of averaging, which if that's what we're talking about, I'm sorry, I just don't know enough about how DHS used to calculate debts to know that that's the change here. The change we were talking about before is about the source of the information.
Commissioner, I note it's now 6 p.m. Might I inquire through you whether intend to sit until the witness has concluded his evidence?
That's pretty much my plan, assuming I can stay upright that long, but...
The whole point of the Ombudsman's investigation was to determine whether, well, a number of points raised in the Ombudsman's investigation was to determine whether the scheme was lawful, at least in the terms that was initially created, correct? To ascertain whether OCI alleged debts which were in fact accurate and reflected the actual earnings of people, correct?
I think, I'm not sure that these are the actual questions posed by the Ombudsman, but that would seem a reasonable thing to think that they were doing. I agree.
Right. Let me get to the next point then. This was a positive assertion by DSS in respect of two features. The first, legality, and the second is that there had been no change in the way DHS assessed PAYG data to calculate debts.
Okay, yes.
Do you accept both of those?
Yes.
Okay. Those 2 points were advanced in defence of the OCI scheme. You see that? You can accept that? It was a DHS position.
DSS?
Sorry, thank you, Commissioner. The DSS position was that the scheme was lawful and that nothing had changed. That's what's conveyed by the introductory sentence.
Well, yes, specifically in regards to what's happening here, but yes.
Yes, and what's happening here is the central point about why there's an inquiry into the OCI scheme. Because there were concerns about its legality and concerns about its fairness and concerns about its accuracy. You understood that to be the case through this process of months of being updated and having involvement in the response to the Ombudsman.
Yes, that's what the Ombudsman's asking about?
Yes.
Yes.
And I'm suggesting that if one looks at the facts which underpinned the 2014 advice, the absence of any factual circumstances save for the proposition of a last resort in the 2017 advice, and the facts contained on the screen before you in the executive minute, which includes a reference to DSS advice about the need for legislative change, you in fact appreciated that the advices remained inconsistent and there was a real question about legality.
I don't accept that.
And that it was obvious on the face of those documents that the concept of a last resort was completely artificial to the question of legality.
I don't accept that. The legal advice that I had says otherwise.
I think you're referring now to the 2017 advice.
Yes.
Right. And I'm suggesting to you that you understood that the attribution of notional income as a result of averaging did not, generally speaking, subject to your hypothetical qualification, lead to an accurate calculation of real debt.
Well,
Which has got nothing to do with last resort or not. We're just talking about the accuracy question.
yes.
And so the third representation, which is made in a backhanded way from this letter, was that in the context of an assertion about legality and an assertion about nothing had changed, that DSS noted that the Ombudsman had found that the scheme accurately calculates debts on the information that was presented to the decision maker.
That's right.
Yes, when you knew, in fact, that could not be right because averaged income does not have that effect.
Well, no, but I think, aren't we comparing two different things? So based on the advice available to the decision maker, this is saying that the debt has been calculated accurately based on that advice. That is
Based on
important
the information,
and true, based on the information that is available to the decision maker.
which is averaged income.
Yes, possibly, yes, in this case, that's right. So based on the information that the decision maker has, the processes that are in place, primarily in DHS, operate to correctly calculate the debt based on that information.
And I'm
Now,
saying
whether that turns out to be the same amount of debt as would be calculated if the actual income was available, I agree that most of the time, it wouldn't. But this is saying, based on the information available to the decision maker, that the calculation is occurring correctly.
But it's not, it doesn't say calculation, actually. It says raising debts, which suggests that the bringing into existence of the debt is appropriate and accurate. And that's not true.
Well, based on the information available to the decision maker.
But if the information available to the decision maker is worthless, it won't be accurately raising debts, will it?
What? Yeah, I think that goes back to would it.
You see,
Possibly not, but that's not what's being talked about here. This is talking about based on the advice available to the decision maker.
But it's not saying it adds it up correctly on the information we have. It goes the further step and says it raises accurate debts. And that's just not true. It didn't.
Well, system is accurately identifying and raising debts based on the information available.
Mm-hmm. It wasn't accurately raising debts on the information available to the decision maker or on any basis. It just wasn't accurately raising debts. So adding the bit about based on the information available to the decision maker doesn't mean that the debts on any view were accurately raised. If it had just said, and the maths adds up on what the decision maker has, then maybe if it had just talked about calculation. But it goes that further step of asserting that the debts raised were accurate. And that just can't be right. All right, I think we'll have to agree to disagree from the look of you, Mr. de Burgh.
Yeah, I don't know how to answer the question. I mean, I think, yeah, sorry.
Mr. de Burgh, it was clear that DSS, from the start of the Ombudsman's investigation, adopted a defensive approach which asserted legality, fairness and accuracy of raising debts by the OCI scheme.
Well, based on my involvement in this, which is using the 2017 legal advice, yes.
And that's why the 2017 legal advice was obtained, because the DSS wanted to adopt that position and it couldn't otherwise do it.
Yeah, I guess it's the wanting bit. Yeah, the 2017 legal advice, yeah, seems reasonably clear in that.
DSS couldn't defend the scheme's lawfulness without the 2017 advice.
Perhaps not. I
Can you
don't
point to anything which says the scheme was remotely lawful apart from the 2017 advice?
No, but I didn't have a particular big role in this, and so, yeah, but no, I don't have anything.
Can you point to anything DSS provided the Ombudsman, apart from the 2017 advice and the explanation from Ms Pulford about why they were inconsistent, which supports the legality of the scheme?
I think you said why they were inconsistent.
Sorry?
Why they were consistent.
consistent?
Yes, sorry.
Well, based on this response to the Ombudsman, which was my involvement, no, like that's what was provided to the Ombudsman.
It is, you can't point to any legal advice which refers to the entitlement calculators or the debt provisions or any external advice or any earlier memos which might point that way.
No.
So DSS hung its hat on the 2017 advice which was obtained after the Ombudsman commenced its investigation.
Well, yeah, having not been involved in this scheme in that time, this is the sort of the only thing that involvement I had, I'm not aware of anything else.
Well, you were involved in the response, so you can answer my question.
Yep.
DSS hung its hat on the 2017 advice which was obtained after the Ombudsman commenced its investigation.
Yes?
And the inference to be drawn from that is that it needed to justify the legality of the scheme in response to the Ombudsman's investigation, because it could not otherwise.
Yeah, I mean, part of this is a premise that the 2017 legal advice that was asked for because of the Ombudsman's question, and I'm not sure that that's true. I didn't ask for that advice. But yeah, having the 2017 advice, I'm not aware of anything else, and it forms a substantial basis of the response to the Ombudsman.
And I suggest to you it was commonly understood between yourself, Kath Halbert, Robert Hurman and Serena Wilson that there was a need to justify the legality of the scheme to the Ombudsman.
Yes.
And that every step taken along the way in terms of responses to the Ombudsman's request were done with that purpose in mind.
Well, there are other reasons that we talked about at the beginning about, providing appropriate information and, the right amount of information, yes.
And I've challenged you on all of those propositions and pointed out what I suggested was a pattern of behaviour.
You have?
Yes. Do you accept the pattern and the purpose?
I don't accept that I knew that it wasn't lawful and therefore went and got some advice that made it lawful. I don't accept that. But I accept that, I agree that you've pointed out, and I agree, more information could have been provided to the Ombudsman to provide more context.
And that was repeatedly, an approach repeatedly adopted by DSS.
Well, in broader than the Ombudsman request?
To the Ombudsman.
To the Ombudsman, yes, that we could have provided more contextual information.
And providing more would have assisted the Ombudsman to conduct its investigation.
It may have, yes, probably would have. More information would have enabled the Ombudsman to do more work.
Just when I gave every indication that I was done. You gave an answer earlier which said you weren't involved in drafting the response, and it may be that you were. It's tab 84 in your document, Exhibit 2151A. You can see that?
Yes.
And you can see that you forwarded a response.
Sorry to interrupt, could I have that brought up because I don't have that document? DSS 5045 0001 0004_R.
Can I just check again your introduction to this bit of questioning?
Your involvement in the draft response to the Ombudsman.
The second response?
Yes.
Yes? But did you suggest that I'd said I wasn't?
I think that's right.
The subject of my statements show that I have said that, and I've produced documents to that effect.
I thought his evidence was in relation to not being involved in the drafting of the Mr Pratt's letter.
I think that's right, Hogendoren. Yeah, it's Mr Pratt's letter he said he wasn't involved in.
No, I think even there I said I don't recall it and it's only been provided to me today. I'm not making an assertion as to whether I drafted Mr Pratt's this letter or not. I don't recall being involved in it.
Right.
But certainly in relation to the Ombudsman's request, yes, I was involved in drafting it and have provided documents to that effect.
All right. It's the Ombudsman's second request.
Yes, and there are emails where I was involved in the first response as well. I just don't have I just didn't have the final response to the Ombudsman's first request.
Yes. All right. Thank you. I think it clarifies.
He's really finished, Ms Hogendoren. Have you any questions?
Almost didn't stand up properly then, Commissioner. I have no questions for
Do you want
Mr. de Burgh.
Mr de Burgh excused?
I do. Thank you, Commissioner.
You're excused, thank you, Mr de Burgh. And I think we're all excused until 10 o'clock on Friday. Thank you.
All rise. The Commission stands adjourned until 10 a.m. on Friday.